ಡೇಟ್ ಇದೆಯಂತ ನೋಡಪ್ಪ ಬಂದ್ಮೇಲೆ ಕೊಡಿಸ್ತೀನಿ. ಕ್ರಿಮಿನಲ್ ಯಾವ್ದು ಡೇಟ್ ಇದೆಯಂತ ನೋಡಪ್ಪ ಟಿಕ್ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ
Insurance company appeal my lord, seeking stay my lord. Matter may be for tomorrow or day after.
Fresh matter for it.
May I request your lordship, on special matter your lordship, specially assigned to your lordship, my lordship, seniority of PDOs. ಇದು ಒಂದು ಸರ್ವಿಸ್ ಮ್ಯಾಟ್ರು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ಸ್ ಆಗಿ ತಮ್ಮ ಮುಂದೆ ಬರ್ಬೇಕು.
ಏನಾಗ್ಬೇಕಿತ್ತು?
ಅದು ಪೋಸ್ಟಿಂಗ್ ಬೇಕಾಗಿತ್ತು.
ಕೊಡಿ ಮೆಮೋನ.
Immediate.
Yeah, given the memo. No.
This
Matter pertains to NIA, Your Lordship. The matter pertains to NIA. It's a medical bill.
Give the memos where no arguments on the memos. They're listing them.
it pertains to case.
If any compliance is there,
My permission, on RFM
said to them, I appeal to you also. Give them memo.
dismissed for non-prosecution agide. As on the date of
Good.
18/9, my lord, my name was not shown. I filed NOC vokala.
RFA-ನಾ?
RF.
RFA ಇಲ್ಲಿ ಬರಲ್ಲ ಸರ್.
My lordship has dismissed for non-prosecution.
ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್
ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಅಲ್ಲೇ ಕೊಡ್ಬೇಕದು. ಈಗ ರೋಸ್ಟರ್ ಯಾರಿಗಿರುತ್ತೋ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು. ಆಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡೋದು ಅವ್ರು ಮಾಡ್ತಾರೆ.
ಸಬ್ಮಿಷನ್ ಇದೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ 43. ಅದು 230 ಕೊಡಿ ಮೇಡಮ್. ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಎಲ್ಲರೇನು 230ಗೆ
43 ಶ್ರೀ ಕಾಲ್ ದಿಸ್ ಫಸ್ಟ್.
ಸರಿ ಆಯ್ತು.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ page wise. List 1, page 1, seal number 1 and 2.
ಬಂದ್ರೆ ಹೇಳೋಣ.
Page 2, seal number 3 to 5. Page 3, seal number 6 to 9. Page 4, seal number 10 to 14. Page 5, seal number 15 to 20. Page 6, seal number 21 to 26. Page 7, seal number 27 to 36. Page 8, seal number 37 to 42. Page 9, seal number 43 to 45. Page 10, seal number 46 and 47. Page 11, seal number 48 to 50. Page 12, seal number 51 to 53. Page 13, seal number 54 to 56. Page 14, seal number 57 to 59. Page, list number 2. Page 1, seal number 1. List number 1, frauders, seal number 1. SPP,
Memo for return, private speaking, Trimurti. 2 to 5. ಯಾರು ಬೇರೆ ರೊಕ್ಕೆಲ್ಲ ಹಾಕಿದಾರಲ್ಲ ಅಂಬೋಸಿರೋ ಅಷ್ಟೇ R2, 3 and 5 ಹಾಕಿದ್ದಾರೆ R4. So, no, he has filed memo of retirement for R2 to 5, but nobody is appearing for R4. Notice ಕೊಟ್ಟಿದ್ದಾರೆ. Of interest, instruction, non-cooperation. That we cannot, do it. Notice issue. Notice retirement.
pertains to case in general.
Fourಗೆ ಉಳಿದವ್ರಿಗೆ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ ಬಟ್ ರೆಸಿಪ್ಟ್ ಮಂಜುನಾಥ್ ಯಾರಿಗೆ ಅಂತ ಬಿಕಾಸ್ he filed it initially for all the rest 2 to 5.
ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಅಂತಿಲ್ಲ.
ಬರೀ R2ಗೆ R3ಗೆ R5 ನಿಮ್ ಜೊತೆ ಇದೆ ಅವ್ರು ಇನ್ನೊಬ್ರು ಯಾರೋ ಹೋಗ್ಬಿಟ್ಟು ರಿಸೀವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಬಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್ ಕಾಪಿನ ಹಾಕಿದ್ದಾರೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಏನಂತ ಬಂದಿದೆ ದಟ್ ಈಸ್ ದ ನೇಮ್ ಆಫ್ R4 ಶಿವಕುಮಾರ್ R4 ಶಿವಕುಮಾರ್ ಏನೋ ರಿಟರ್ನ್ ಬಂದಿದೆ insufficient but since Ambosirao Najre, Nara Council has appeared for response 2, 3 and 5 and proof of service of notice and respond number 4, proof of service of retirement notice. And respond number 4 is submitted. The KP Trimurti Lower Council is permitted to retire for response 2 to 5. Who is R1? Served anta idu.
ರಾಮಕೃಷ್ಣ.
R1.
R1 state,
No, my lord.
It is appeal itself is by.
Bill filed by the
Accused
state.
number 1 our service agide bandilvana. Respond number 1 accused those served as unrepresented. Respond number 4 is also absent. This is an appeal against order of acquittal. In the absence of respond number 1 and 4, the matter cannot be proceeded, it cannot be heard. Issue non-bailable warrant against respond number 1 and 4. This is from which place? 2015 and 2012 AC. Allu split up agitta.
Please, my lord, split up.
Against whom it was split up agide?
Accused number 3 and 4.
Split up Ramakrishna alias Kitty. Accused number 1 ಮೇಲೆ split up ಆಗಿತ್ತು.
Please,
That is respond number 1. Issue non-bailable warrant against respond number 1 and 5 ಅವನ್ನೆಲ್ಲ ಆಂಧ್ರ ಪ್ರದೇಶದಲ್ಲಿದ್ದಾನೆ. 1 and 5 ಅಲ್ಲ 1 and 4. 1 and 4. 4 is also Gram Panchayat office. 4 address ಯಾವುದು? ಗ್ರಾಮ ಪಂಚಾಯತ್ ಆಫೀಸ್ ಅಂತ ಅಷ್ಟೇ ಇದೆ. ಆದರ್ಶ್ ನಗರ್ ನೆಲಮಂಗಲ ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಫಾರ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಥ್ರೂ SP. ಅಲ್ಲ ಅವ್ರಿಗೆ ಆಂಧ್ರ ಪ್ರದೇಶದಲ್ಲಿ ಇರೋರಿಗೆ SP ತುಮಕೂರು ಕೊಡು ಥ್ರೂ SP ತುಮಕೂರು. ಓಕೆ ಇಫ್ respond 1 and 4 are arrested in execution of a warrant, they shall be produced before the trial court and trial court shall remand them to judicial custody till further orders of this court. List from
1311.
13.
Seal number 2.
Yes.
Biri Mary, Rajini HJ, party in person.
IA number 4 is filed and I am not been aware. No notice has been also sent.
It was passed. They are not, she has not complied. Where is this letter? Disposed matter. No, it will not. Letter ಎಲ್ಲಿದೆ ಅದು? I saw the objection. Letter for requesting to send the affidavit. ಎಲ್ಲಿದೆ ಅದು letter?
Assets and liabilities are not being
What
sent to
asset?
the lower court.
ಇದೆ letter ಇರಲ್ಲ ಇಟ್ಟಿದ್ದಾರೆ. ಅದು ಹೇಗೆ ರಿಟರ್ನ್ ಮಾಡಕ್ ಬರುತ್ತೆ? ಪಾರ್ಟ್ ಆಫ್ ದ ರೆಕಾರ್ಡ್. ಬೇಕಂದ್ರೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ತಗೋಬೇಕು. ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಪ್ರಿನ್ಸಿಪಲ್ ಜಡ್ಜ್ ಫ್ಯಾಮಿಲಿ ನಾನು ಪಾರ್ಟಿ ಹಾಕಿದೆ. Because that was filed in support of I. The peremptory order dated 27/9/2024 is not compliant. Therefore, I 4 of 2024 already stood dismissed. No further orders are required. Where is the letter addressed by the trial court? The affidavit of assets and liabilities submitted by the parties in support of I 1 of 2024 are required by the trial court for disposal of the said application. Therefore, registry shall transmit those records to the trial court as requested. By retaining copies of the same. Okay. Yes, it was not complied. Some stay was sought. That was a stay application. They are not complied office objection.
Yes, Your
That
Honor.
is also not come.
Yeah.
The matter is not going on there and that alimony application in the family.
It's
court,
going on, for which, that's why we need the assets and liabilities. And it is,
we have directed it to send other sent. Forthwith.
but Your Honor, IA number 4 is, I think it is observed because,
Now it is already dismissed because that they are not complied the office objections.
yeah, in spite completely disposing of will be good, Your Honor, because they're coming with new application, which we are also surprised. They can challenge in the Supreme Court rather challenging here.
We have already rejected that.
Oh.
Yes.
Cell number 3, Bhanuprakash Shetty, Jwala Kumar.
Yes.
For R2B. I'm appearing on behalf of Jwala Kumar. Copies serve ಮಾಡಬೇಕಾಯ್ತು.
Non-filing of wakalat for R2.
We will file wakalat also on 15 days.
Non-filing of acknowledgement has served copies on R2. Delay of 91 days. Who has moved it? Without complying the office objection, they have moved the matter. And I have counsel for the appellant though. No, avare move ಮಾಡಿದ್ರಿ. You have not moved, no?
I have not.
Has moved the matter is absent. ಏನು? ಇಲ್ಲಿ ಬರ್ತಾರ ಅವ್ರು regular
Bhanuprakash.
Finally, 2 weeks time is granted to do that. Granted to comply the office obstructions. It's after 2 weeks. But move back ಮಾಡ್ಬೇಕು ಅದನ್ನ.
Cell number 4, B Pradeep, HV Bhanuprakash.
For appellant.
I'm
Price with
the ad-
time allowed.
I'm the advocate
Next step
for,
for our-
I'm the
What is
advocate.
it for the application for release of the amount?
My lord, we are challenging the liability on the ground that police have charge sheeted under section 185 of MA Act, my lord.
185
MB Act,
relating to
consuming alcohol. He was consuming
Driver.
alcohol.
is that correct? Oh, is that correct? He is saying that the driver was charge sheeted For
Yes.
drunken driving.
My lordship, my contention is, yes, in the charge sheet, there is a contention that he was drunk. But how much alcohol was present is not available. Hence, without that being available, they cannot take that contention, because usually it is above 30 mg, then it,
ಅದೇ merits ಮೇಲೆ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅದನ್ನ.
the lordship, at least 50% may be released.
No, we'll consider it. Which was the vehicle involved?
The vehicle involved
Who
was
is responsible?
mini goods vehicle bearing
Many
registration of
goods vehicle.
K093325.
So driver of that mini goods vehicle had consumed alcohol.
Yes, ma'am.
Not this one. Liability is fastened to insurer.
Yes, ma'am.
What is the finding on that? Trial court's finding on this contention.
Paragraph 25, your lordship.
Para 25 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೀವು.
Internal page 13, paragraph 25.
So the allegation made in the charge sheet is not conclusive to hold that accused was drunk. And the percentage had exceeded 30 mg to 100 mg.
30 mg per 100 ml.
Any person was examined to say that he had consumed less than this.
No, your lordship. Nobody is examined.
If it is assumed that driver they refer to a judgment of this court. Razai's alliance versus so and so. Andhra Pradesh has said that mere filing of charge sheet is not sufficient. But we have to consider, we will consider it after receipt of the records. But you have to comply some other objections. The notice ಯಾರಿಗೂ ಬೇಕಿದ್ರಲ್ಲಿ?
Specific time, I will take steps for R4.
R4.
Yes,
Who is R4?
Owner of the mini goods vehicle.
That request by, since the liability of the insurer is under challenge, IA3 of 2023 shall be considered after the receipt of the TCRs. At request 2 weeks time is, finally 2 weeks time is granted to do the needful in respect of respond number 4,
Please.
telling which appeal against him shall stand dismissed. Okay. Call for TCRs.
Please.
ಬಂದಿಲ್ಲ ಇಲ್ಲ TCR ಕೆಪ್ಪಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬಂದಿದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ. ಅಡ್ಮಿಟ್ ಆಗಿತ್ತಾ ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ.
ಅದೇ ಆಗಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಆದಂಗಿಲ್ಲ. ಅದಕ್ಕೆ ಇರಲಿ ಕಾಲ್ ಫಾರ್ TCRs. ಡೇಟ್ ಹೇಳಿ, ಲಿಸ್ಟ್ ಆಫ್ ಎಲ್ಲಿಂದ ಬರ್ಬೇಕಾಗಿರೋದು?
7/11.
We'll consider that after receipt of TCRs. Yes.
7/11. Seal number 5, FS Dabali, KT Gurudev Prasad.
So R3. Yes, who is R3? Notice owner. Consignment details not found ಅಂತ ಬರ್ತಾ ಇದಂತೆ. List on date.
ಇದರಲ್ಲಿ first matter and second matter. Your lordship has permitted us to withdraw the amount. Meanwhile, records have come to this court. The records may be sent.
ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ TCR ಸರ್ವಿಸ್.
Unbutted.
3770. ಯಾವಾದ್ರೂ ಫೈಲ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು?
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು.
ಫೈಲ್ ಮಾಡಿ ಹಂಗಂದ್ರೆ ಹಾಗಾದ್ರೆ. Are you going to file it today?
ಮಾಡ್ತೀನಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
Counsel for the parent submits memo for return of the TCRs. ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿದ್ದು ರಿಲೀಸ್ಗೆ?
ಇಲ್ಲಿ ಆಗಿರೋದು 22/8 ಅಲ್ಲಿ.
ABK
40% ಅಂತ ಆಗಿದೆ. 6/7.
22/8.
ಅದಾದ್ಮೇಲೆ ಇದು ಬೇರೆ ಆರ್ಡರ್ ಶೀಟ್ ಇರಬೇಕು.
ಎರಡರಲ್ಲೂ ಆಗಿದೆ.
ಇದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಮಾಡಿಲ್ವಾ ಇದನ್ನು? ಇದು ಫಸ್ಟ್ ಸೆಟ್ ಅಲ್ಲೇ ಮಾಡಿಲ್ವಾ? 22/8/2024 ಆರ್ಡರ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅದು. ಇಲ್ಲಿ 2020. Since return the TCS to the tribunal to enable the claimants to enable the tribunal to release the amount in compliance with the order dated 22/8/2024.
ಅದ್ರಲ್ಲೂ 3867 ಅಲ್ಲ
ಎರಡರಲ್ಲೂ ಅಲ್ವಾ?
ಎರಡರಲ್ಲೂ
ಕಾಮನ್ ಆರ್ಡರ್ list after 2 weeks.
ಅದು
Soon after the purpose is over, the tribunal shall resubmit the records and record. Is
46 third matter ನಲ್ಲಿ 4668/23
ಅಲ್ಲ, this is 5 and 5.1 ಅಲ್ವಾ?
ಹೌದು.
5 and 5.1 ಅಲ್ಲಿ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಡಿಲೇ ಇದೆ ಅಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ.
ಇವರಿಗೆ ಡೈರೆಕ್ಟ್ ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ನೋಟಿಸ್ ಆಗಿದೆ
4668 ಅಲ್ಲ, ಬೇರೆಯವರು ಇದ್ದಾರೆ ಅಪಾರ್ಟ್ ಫ್ರಮ್ FS. ಆಯ್ತು, ಹುಡುಗರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ICICI ಇದೆ. ICICI ಕೃಷ್ಣಕಿ ವಿಶ್ವರಾವ್ ಕೇರಳಿ 5.2 ನಲ್ಲಿ ಶ್ರೀ FS ದಪಾಲಿ ಅಂಡ್ ಶ್ರೀ Krishna Kishore, learned standing counsel, are requested to accept notice for respondent number 1 and 3 respectively. But what about R2?
R2 ಗೆ ಮೆಮೊ ಹಾಕ್ತೀನಿ.
They shall file their ವಕಾಲತಿ within 2 weeks. Their name shall be shown in the cause list accordingly. Appellant's counsel shall serve the copies on them. ಏನು? What about R2?
R2 ಗೆ ಮೆಮೊ ಹಾಕ್ತೀನಿ. ಡಿಸ್ಪೆನ್ಸೇಷನ್
ಮೆಮೊ ಹಾಕ್ತೀರಾ? ಬೇರೆದ್ರಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯಾ?
ಓನರ್
ಅಲ್ಲ, ಕರೆಕ್ಟ್. ಲಯಬಿಲಿಟಿ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಲೈಬಿಲಿಟಿ ಇವ್ರ ಮೇಲೆ ಏನಿಲ್ಲ.
ಅವ್ರು KSRTC ಅವರು
KSRTC ಅವ್ರದ್ದು ಇದೆ.
ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ ಬಿಡಿ, ಯಾಕಂದ್ರೆ ಮೊದಲಿಂದ 2ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಅಂತಾನೆ ಇದೆಯಲ್ಲ 2ರಲ್ಲಿ.
ನೋಟಿಸ್ ಫಸ್ಟ್ ಟೈಮ್ ಐ ವಿಲ್ ಟೇಕ್ ನೋಟಿಸ್.
ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಹೇಳಿ 4 weeks ಬಿಟ್ಟ ಕೊಡಿ.
22/11.
22.
Till number 6, Prakasha HC.
R1 and R2 notice. Address C left ಅಂತ ಬಂದಿದೆ. Address C left, address C cannot be located. ಯಾರು? R1 and R2. R1 is respond number 1. R2 Bharti Access and ಏನು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಕೆನಾಟ್ ಬಿ ಲೊಕೇಟೆಡ್ ಅಂತ ಬಂದಿದೆ. ಪಾಲಿಸಿ ಇಶ್ಯೂ ಅಲ್ಲ, ನೀವಾಯ್ತು ಇನ್ಶೂರೆನ್ಸ್ ಮರ್ಜ್ ಆಗಿದೆ. ಭಾರತಿ ಎಕ್ಸಸ್ ಯಾರು? ಸಂಬಡಿ ಮಿಸ್ಟೇಕ್. ಯು ಟೇಕಿಶ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಹಾಗಾದ್ರೆ ಈಗ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಭಾರತಿ ಎಕ್ಸಾ ವಾಸ್ ದ ಪಾರ್ಟಿ. ಇಟ್ ಅಪಿಯರ್ಸ್ ದೇರ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ರಿಪೋರ್ಟೆಡ್. ಇಟ್ ಸೀಮ್ಸ್
ರೀಸೆಂಟ್ ಆಗಿ ಆಗಿರೋ
it is submitted that Bharti respond number 2 Bharti Exa General Insurance Company Limited is now merged with ಯಾವ್ದ್ರಲ್ಲಿ merged?
ICICI Lombard General Insurance Company.
ICICI Lombard
General Insurance Company.
General Insurance Company. Appellant's counsel shall implead. ಅವ್ರನ್ನು ಮಾಡ್ಕೊಂಬಿಡಿ, ಅವ್ರ ಹೆಸರು ಕರ್ಕೊಂಡು ಅವ್ರನ್ನ. ಅಲ್ಲ, ರೆಸೊಲ್ಯೂಷನ್ ಕಾಪಿ ಒಂದು ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
Appellant's counsel shall impede the said company, successor company also. As respond number 2A anta ಮಾಡಿ. As respond number 2A. Got it? Okay. Shri Krishna Kishore Leonard, standing counsel for ICICI Lombard General Insurance Company is requested to accept notice for the said company. Appellant's counsel, he shall file the wakalat in the registry within 2 weeks. His name shall be shown in the cause list accordingly. Appellant's counsel shall amend the cause title of the appeal memo and furnish the copies to counsel for respond number 2A. Please.
File the amended cause title.
1 week time is 2 weeks. 2 weeks time is granted through the needful in respect of respond number 1.
Right.
List from 2023.
19/11.
ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಅವ್ರನ್ನ 2A ಅಂತ ಮಾಡಿ. Order of this.
Till number 7, B Pradeep, KT Pradeep.
10 ಬರುತ್ತೆ.
For applying.
Dispensation notice to R3. Liability is not in challenge.
No. R3 is owner of the vehicle.
The insurance. R3 is the owner. The appellant challenging the negligence and quantum of. But since respondent number 3 is not, sorry, the appellant insurer is not responding, not disputing its liability under the insurance contract. Notice to respondent number 3 is dispensed with as per. ಏನಾಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ ಮುಂದೆ? ಯಾರೋ?
Delay 146 days.
146 days.
ಹ್ಮ್.
It may be condoned.
Now counsel for respondent number 1 and 2 concedes for condonation of the delay, considering the same and the reasons assigned, the delay of 146 days in filing the appeal is condoned in the interest of justice. I1 of 2023 is disposed of accordingly. Records ಬೇಕಾಗುತ್ತಲ್ಲ
Records
negligence.
ಬೇಕಾಗುತ್ತೆ.
Yes.
My appeal may be posted along with this 6116 of 23.
Yes. It is submitted that this matter is connected to MFA number, so
Six-
also
6163,
that is together
6116 of 23.
4 weeks ಆದ್ಮೇಲೆ
25 level.
25 and 25.
Number 8, Gayatri M, SPP for R1.
Respondent number 2 to 4, my lord.
Hemant
Respondent number
Kumar
2 to 4 are present before this honorable court, my lord. I filed an application for 17 class 2 warrant recall, my lord.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಲ್ಲ ಅದ್ರ ಮೇಲೆ
Topic serve ಮಾಡಿದ್ದೀನಿ, my lord.
ಆಫೀಸರು ಮಾಡೋದಲ್ಲ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಇಲ್ಲ ಅಫಿಡವಿಟ್ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ, ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅಫಿಡವಿಟ್ ಫೈಲ್ ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಬರಲಿ ಹಾಗಾದ್ರೆ ನೋಡೋಣ.
Please, my lord, warrant recall.
ಕರೆಕ್ಟ್ ನೀವು ಹಾಕಿದ್ ನಮಗ್ ಬಂದಿಲ್ಲ. ಈ ವೆನ್ ಡಿಡ್ ಯು ಫೈಲ್ ಇಟ್?
ಮಾರ್ನಿಂಗ್ ಫೈಲ್ ಮಾಡಿದೆ.
ಮತ್ತೆ ಮಾರ್ನಿಂಗ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ವಿ ಶುಡ್ ರಿಸೀವ್ ದಟ್. ಅದನ್ನ ನೋಡಿ
ಕಳ್ಸಿನಿ ಸರ್, ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಓಕೆ.
Passed over. Still number 9, Aslam Khan.
ಅವ್ರು ಬಂದು ನಿಂತ್ಕೊಂಡು ಮಾಡಿದ್ರು. Okay.
Actually, last occasion, 23, I have filed
Good.
to bring the LRs of the,
There is delay of 388 days in filing LR application.
yes,
Council has to file application for setting aside the abatement.
abatement I had to file also because I'm waiting for the appellant, that is the LRs of the appellant to come. They are not come, they are ready, applications ready. I'll give you just a place for 2 weeks then. Abatement I have not filed by oversight laws.
LR's petitioner number 6. ಏನಿದೆ?
Yes, laws.
Petitioner number 6. Where is the petitioner here?
Petition number 6,
ಈ
Right.
ಕೇಸಲ್ಲಿ petitioner number 6 ಎಲ್ಲಿ
I had not,
ಬರ್ತದೆ?
I had not made the party, that the LRs has to be made, bring on records laws.
Who is dead?
She is the mother of the deceased.
She was not made party before the.
Yes, she has made, but it has come to me recently. I have appeared for only for up to 5.
Who-
Petition number,
who are appearing here?
for petition number 1 to 5, later they have come to
Where
me.
is in an appeal where the petitioner comes?
Virajpet, not from Mysore, of Chamarajnagar.
ಅಪೀಲ್ ಅಲ್ಲಿ ಅಪೆಲೆಂಟ್ ಇರ್ತಾರೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರ್ತಾರೆ. ಪಿಟಿಷನರ್ ಎಲ್ಲಿ ಬರ್ತಾರೆ? ನಾವು ಟೆಲ್ ಅಸ್ ಇನ್ ದಿ ಫ್ರಮ್ ದಿಸ್ ರೆಕಾರ್ಡ್ ಹೂ ಇಸ್ ಡೆಡ್.
6 petition, appellant number 6.
ಮೋಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್ ಮಾಡಾಗ ವೇರ್ ಇಸ್ ದ ಸಿಕ್ಸ್ತ್?
I have not made, I have filed an application to bring the alerts of the record. That is that they raised the objection. On that objection, I have filed application.
ಕರೆಕ್ಟ್.
That to bring on records. Madila. Later I have filed. Later I have filed after filing this appeal.
You can file on memo also, saying that already other legal heirs of the deceased are.
How they are related?
They are the sons of the deceased.
ಇದೇ ತರ ಇದ್ದವ್ರನ್ನೇ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತರ್ತಾ ಇದಾರ ನೋಡಿ.
ಅದೇ ಹಂಗೆ.
Who was claimant number 6 was
Mother of the deceased,
Maimunisa.
Maimunisa.
What is the names of these LRs? Muhammad Sadiq,
Yes, Lord.
Dus,
Yes,
Samad.
yeah,
They
3.
were not on record before the trial court.
Yeah, no, they are not on record on trial court, Lord.
Muhammad Sadiq,
Muhammad Sadiq, Abdul Qudus,
Samad.
Talib, Abdul Wajid, Abdul Samad.
Why they were not made party?
That I was not appearing the Lordship, I am appearing here only.
Correct. Where is the survivorship certificate?
That I have not, I'll produce it, Lordship. Legal head, sir. I have produced the other cards I have produced.
Aadhaar card, you have to produce the survivorship certificate.
Yes, Lordship, I'll produce.
And there is office objection also on the.
Yes, that I'll comply.
This
Allow 2 weeks time.
2 weeks time is granted to comply the objection on I number 1 now.
24.
356. Objection on third time ಅಂತ ಅಷ್ಟೇ ಹಾಕಿದ್ದಾರೆ.
That is second time it is coming, lordship. Last week it has come, today it has come.
2 of 2024.
That I'll comply, lordship.
2024. The appellant, I'm sorry, appellant's counsel shall also produce the survivorship certificate to show that applicants 1 to 3 are the legal representatives of deceased sixth claimant. List after 2 weeks.
Much obliged.
Till number 10, Ravishankar Samprati, Madhu MP.
PCR is awaited.
ಎಲ್ಲಿಂದ ಬರಬೇಕು?
ಇಲ್ಲ ಬೆಂಗಳೂರಿಂದ.
List after the receipt of TCRs. ಬಂದು list ಮಾಡಿ.
Till number 11, Narasimhamurthy L.
R1 and 2 ಅಂತ ಬರ್ತದೆ. Left ಅಂತ ಬಂದಿದೆ ಅಂತ ನಿಮ್ಮ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿದು. Which is that appeal? ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ. ಅದೇ who has filed that appeal?
Pradeep.
Shri B. Pradeep, learned standing counsel for respondent Brown is request to accept notice for respondent Brown. It is then it is submitted that this matter is connected to MFA number 908 of 2024. Please both the matters together on and 2 weeks.
12-11.
Copy also, sir.
Copy, no, sir.
ಮಾಡಿ.
Till number 12, Suresh Latur, Manjula.
Appearing for the third respondent, your lordship.
Furnishing PF, you have to furnish PF also to order for the second time. Yeah, request. Next 2 weeks time is granted to do the needful in respect of ಅದು ಬೇಕು, ಅದು ಅರ್ಜೆಂಟ್, you have to pay the process.
And then only we will consider.
ಯಾರಿಗೇನು ಅದ್ರ ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಆಗ್ತಾ ಇರುತ್ತೆ ಅಷ್ಟೇ, ಅಲ್ಲ ಅದ್ರ ಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 3759 R2 respect of R2 ಇಲ್ಲಿ ರಿಟರ್ನ್ ಮಾಡೋಣ ಅಂತ ಹೋಗ್ತಾರೆ. ರಿಟರ್ನ್ TCRs ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದು ಪೇಮೆಂಟ್ಗೆ? when that order payment order is passed? Notice to respondents business. ಎಲ್ಲಿದೆ? when is that order passed here? Why are you seeking the return of the documents? Yeah, insurer has not preferred any appeal.
No, your lordship.
Yeah, satisfied the award. Return the TCS to the tribunal to enable the tribunal to pass orders on the dispersal of the FD amount. Soon after the purpose is over, the tribunal shall resubmit the records. List on four weeks bitte ಹಾಕೊಳ್ಳಿ. ಅದು
25-11. Till number 13, HS Lingraj.
Week's time I kindly be granted to produce the receipt for having deposited the amount. Amount deposit ಆಗಿದೆ ಅಂತ.
Represented. All claimants are served and
Yes.
execution of file ಮಾಡಿದಾರಾ?
I don't. No information.
Request 2 weeks time is granted to comply the office objection.
Till number 14, G. Lakshmi Shra.
Apply ಮಾಡಿರ ಬರೀ ಈಗ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಂತ ಮಾಡಬಹುದು.
We have not deposited the amount, my lords. Some difficulty, my lords, I seek for an extension by 1 week, my lords.
You have filed application? No. You have not deposited so far?
We have not deposited. I obtained instructions today.
You are going to file application for extension?
I have not filed, my lords.
But interim state till next year indeed subject to the appellant depositing 50% of the award amount before that.
That's on 4th of September, my lords. Your lordships have passed an order.
Now,
4th of September.
more than 1 month, it's.
4 ವಾರ ಆಗಿದೆ.
But if you want, you have to file an application. ಅವ್ರು ತಗೊಳ್ಳೋದಿಲ್ಲ.
ಮುಂದಿನ ಸೋಮವಾರದಲ್ಲಿ ಕಟ್ಟಿಸ್ಬಿಡಿ. ನೋಡಿ, I will see that it is deposited within a week, my lords.
ಡೆಪಾಸಿಟ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ತಗೊಂಡ್ ಬಾಳ ಬಟ್ ಲುಕ್ ಎಟ್ ದ ಅಟಿಟ್ಯೂಡ್. ನೀವು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೇರೆ ಯಾರು ಇಂಡಿವಿಜುವಲ್ಸ್ ಆದ್ರೆ ಬೇರೆ.
There absolutely no dispute, my lords.
Even file an application for extension. ಅಲ್ಲಿ ಯಾರೋ IAS ಆಫೀಸರ್ ಇರ್ತಾರೆ, ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್, ಅವ್ರಿಗೆ
ಇಲ್ಲ, ಮಂಡೇ ಒಳಗಡೆ ಕಟ್ಟಿಸ್ಬಿಡ್ರಿ.
we understand it's they have some problem, but at least they should file an application for extension.
Some communication, because this is from Chikmagalur division and another is from Mandya division. They have been requesting the central officers to send the funds. Some difficulty in supplying the funds, my lord. That is a difficulty.
Request finally 2 weeks time is granted to do the needful, failing which interim order shall stand vacated.
Please, my lord, I will see that on Monday. Next matter also similar order.
2 weeks. 14, 15
Similar. Grateful.
ಏನು ಎರಡರಲ್ಲೂ claimants are served but unrepresented. Yes.
Seal number 16, D. Vijay Kumar, Madhusudan N.
I appear for respondent number 1 to 3, my lord.
Second time.
I am the claimant before the
That's number
tribunal.
1 to 3. Non-filing, they have deposited the amount or not?
No, still not deposited.
D. Vijay Kumar. No representation for the appellant, interim order ಬಗ್ಗೆ ತಗೊಳ್ತಾರೆ. Second time, finally 2 weeks time is granted to do the needful in respect of respondent number 4, failing which appeal against respondent number 4 shall stand vacated, shall stand dismissed. Award amount within 4 weeks. ಇದು ಯಾವಾಗ ಆರ್ಡರ್ 4/9.
ಹೌದು ಸ್ವಾಮಿ.
The interim order dated 4/9/2024 for deposit of 50% of the award is not compliant. Therefore, interim order till next hearing date ಅಂತ ಕೊಟ್ಟಿದ್ರೆ
My lord,
interim stay was absolutely good. Interim order. Therefore, respondents claimants are at liberty to execute the award. List after 4 weeks.
Hearing on IA, seal number 17, KB Loknath.
the appellant, my lord, 165 days delay in filing appeal.
Who is the insurer? ಏನಾಗಿದೆ? ಅಲೋ ಆಗಿದೆ, ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Dismiss size.
ಯಾರು? ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. ನೀವಿದ್ದೀರಾ ಶಿವಣ್ಣಗೌಡ? ಶ್ರೀ ಶಿವಣ್ಣಗೌಡ ಇಬ್ರು ಇದ್ದಾರೆ. ಯಾರು ನಿಮ್ಮಲ್ಲಿ ಯಾರು ತಗೊಳ್ತೀರಿ? ಅಶೋಕ್ ಅವರು. Shri B.C. Shivanegoda, learned standing counsel correspondent is requested to accept notice correspondent to. ಉಳಿದಿದ್ದೆಲ್ಲ ಬೇರೆ ಹಾಕೊಳ್ಳಿ. Sir, the copies are in. Shivanegoda. Issue notice to correspondent number 1, list on
2311.
23.
Seal number 18, H.C. Prakasha, C. Shankar Reddy.
188 days. ಎಲ್ಲಿದ್ದಾರೆ ಶಂಕರ್ ರೆಡ್ಡಿ ಅವರು? ಏನು, ವಾಟ್ ಇಸ್ ದ ರೀಸನ್ ಅಸೈನ್? 32, 13, 10 minus. 16,42,032 is granted.
30% contributing negligence on the deceased.
Suffering from viral fever. ಅದಕ್ಕೇನಿದೆ? Suffering from viral fever. ಇಲ್ಲ ಏನೋ ಪಾವರ್ಟಿ, ಇಗ್ನರೆನ್ಸ್, there are 2 minor children, ಅದನ್ನ ಏನಾರ ಹೇಳಿದ್ರೆ ಸರಿ. ಏನೋ ಒಂದು ಮನ್ಸಿಗೆ ಬಂದು ಈಗ ಹೇಳಿದ್ರೆ ನಾವು we ask you to produce the record. ಇದನ್ನ ಹೇಳೋದಿಲ್ಲ, there are 2 minors ಅಂತ ಹೇಳಿ. ಇಂಟ್ರೆಸ್ಟ್ ಡಿನೈ ಮಾಡೋಣ. 188 days ಪಬ್ಲಿಕ್ ಮನಿ Order number 1 of 2023. Considering the fact that claimant number 2 and 3 are minors, and the breadwinner of the claimants had died, delay of 188 days in filing the appeal is condoned in the interest of justice, with the condition that if they succeed in the appeal, appellants shall not be entitled to interest on the enhanced compensation. I number
1 of 23.
1 of 23, 23 is disposed of accordingly. ಇದೇನಂತ ಹೇಳಿದ್ರಲ್ಲ ನೆಗ್ಲಿಜೆನ್ಸ್
Yes, my lord. 30% contributed negligence.
ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCRs.
TCS.
TCS ಬಂದಿದೆ ಇಲ್ಲ
ಇಲ್ಲ, LCR TCR
ಅಲ್ಲ ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ವಾ
ಆಗಿದೆ.
ಅದೇ ಶಂಕರ್ ರೆಡ್ಡಿ ಅವರು ಇದ್ದಾರೆ
On record.
ಅದನ್ನ ನೋಡೇ ಮಾಡಿ ಲಿಸ್ಟ್ ಆಫ್ ದ ರಿಸಿಪ್ಟ್ ಆಫ್ TCS.
Serial number 19,
Machu.
Manjula Devi Kavadolli.
For appellant in this case, this is the case of death and there is a delay of 248 days in filing the appeal, my lord.
ನೋಟಿಸ್ ಯಾರು ಹೂ ಇಸ್ ದ ಇನ್ಶೂರರ್ ಯುನೈಟೆಡ್
United
ಯುನೈಟೆಡ್ ಅವ್ರಿಗೆ ನೋಟಿಸೇ ಮಾಡ್ತೀವಿ
United,
ಅವ್ರೇನೋ ಅಪಿಯರ್ ಆಗೋದಿಲ್ವಂತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು
United India.
ಅಲ್ಲ we were told this insurance company United India, so we assign to somebody, it will not assign to them. We'll issue notice to all of
please,
them.
my lord, I will take notice.
Issue notice to response 1 to 3. List on
2211.
With your lordships kindly, my lord, serial number 16, my lord.
we have already crossed that. It's over.
Alla.
Yes, next.
Is there any adverse order on the state?
Sugunamma, Suguna Reddy.
Yes, I appeal for the appellant in this case, my lord. There is delay of 214 days in filing the appeal, claimant's appeal. It is a case of injuries, my lord.
Which one is there? Was a common order. There were
R1,
Oh,
respondent
yes.
number 1 and 2.
this is against 4032.
I am sorry.
And this is against there were 2 petitions, claim petitions.
No, this is only one, my lord. Serial number 20.
Correct. Yeah, correct. You have challenged only one order. Or
Yes,
there
yes,
is another case also.
That is not, that I have not challenged. Only 4031.
Bajaj Alliance. Where is the Bajaj Alliance now?
4032. My
Bajaj
appeal is in
Alliance.
this.
Anybody is there?
H.S. Lingaraju, Sanmati, H.R. P.V. Raju, Pradeep, O. Manish, N. Krishnaswamy, D. Jayakumar, P.S. Jagadish.
Yes, Jagadish. Where is that? Lingaraj.
R1 is concerned. I am
Yes,
we file a memo for
You-
seeking
we
dispensation
direct
of.
Mr. Lingaraj to take notice, you sir.
Yes, ma'am.
copies and-
Yes, my lord. I will
Yes,
serve.
yes,
I will
yes,
serve.
Yes, just-
And R1 is concerned, your lordship may kindly dispense with issue of notice. I will file the memo in the registry.
Shri H.S. Lingaraj, Lower Standing Council for Respondent is request to accept notice for respondent to. Other than that, Lower Council for the appellant seeks the dispensation of notice to respondent alone. She shall file the memo to that effect in the registry. The records show that respondent 1 had not contested the matter before the tribunal. Liability is given.
He's on the insurance company, my lord.
Under the influent award, liability is passed to the insurer / respondent. Therefore, notice to respondent alone is dispensed with as paid for. You serve the copies.
Yes, 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 yes. I will serve. Much of it.
Serial number 21, Bhanu Prakash H.V.
Bhanu Prakash ಅವಾಗ ಇರ್ಲಿಲ್ಲ ಇನ್ನೊಂದು ಕೇಸ್ there are 2-3 matters. ಯಾರು ಕೊಲೀಗ್ಸ್ ಇಲ್ವಾ? You should have more colleagues. 739. ಏನಿದ್ರಲ್ಲಿ dispensation of notice to R1 and R2. They have not preferred any appeal. There is a common award, whether against other award also a petition is, appeal is fine, not challenge. 480. 480 case of injury. Is it a case of injury or death? 480. No, 480. They are not, insurance company has not challenged the award. There is United India Insurance ಅಂದ್ರೆ notice ಹೋಗು. Delay ಬೇರೆ ಇದೆಯಾ? Memo file ಮಾಡಿದೀರಾ? The record show that 1 and 2 both were ex parte. Respondent 1 and 2 had not contested the matter before the tribunal. Therefore, notice to respondent 1 and 2 is dispensed with as paid for. Issue notice to respondent number 3. List on.
2211. 2211. See number 22, government advocate.
Lords, in the delay application, my lords, there are some errors, my lords. Para number 4 of the delay application.
Notice ಹೋಗ್ಬೇಕಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಅಲ್ಲ,
Officer
correction
section.
ಮಾಡಬೇಕು.
Hmm?
There are corrections to be done in the delay application, my lords. Para number 4.
The office has not raised any objection. Para number 4, what is that error?
The delay application.
Para 4 of the affidavit.
Yes, my lords.
Affidavit ನಲ್ಲಿ ಹೇಗೆ correction ಮಾಡಕ್ಕೆ? You have to file fresh affidavit.
Yes, my lords. We'll do that.
What's the impugn judgment? ಅಲ್ಲ ಇದು IA notice ಹೋಗಿರುತ್ತಲ್ಲ ಮತ್ತೆ. What is the error?
My lords, the judgment was delivered on 3/8, my lords. The certified copy was obtained on 21/2 itself, my lords. Before the judgment was delivered, the certified copy was obtained. So that is the error being committed, and there is a GO also, government order.
Hmm.
So that is the reason.
Now, whenever you have taken the certified copy, date there will be endorsement of the certified copy to that.
Yes, my lords, but there is a GO, my lords, government order, my lords.
What is
That is
the
the reason.
Pricing.
ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ? authorization ಹಾಕಿಲ್ವಾ? See, judgment was received on 21/2, but
Please.
the certificate copy produced here shows that it was received on 23/8. ಅಲ್ಲ, ಇಲ್ಲಿ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. It was received on 21/2, judgment ಆಗಕ್ಕಿಂತ ಮೊದಲನೇ ಕಾಪಿ ರಿಸೀವ್ ಮಾಡಿ.
ಹೌದು.
And the law issued a GO on 33/2022. GO is at page number?
23. Year change. Year change.
ಅಲ್ಲ, ಅದು ಕರೆಕ್ಟ್ ಅಫಿಡವಿಟ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಬೇಕಲ್ಲ ಅವ್ರು ಅದನ್ನ. ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ? ಪೇಜ್ ನಂಬರ್. ಅಲ್ಲ, ಅದು ಬರ್ದಿರೋದಲ್ಲ. ಜಿಯೋ ಎಲ್ಲಿ ಇಶ್ಯೂ?
GO ಇದೆ.
ಪೇಜ್ ನಂಬರ್ 37.
There is GO, that is the reason. And it has been signed by the official.
Learned counsel for the appellant submits that there are some errors in submits that there are some errors in para 4 of the affidavit, accidental errors ಅಂತ ಮಾಡಿ. Accidental errors in para 4 of the affidavit. ಯಾವ ತರದ affidavit swear ಮಾಡ್ತಾರೆ ಅವರು? ಯಾರು? Who is this? Deputy Director of KCI.
Please.
Accidental error in para 4 of the affidavit filed in support of IA number 1 now. ಎಷ್ಟಿದು? IA 1 of 2023. 1 of 23. 1 week time is, I'm sorry. as
That's 2
requested.
weeks. I have to call the official and again GO has to be issued.
ಇಲ್ಲಿ 1 of 2023. ಡಿಲೇ ಯಾವಾಗಲೂ ಫಸ್ಟ್ ಇರ್ಬೇಕಲ್ಲ. At request, 2 weeks time is granted to file the fresh affidavit in support of IA 1 of 2023. List on how much time you want? 2023, 2025 ಬಂದ್ವಿ ನಾವು.
1211.
12.
See number 23, MM Ashoka.
The claimant's appeal, my lord, against the disallowed portion of
Disallowed portion of?
the claim made before the tribunal.
What is the error in that?
Error, my lord, it is a fatal case, my lord.
National Insurance Company. Ashok Patil ಇದಾರಾ ಇದ್ರಲ್ಲಿ?
That is a
You represent National Insurance Company?
delay of 58, 56 days. also.
Ashok and Patil.
Ashok N.
Yeah,
Patil.
better.
Nurse Training Council for Respondent matter is requested to accept notice for respondent. Appellant's counsel shall serve the copy.
Madam,
copy. His name shall
number
be shown in the
good.
copies accordingly.
Actually, look at it.
What about respondent number 1? Hello, 1 and 3. There are more than a trial court only, there were only 2 respondents. Why now?
Although the third one is
Petitioner number 3.
3 is that major daughter,
She has not read.
she has not awarded any compensation. It's
Issue
only a
notice.
formal party.
Correct, dispensation ಮಾಡಿಸ್ಕೊಡ್ತೀರಾ ಹೇಗೆ?
Hangye madam.
Issue notice to respond number 1 and 3, list on.
Number good.
2211. See number 24, Hari Prasad MB.
One 68 is
For the appealment. So RC owner appeal. There is an 168 days of delay.
ಟೋಕಿಯೋ ಯಾರಿದ್ದಾರೆ ಟೋಕಿಯೋಗೆ ಇವರಿದ್ರು ಅಂತ ಕಾಣಿಸುತ್ತೆ. ನೀವಿದ್ದೀರಾ? ನೋಡಿ ಶಿವಣ್ಣಗೌಡ, ನಿಮ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವ್ರ ಸರ್ವಿಸ್ ಆದ್ರೂ ಅಪೇರ್ ಆಗೋದಿಲ್ಲ.
ಸರ್ ಇಲ್ಲ, ಕಂಪ್ನಿಗಳು ಈಗ ಏನಾಗ್ತಿದೆ ಸ್ವಾಮಿ, ಇಲ್ಲಿದ್ದು ಬೇರೆ ಕಡೆ ಹೋದಾಗ ಆ ಒಂದು ಪ್ರಾಬ್ಲಮ್ಗಳು ಆಗ್ತಿದೆ. ನಾವು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿರ್ತೀವಿ, ಬಟ್ ಜನಗಳಿಗೆ ಗೊತ್ತಿರಲ್ಲ ಅದು
ಇದಾರೆ.
ಪಾರ್ಟಿ ಮಾಡಿ.
ಅಲ್ಲ ಇದೇನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಇದು.
ಅಲ್ಲಿ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ, ಈ ಸೆಕ್ಯೂರಿಟಿ ಅವ್ರು ತಗೊಂಡ್ಬಿಡ್ತಾರೆ, ಬಟ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ಅದು ನಾವು
ಬೇರೆ ಕೇಸಿಂದ ಅದು ಟೋಕಿಯೋ ಅಲ್ಲ ಅದು.
ನಾನೇನೋ
8772 ನನ್ ಫೈಲ್ ಕೈ ಕೊಟ್ಟಿದ್ದೆ, ಬೇರೆ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು ಕೈಗೆ, ಅದಕ್ಕೂ ಟ್ಯಾಲಿನೇ ಆಗ್ತಿಲ್ವಲ್ಲ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೆ. ನಿಮ್ದು ಹಾಗೆ ಇದೆ. ಮ್ಯಾನೇಜರ್ ಟೋಕಿಯೋ
Photo.
ಯಾವ್ದು ವಿದ್ಯಾನಗರ್ ಮಂಡ್ಯ.
Yes, my lord.
ಶ್ರೀ ಬಿ.ಸಿ. ಶಿವಣ್ಣಗೌಡ, ಲೆವೆಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 is request. ಸರಿ, ಅಂಡರ್ಟೇಕ್ಸ್ ಅಂತ ಬರಿತೀವಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಪಿಯರ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 is permitted to file the wakalat in the registry within 2 weeks. ಇದರಲ್ಲಿ ಡಿಲೇ ಇದೆಯಾ?
A delay of 168 days.
168 days.
Case of death, my lord.
ಒಬ್ಬರನ್ನೇ ತೋರಿಸಿದ್ದಾರೆ ಇವ್ರನ್ನ.
Case of death, pay and recovery.
ಏನ್ ರಿಕವರಿ ಆಗುತ್ತೆ, ಓನರ್ ಬೇಕು.
ಇಲ್ಲಿ ಓನರ್ ಅಪೀಲ್
Owner, Vasi owner.
ಅವರೇನು they have not filed an execution petition,
They have filed an execution petition pending, my lord.
but ಅವ್ರ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಬೇಕಾಗುತ್ತಲ್ಲ. ಈಗ there is
The notice has been served on all the parties.
third and represent
On all the parties it has been served.
5466. What do you say for delay? Owners appeal.
ಡಿಲೇ ಕಂಡು
ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅವರು? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗಲೇ ಗೊತ್ತಾಯ್ತು ಅಂತನಾ?
Oh, Swami.
ರಿಕವರಿ ಬಂದಿದೆ.
Contested before the trial court or not? As either HC.
ಕಂಪನಿ ಅವ್ರು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿ,
It has appeared for him.
that after the award, company has satisfied the award, pay and recovery order has been passed. Pay and recovery order has been challenged by him. Already,
Oh, you have initiated proceedings against them,
we have initiated.
Execution petition has already been filed against me, my lord.
filed by
That's
the insurance company.
Yes, my lord.
Insurance company.
Insurance company.
Then if you also have to deposit certain amount, if at all you want to pay, stay execution.
The applicant is ready to
Very
pay
poor.
the deposit. Statutory amount has been deposited 25,000. If an order of stay is granted, the applicant would definitely pay the order of.
Correct, you were represented through an advocate before the trial court. Here also you do not file the appeal immediately. Now there is 188 days delay.
For the reason, my lord,
168 days delay is there.
the application was filed on 1/8/2023 and the copy was ready only in the month of November.
Correct, ಅವಾಗ 168 days ಆಗುತ್ತಾ?
Subsequent,
ನೋಡೋಣ, we'll see your certified copy.
please, my lord.
1/8/2020, that is at the most 3 months.
Yes, my lord. After that, he had some loss in the business, my lord, and he could not consult an advocate. Only after that, he approached me and an appeal has been preferred, my lord.
ನಮಗೆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋದಕ್ಕೆ we are not finding grounds now. Business ಪನ್ನು poverty ಎಲ್ಲಿ?
Because of the corona, he underwent it.
If he comply conditional order,
What was that, right, what was that condition violation? Why it was pay and recovery, ನಿಮಗೆ records.
don't know. Basis of
It
the.
is based on the identification of who was actually the rider, my lord. There was a dispute as to who was rider. Though there was a charge sheet filed and the accused was acquitted. And the court come to a conclusion that the pillion rider was actually the rider. A charge sheet was on the rider and he got acquitted after full test trial.
Considering the English ನಲ್ಲಿ sign ಮಾಡಿದ್ದಾರೆ, ignorance considering there is.
He's a businessman.
Delay of 168 days in filing the appeal is condoned in the interest of justice. I 1/2020, he is disposed of accordingly. Okay. Stay ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅವ್ರು ಕಾಪಿ ನೀವು ಸರ್ವ್ ಆಗಿತ್ತು. ಸಬ್ಜೆಕ್ಟ್ ಟು ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡೋದು? ಸರಿ, 5 ಲಕ್ಷ ಬಹಳ ಕಡಿಮೆ ಆಯ್ತಲ್ಲ.
5 lakhs.
What do you say for interim stay?
The condition, your lordship, it's the discretion of the court.
Not asking you 25 lakhs, 17,060 is the, decretal amount.
At least 75% of the award amount, maybe.
50%, 50, 10 lakhs.
My lord, even
When, okay, 10, one was. He was represented. by another.
ಡೆಪಾಸಿಟ್ ಅಷ್ಟೇ ಮಾಡಿರ್ತಾರೆ ಸ್ವಾಮಿ, ಸಾಟಿಸ್ಫೈ ಮಾಡಿರ್ತಾರೆ, ಏನಾದ್ರು ಸಕ್ಸೀಡ್ ಆದ್ರೆ he will get the return the money. It will be laying in the court.
thing is that,
Appellant depositing
please,
rupees 10 lakhs.
my lord, 5 lakhs, my lord. He has already underwent a loss in the business. That is what the affidavit says, my lord.
Why should he own a vehicle if that is the case? If he was under loss, it was the vehicle.
Vehicle is a two-wheeler vehicle, my lord.
Who was
My lord, there is a dispute with regard to identity of the rider.
Leonard
Against the rider.
What was, troubling us was that 168 days, though you were represented before the trial court by an advocate, you
Please,
did not file an appeal in time. Now also you are not ready. Whether is it for courts or for the benefit of the people who are indolent?
I request for any reason about 5 lakhs, my lord.
Subject, warrant ಬಂದ್ರೆ ಅವರೇ ಕೊಡ್ತಾರೆ ಬಿಡಿ. Appellant depositing rupees 10 lakhs before the tribunal. Out of the said 10 lakhs, 5 lakhs shall be deposited within 4 weeks from the date of this order, and balance 5 lakhs shall be deposited within the next 4 weeks. I number 2023 is disposed of accordingly. List on 8 weeks with report. Records all for
Straightforward.
TCS and ಮಾಡಿದ್ದೀವಿ.
9th one. Okay, number 25. Syed
For
Abdul
appellant, appellant in this case, my lord, it's the case of injury, my lord.
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿಗೆ ಬೇಕಾದ್ರೆ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಕಟ್ತಾರೆ ಅವರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿಗೆ.
It's a case of injury, my lord.
ಮೊದಲು ಅವರು ಡೆಪಾಸಿಟ್ ತರ ಮಾಡಲಿ, ಅವರ ಆರ್ಡರ್ ವಿಲ್ ಬಿ ಫ್ರೀ ಮ್ಯಾಚ್ಯೂರ್ಡ್. ಎಸ್ ಏನಾಗಿದೆ ಇದರಲ್ಲಿ 160
It is a injury, my lord.
ಏನು ಕ್ವಾಂಟಮ್
16 disability is 84%, but the tribunal has awarded only 16%, my lord.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾಂಡ್. ಯಾರು ಹೂ ಇಸ್ ದ ಇನ್ಶೂರರ್?
Insurance is Oriental, my lord.
ಓರಿಯೆಂಟಲ್ ಯಾರು ಇದಾರ? ಇವ್ರು ಇದಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಇದಾರ ಓರಿಯೆಂಟಲ್ಗೆ?
ಇದಾರೆ.
ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು
Oriental.
ಯಾರು ಇವರು ಇದಾರ? ವೃಷಭೇಂದ್ರ ಓರಿಯೆಂಟಲ್ಗೆ ಇದ್ದೀರಾ? ಯಾರು?
HC Vishwendraya.
HC Vishwendraya, lawyer standing counsel for respondent is requested to accept notice for respondent. ಯಾರು ಕ್ಲೈಮೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ಅವರು ಇಲ್ಲಿ ಆನ್ಲೈನ್ ಇದ್ದಾರೆ. Mr. Sabur,
Yes, ma'am.
sir, the copies and Vishwendraya.
Yes, my lord. Yes, my lord.
What about respondent number 1?
To be dispensed with because liability is on the R2, my lord.
You have to file a memo in the registry for that.
Yes, my lord, I'll definitely help.
Lawyer counsel for the appointment 6 dispensation. ಸಾಹೇಬ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೀವು ಕಾಣ್ತಾನೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. ಸಬೂರ್ ಅವ್ರ ಏನಂತ?
I'm not well, my lord. I underwent surgery, eye surgery.
Sir, get well soon.
Yes.
ಏನು what was your problem?
2 eye surgery.
ಆಲ್ ರೈಟ್, ಅವ್ರಿಗೆ ಬೆಳಕು ನೋಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. Counsel for the appellant seeks dispensation of notice for respondent number 1. He is permitted to file a memo to that effect in the registry. Records show that respondent number 1 had not contested the matter before the tribunal. Under the impugned award, liability is passed to respondent number 2.
Yes, my lord.
Impugned award, liability is passed to respondent number 2, the insurer. Therefore, notice to respondent number 1 is dispensed with as paid for. Delay ಏನಾರ ಇದೆಯಾ? 16 days.
Yeah, 16 days, my lord.
ಏನು? You want time to condonation of delay? ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ ಹೇಳ್ತೀರಾ? Unless after 2 weeks. ವಕಾಲತ್ ಹಾಕಿ ಮೊದಲ ಆಮೇಲೆ ಕಾಪಿ ಸಾರು ಮಾಡಿ ಅವ್ರು.
Yes, my lord. I'll serve.
BC Shivannegowda, Tippeswamy BC.
In this case, I have deposited the amount of 11,79,861 on 29/5/24. I will produce the acclarament.
ಎಲ್ಲ withdrawal application ಹಾಕಿದಾರಲ್ಲ.
We are challenging the liability.
No representation for respondent number 3 is minor for respondents. Respondents.
ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. Any date may be fixed, my lord.
Proof produce ಮಾಡಿ.
I will produce it minutes. Any date may be fixed, my lord, for final hearing.
Proof of ಡೆಪಾಸಿಟ್ ಆಫ್ ದ ಅಮೌಂಟ್. ಇದರಲ್ಲಿ ಏನ್ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಆಗಿ ಅಡ್ಮಿಟ್ ಆಗಿ ಎಲ್ಲ ಆಗಿದೆಯಾ?
ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TC.
Match.
List after 2 weeks. ಬಂದಿಲ್ಲ.
Cell number 27, Nagraj Hegde.
Notice delay of 41 days. ಏನಿದು what? Quantum?
Yes, madam, only quantum.
Okay. Disability taken is on the lower side. Who is the national insurance company? ಈಗ ಯಾರ ತಗೊಂಡಿದ್ರಲ್ಲ, ಇದೀರಾ ನೀವಿದ್ದೀರಾ? ವಿಶ್ವೇಂದ್ರ ಅವರು ಇದ್ದೀರಾ?
ವಿಶ್ವೇಂದ್ರ ಇದೆ. HC Vishwendra.
Vishwendra, standing counsel for respondent is requested to accept notice for respondent. What about respond number 1?
Notice me.
Notice ಹೋಗ್ಬೇಕಾ?
Yeah, appeared through advocate and.
ಡಿಲೇ ಇದೆಯಾ?
41 days.
Issue notice to respond number 1. ಅವ್ರಿಗೂ ಕಾಪಿ ಸರ್ list
3511.
25.
Cell number 28, Sachin VS.
834 days.
834.
Appeal is by whom? Claimants. Yes, ಅವರೇ ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ನೀವೇ ಇದ್ದೀರಾ ಅದರಲ್ಲೇನು?
N Krishna.
ಇವರು ಇದ್ದಾರೆ, ನೀವು ಇದ್ದೀರಾ?
National.
ಅವರೆಲ್ಲ ಈಗ ಈಸ್ ಲೈಕ್ ಅ ಬ್ಯಾನಿಯನ್ ಟ್ರೀ ಎಲ್ಲರಿಗೂ. ಶ್ರೀ BC ಶಿವನೇಗೌಡ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ಟು
National Insurance.
is requested to accept notice for respond to ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ವಾಟ್ ಅಬೌಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1? ಅವ್ರಿಗೂ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1. ಲಿಸ್ಟ್ ಆನ್
2511. Cell number 29, Rangegowda NR.
ಈ ಸರಿ ಮಾತ್ರ ಅವ್ರಿಗೆ ಕೊಡೋದು ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ.
Climate's appeal.
ಆನ್ ವಾಟ್ ಗ್ರೌಂಡ್?
Not enhancement of compensation and contributory negligence fixed against the appellant.
ಎಸ್ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರು ಇದೀರಾ? ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಈ ಸರಿ ಅವ್ರು ಯಾವಾಗ they feel bad if court assigns the matter and they remain absent. But issue notice to the respondents. List on
2511.
Not the memo for dispensation of notice to order.
even a contributory negligence and
This is just a, as against the, is the one.
as against the deceased.
This is the one.
ಅಲ್ಲ ಇಬ್ಬರಿಗೂ ಶೇರ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ ಹಾಗಿದ್ರೆ
ಇಲ್ಲ.
deceased and
Eh,
ಎಷ್ಟು how far?
Insurance company 85%. Deceased on the part of the deceased is 15%.
So ಓನರ್ ಅವರು ಅಲ್ಲಿ
Owner and not necessary there. They have
ಅಲ್ಲಿ
satisfy the trial court award.
expert.
Please.
They have satisfied.
Please.
Now counsel for the appellant submits memo for dispensation of notice to respond number 2. The records show that respond number 2 had not contested the matter before the tribunal. Therefore, notice to respond number 2 is dispensed with as paid for. Issue notice to respond number 1. List on
2511.
Much obliged.
30, N Krishnaswamy.
City has granted 1,62 lakhs and odd and held 50% negligence on the driver of lorry and another 50% on the driver of car. Not vehicle hits from behind, therefore 100% negligence
case of
has.
injury, no? It's a case of injury.
Yes, ma'am. But,
There is delay also.
there is delay, I may be
39 days.
deposit 50% of my liability.
How much is apportionment is?
50-50.
Recover 50% of the amount jointly and recover. Respond number 2 shall deposit the entire compensation amount of the.
Once again, pay and recovery. My lord, the honorable judge holds that I am liable to
Thereafter, said respondent can recover 50%
50% from a tortfeasor who is not even a party.
and insurer of the car, owner and insurer of the car. Andre, that insurance company is not made party.
Not made part.
Only one insurance company.
One
was-
insurance company,
So your liability is 50%.
50% on me.
But our 50%.
We can't recover it. Meaning,
ಅಲ್ಲಿ correct.
we cannot recover from him.
ಅವ್ರೇ ಇಲ್ಲಿ ನೋಡಿ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ
And
ಆ ಇನ್ನೊಂದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಪಾರ್ಟಿ ಮಾಡೇ ಇಲ್ಲ.
ಆದ್ರೂ ಸಹ paid recovery. This concept has proceeded further.
Necessary
At least you would have made party, yes.
ನಾನ್ ಮಾಡ್ತೀನಿ, ಈಗ ಮಾಡ್ತೀನಿ. My lord issues notice, I will make insurer and also owner of other insurance.
taken up that contention.
We have taken up no negligence as far as lorry is concerned. But entire negligence on the part of driver, 50-50 ಮಾಡಿದ್ದಾರೆ. I will take note, make him a party and
Insurer of the lorry or car? You are the insurer of the lorry or car?
lorry.
Lorry.
And it hits behind, from behind. That is what the finding is.
Issue notice to the respondents. Increase of execution of the include award till next hearing date because there is delay.
Not good.
Till next hearing date, subject to appellant depositing 50% of its liability in terms of the award. In terms of within 4 weeks from the date of the receipt of the copy of this order. List on
26/11. List number 2.
ಇಲ್ಲಿ ಮಾಡೋಣ. They can see that from non-joint office report.
List number 2, hearing on IAS, number 1. Yes, Balakrishnan, SPC.
Hearing for appellants, my lords.
Mission to one. Yes. 76 days delay is there in the first appeal, 75 days, 70, ಎಲ್ಲದರಲ್ಲೂ delay ಇದೆಯಾ?
4 matters 76 days delay and in 5 matters 75 days. 75 days.
In some cases 76 days and in some cases 75 days.
days.
In custody is the reason?
Yes, my lord.
Yes.
I was not able to reach his relatives also.
Delay condone ಮಾಡೋಣ. ನಾಲ್ಕು
After 30 days, it is the satisfaction of the son report not to condone the delay. As per the
Yeah.
act.
This is investigation conducted by
Notes,
NI.
CCB matters.
CCB, not.
Yes, ma'am.
As per NA section 21 appeal.
No, you are referring to UAPA Act.
30 days.
Yes, matters.
UAPA Act and
UAPM.
UAPA, not NI. ಯಾವ್ದು provision?
Section 25, 21 plus 5 of NIA Act.
Plus 5 matters.
They are in judicial custody alva. No, this appeal is not under the NIA Act. 21(4). But it was submitted that this was not conducted by NIA, investigation is
No,
there.
my lords. CCB is also important, my lords. This is NIA court, my lords.
Correct, appeal ಬರೋದು NIA Act ಅಲ್ಲಿ ಬರುತ್ತೆ, ಆಮೇಲೆ ಬರುತ್ತೆ.
Like NIA Act.
NA.
Since schedule offense are there, UAPA is there, my lords, schedule offense. Schedule offense is there, my lords.
Other side.
There is a still offenses.
Schedule offenses, okay. Generally, a national investigation agency ಅವರು investigate ಮಾಡೋದು. For High Court in Central prescribing for custody. 21. So after 90 days, no appeal.
Lords.
After 30 days, only
And
the
that also
period
not-
is between 30 and 90.
30 and 90 days.
60 days.
Recently, there is a coordinated bench.
6 days ಅದರೊಳಗೆ ಬರುತ್ತಲ್ಲ.
That's it, my lords, 90 days, within 90 days. Even after 90 days also, my lords, there is judgment of this honorable court coordinated bench recently. But my lords, beyond 90 days also, it is condoned. if I'm right, my lord, so.
Can be condoned.
Then, my lord, if I'm right, my lord, just I have to verify that judgment. Recently, my lord, so. But any,
60 days plus 60 days is assigned land acquisition act, 39. So appeal should be against the reference code. or
If delay is beyond 90 days, it cannot be condoned. But ಇಲ್ಲಿ 90
but
days
any,
ಇಲ್ವೇ ಇಲ್ಲ.
in this case, my lord, that is not applicable, my lord, so it is within 90 days.
So-
If
But-
recently, my lord, if I'm right, my lord, so just I will verify, coordinate. with-
According to section
Yes, sir.
21 class 5 megawatts, there is a provided
Right.
further that no appeal shall be entertained after the expiry of period of 90 days. my lord.
That's 90 days. In your case, it's not
Recently.
all within 90
I will
days.
verify, my lord.
Within 90 days.
But they are all in judicial custody.
Yes,
So
ma'am.
that would be the cause.
It's same thing.
ಅಲ್ಲ, ಇಲ್ಲಿ ನಾವು 90 days ಅಂತ.
90 ಮೇಲೆ ಕಂಟ್ರೋಲ್ ಮಾಡಬಹುದು.
ಇಲ್ಲಿ 90 these cases.
In this case, my lord, it is 90.
ಬಂದಾಗ ನೋಡೋಣ.
But after
Our
30 days, it is the satisfaction of the son of court, my lord, to condone the bill.
In all these matters, the appellants are in judicial custody. There is delay of the delay ranging to 75 to 76 days in filing these appeals. Judicial custody of the appellants is the ground urged to explain the delay. Considering the same, application is under 21(5).
21 class.
21, read with section 21 of the.
5 of limitation act, my lord, so.
5 ಆಯ್ತು. Delay of. Sorry, no. Considering the same and the fact that the delay is within 90 days, 90 days, the delay in filing the above appeals is condoned in the interest of justice. Another one of 2024 in all the above appeals is disposed of accordingly. Yes, ಏನು counter ಏನಾರು ಹಾಕೋದಿತ್ತಾ?
Lords, 2 weeks time may be granted, my lords, to file counter. 2 weeks time may be granted, my lords.
Date may be given, my lords.
Because I had to,
Successive bail application.
Since 2000
lords, I had to get the instructions with regard to my lords, because some of the accused appellants were involved in my lords convicted by Kerala, my lords, in Kerala. But I am trying to get the information, my lords, of those cases also.
may be listed in.
SPP 2 ಅಲ್ವಾ?
SPP 2, my lords.
ಇದು successive bail application.
Lords,
Successive bail application or
No, my lords.
that I am trying to verify, my lords.
successive bail application. Repeatedly ಬರ್ತವೆ ಅದಾದ್ಮೇಲೆ ಇದು ಇದಾದ್ಮೇಲೆ. Reviewing the orders for successive bail application. Now only changed circumstance they have to establish. What is the changed circumstance? Only custody.
Custody period, my lords.
That
Now the matter is, my lords, set down for my lords arguments.
that's idralli similar matters are these matters only we have noticed that.
I'll
Only
file up.
one witness was not, I mean.
No, my lords,
the-
313 is, my lords, over. Arguments on the prosecution side is over. Now, my lords, they have come up with certain applications to recall 2-3 witnesses, my lords. Because of that, this delay. Not, delay is not on the part of prosecution, my lords.
Right, that's, no, they only in some Supreme Court order was there here to recall one witness.
That is, everything is over, my lords. Now, after argument of,
That is also over now.
after argument of, my lords, prosecution side, now they have filed 3 applications, my lords. In fact, they have,
At request of counsel, says, PP2, 2 weeks time is fine, granted to file.
date may be.
ಅಲ್ಲ ಅದು ಏನಂದ್ರೆ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇರ್ತಾರೆ, ಡಿಲೇ ಮಾಡಬಾರ್ದು ಅನ್ನೋ.
I will file objections, my lords. I will not seek any adjournment, my lords, 2 weeks time, my lords.
What we are trying to tell you is, it is a successive bail application. There will not be much for you to file. I mean,
No, with regard to,
bail ಅಂತೂ ಏನೂ ಇರೋದಿಲ್ಲ, only changed circumstances.
yes, ma'am.
File counter to the appeals, list on 10 days ಆದ್ಮೇಲೆ date. You can file it.
411.
That's all. Instead of 4 file,
File.
publish.
11.
ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ.
List number 1.
ಇಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ಒಳಗ್ ಮಾಡ್ತಿರ್ತಾರೆ. ಇಲ್ಲ, you have to do it. Yes.
List number 1 for admission, seal number 31, R Raghu
For appellant, my lord.
and Patil.
Case of death, my lord. Aged about 51 years at the time of the accident, my lord.
1 second. SPP ಅವರೇ ರೇಟ್ ಆಯ್ತು ಕಾಮನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು ಆಗುತ್ತೆ ಎಲ್ಲದ್ರಲ್ಲೂ ಕೇಸಲ್ಲಿ ಅಂತ ಸೇರ್ಕೊಂಡು ಸೊ ದಟ್
What is the stage is important. I will tell you.
ಎಸ್
Objection for all.
ಎಸ್ ಅಲ್ಲಿ ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಎಸ್ ಹೇಳಿ ಮಿಸ್ಟರ್ ರಘು ಏನಿದೆ ಅಡ್ಮಿಷನ್
My lord, case of death, my lord. Aged of 51 years, my lord, at the time of the accident, and my lord is doing banana business and earning 20,000 per month, my lord. Court has taken 6,500, my lord. Date of accident is, my lord, 2015 year, my lord, 9,000 ಆಗ್ಬೇಕು sir. ಅದೊಂದೇ
ಅದಂದೇನಾ
9,000 into 1/3 ಆಗ್ಬೇಕು ಸ್ವಾಮಿ, 10% future factor add ಆಗ್ಬೇಕು.
ಸೊ ನೋಷನಲ್ ಇನ್ಕಮ್ ಓನ್ಲಿ
ಅಷ್ಟೇ.
ಎಸ್ ಏನ್ ಹೇಳ್ತಾರೆ ಎಷ್ಟಿತ್ತು ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್
15 ಇದೆ sir. 2015. 9,000 should be, my lords, adopted.
2000
6,000.
500 ತಗೊಂಡಿದ್ದು.
6,500 is taken.
9,000 plus 10% ಆದ್ರೆ 9,900 ಆಗುತ್ತೆ.
17 ಅವಾರ್ಡ್
Age ಎಷ್ಟು?
Age 51 years.
51 years.
10%.
10%.
10%, my lords, is the future prospects to be added.
Date of accident is 8/12/2015.
Yes.
6:45 PM. Age based on PM report.
Yes, madam.
Yes, my lords.
What is the age?
51 years.
11.
Dependents.
Wife and 2 children, my lord, 1/3 deduct ಮಾಡಿದಾರೆ already.
ಅದು ಕರೆಕ್ಟ್ ಇದೆಯಾ?
Correct
Is
ಇದೆ.
also correct.
1/3 is correct.
Yes, ma'am.
So income we have to take at
9,000 plus 900, madam. 9,900 divided by 1/3,
then is sing plus
10%.
self banana business.
Banana business. Banana sales business.
ಸರಿ ನಾವು ನೋಡ್ಬೇಕು ಅವ್ರು ಹೇಳಿದ್ರು 51 years 10% ತಗೋಬೇಕು.
Yes, ma'am.
9,900 ಇದರಲ್ಲಿ ಮೈನಸ್ ಎಷ್ಟು 3 ಡಿಪೆಂಡೆಂಟ್
1/3 ಅಂದ್ರೆ 3,300 ಆಗುತ್ತೆ ಮೇಡಮ್ ಮೈನಸ್.
into 2/3 ಮಾಡ್ಬೇಕು
Yes,
ಅಷ್ಟೇ.
ma'am.
6,600.
6,600
Into 12 into 11, madam, multiply.
600 into 12 into
11 multiply.
ಕರೆಕ್ಟ್ ಇದೆ ಮಲ್ಟಿಪ್ಲೈ.
Multiply correct.
ನೀನು ಯಾರೋ ಹೇಳ್ದಾಗ
8,71,200. 71,200.
8,71,200. ಇದರಲ್ಲಿ ಆಯ್ತಲ್ಲ ಒಂಥರ್ಡ್ ಮೊದಲೇ ಮಾಡಿದೀವಿ. ಕಾನ್ಸೋರ್ಷಿಯಮ್ 3 ಜನ ಇದ್ದಾರೆ. 1,32,000 ಆಗುತ್ತೆ ಕರೆಕ್ಟಾ?
Yes, ma'am.
33,000.
There is medical expenses of 19,760, my lords. Your lordship, kindly take note of that.
19,760.
760.
ಅದು ಅದೇ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಲ್ಲ.
ಇಲ್ಲ.
That has to be 19,760. ಅದೆಲ್ಲ ನಮಗೆ ಅದನ್ನ ರೀಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ
19,760.
760 ಇದಿಷ್ಟು ಸೇರಿಸಿದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
760.
760.
ಇಲ್ಲಿದೆ ಬೇಕಲ್ಲ?
Yes, ma'am.
ಅಷ್ಟೇನಾ?
10,55,960.
ಇಂಟ್ರೆಸ್ಟ್ 6% ಕೊಡಿ. ಎಷ್ಟು?
10,55,000.
10,55,960. 960. ಅಷ್ಟೇ ಅಲ್ವಾ ಇದು?
ಹೌದು.
The matters come up for ಇದರಲ್ಲಿ ಏನಾಗಿತ್ತು ಉಳಿದವ್ರಿಗೆ ವಾಟ್ ಅಬೌಟ್ ಅದರ್ಸ್?
R1
third unrepresented. Whether the company, though the matter has come up for admission with consent of both sides and the matter is taken for final disposal. Whether the compensation awarded to the appellant's claimants by the influent award is just as a question involved in this case. The appellants were claimants 1 to 3 and respondents were response 1 to 3 in MEC number 825/2016 before the senior civil judge and JMFC and MACT Nanjangud For the purpose of convenience, the parties are referred to henceforth according to their ranks before the tribunal.
130.
ಯಾವ್ದು consortium one
Claimant number one is wife and children, you know.
1,32,000.
Claimant number one is the wife. 2 and 3 are the minor children of deceased Subbanna on 18/12/2015 at 6:45 PM. When Subbanna was proceeding on his bicycle near Devi Ramanahalli Gate Cross, lorry bearing registration number KA09 P8028 driven by respondent number 1 hit the bicycle of Subbanna and caused him grievous injuries. Immediately, the injured was shifted to Government Hospital Nanjangud, and from there he was shifted to JSS Hospital Mysore for
10,55,960.
higher treatment. He succumbed on 9/12/2015. He succumbed to the injuries. Hospital in the hospital. His driver come owner at the relevant time, respondent number 1 and 2 were the driver and owner of the offending lorry, and respondent number 3 was the insurer of the same. Claimants filed MVC number 825/2016 before the tribunal, claiming compensation of this 53 lakhs on the ground that deceased was earning rupees 20,000 per month by doing banana business, and they were all dependent on him, on his income. They claimed that due to his death, they have suffered damages to the tune of 53 lakhs. 53 lakhs. Next. Yeah. Respondents 1 and 2 did not contest the petition. Only respondent insurer contested the petition, denying the rashness and negligence on the part of the driver of the lorry, age, occupation, and income of the deceased, and its liability to pay the compensation. Respondent also contended that the driver of the lorry was not holding effective driving license and vehicle had no permit and fitness certificate, etc. Thereby, there is violation of condition of the policy. In support of their claims, claimants got examined claimant number 3 as PW1 and got marked exhibit P1 to P24. Respondents did not adduce any evidence. The tribunal, on hearing the parties by the impugned award, held that the accident occurred due to the actionable negligence on the part of driver of lorry number, the driver/respondent number, driver on the part of respondent number 1, the driver of the lorry. The tribunal considered the age of the deceased as 51 years, notionally assessed his income at rupees 6,500 per month. ಅದಕ್ಕೆ ಇದನ್ನು ಕೊಟ್ಟಿಲ್ವಾ ಅವರು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 2017 ಜಜ್ಮೆಂಟ್ ಅವಾಗ ಇನ್ನೂ ಬಂದಿರ್ಲಿಲ್ವಾ ಈ ಜಜ್ಮೆಂಟ್ ಅಂತ ಕನ್ಸ ದಿಸ್ ಇಸ್ ಬಿಫೋರ್ ಪುನೈಸಿಂಗ್ applied deducted 1/3 from his income, applied 11 multiplier and assessed the damages on the loss of dependency at rupees 5,72,000. The tribunal in all awarded compensation of 7,61,760 on different heads as below. The page, internal page 8 ಒಳಗಿದೆ ನೋಡಿ statement. Tribunal further held that tribunal rejected the contention of the insurer about violation of policy conditions and directed respond number 3 to 3 to deposit the balance, the compensation amount. Next one. I'm sorry, respondents have not challenged the award on any of the grounds. Claimants / appellants have challenged the award on the ground of questioning the adequacy of the compensation awarded. She so and so learned counsel for the appellants submits that the income assessed by the tribunal is on the lower side. And tribunal ought to have added future prospects to the income of the deceased. ಅದು ಒಂದೇ ಅಲ್ವಾ ನಿಮ್ದು ಸಬ್ಮಿಷನ್ ಅದು ಒಂದೇ. Shri Ashok B. Patil, learned counsel, submits that since there was no proof of actual income, the tribunal was justified in assessing the income at this 6,500 per month. ಏನ್ ಕೊಟ್ಟಿದ್ರು ಅವ್ರ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಿದ್ರು because he was aged 51 years.
No documents produced.
No document.
Yes, ma'am. The fact that the claimants were the dependents of the deceased and he was doing he was trading in bananas. ಅದ್ರ ಬಗ್ಗೆ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ. ಟ್ರೇಡಿಂಗ್ ಇನ್ ಬನಾನಾಸ್ ಅನ್ನೋದಕ್ಕೆ ಅಲ್ಲ, ಟ್ರೇಡಿಂಗ್ ಇನ್ ಬನಾನಾ and he was their breadwinner is not disputed, was not disputed. At the time of the accident, the deceased was aged 51 years and hale and healthy. Considering the cost of living and minimum wage rates during the relevant period, the notional income assessed by the tribunal is on the lower side. It should have been minimum at rupees 9,000 per month. Per month. In view of the judgment of the Supreme Court in Proceedings this case, and having regard to the age and employment of the deceased, future prospects at the rate of 10% on the income of the deceased has to be added to his income. Out of the income of the deceased, as he had Mr. dependents, 3 dependents, 1/3 has to be deducted for his personal expenses. Therefore, his monthly income comes to rupees 9,000 plus 900 is equal to 9,900 into 2/3 is equal to 6,600. The applicable multiplier is 11. Therefore, compensation payable on the head of loss of dependency comes to 6,600 into 12 into 11, 8,71,200. In view of the judgment of the Supreme Court in Pranay-Sethi's case and Magma General Insurance Company's case, that each of the claimants are entitled to compensation of rupees 40,000 on the head of consortium with escalation of 10%. Similarly, the claimants are entitled to compensation of
rupees 15,000 plus 15,000 on the heads of funeral expenses and loss of estate with escalation at 10%. The medical expenses awarded by the tribunal, which comes to rupees 33,000, comes to 33,000. The medical expenses awarded was based on the evidence adduced. Therefore, the just compensation payable is as follows. Loss of dependency, 8,71,200. Consortium, 1,32,000. Separate account. Funeral expenses, 16,500. Loss of estate, 16,500. Medical expenses, 19,760. Total 10,55,960. ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆಷ್ಟು 7 lakhs ಆಗಿದೆ.
7,61,760.
ಅಲ್ಲಿ minus 7,61,760 awarded by the tribunal. ಎಷ್ಟಾಗುತ್ತೆ ಅವಾಗ? 7,61,760. ಇದ್ರಲ್ಲಿ ಯಾರು ಹೋದ್ರೆ
2,94,000.
enhancement ಅಂತ ಬರ್ಕೊಳ್ಳಿ. For the purpose of business, the appeal deserves to be allowed in part, hence the following order. The appeal is partly allowed. Even 53 ಲಕ್ಷ ಕೇಳಿದಿರಿ. Claimants are entitled to enhanced compensation of rupees 2,94,200 with interest thereon at 6% per annum from the date of the petition till its realization. Respondent, the insurer, free alla.
Yes, madam.
Respondent,
deposit the enhanced compensation before the tribunal within 4 weeks from the date of the receipt of a copy of this order. On such deposit, the tribunal shall digitally release the said amount to the claimants.
The entire amount may be
Release the said amount in terms of the award regarding their shares.
Number 32, Suresh Latu.
Correction. Where is their insurance company? Notice delay ಇದೆಯಾ? ಹಾಗಾದ್ರೆ ಡಿಲೇ ಏನು? ಇಟ್ಸ್ ಕೇಸ್ ಆಫ್ ಇಂಜುರಿ. ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತೆ ಹಾಗೆ. ಏನು ಡಿಸಬಿಲಿಟಿ ಯು ಆರ್ ಕ್ವಶನಿಂಗ್? No, you are on which ground?
Head injury days only.
Head injury. How much is taken by the tribunal?
45%.
Doctor ಹೇಳಿದ್ದು
62% is
62%. Admit ಮಾಡ್ತಾರೆ. Heard admit. Call for TCRs. Issue notice to the respondents. List on
26/11. Seal number 33, P. Suresh.
Royal Sundaram. Royal Sundaram, you are iದ್ರಲ್ಲಿ. Is anybody appearing for Royal Sundaram here? ಇಲ್ವಾ? ನೋಡಿ ಯಾರಿದ್ದಾರೆ? ರವಿಶಂಕರ್ appear ಆಗ್ತಾರೆ. ಯಾರೋ ಒಬ್ರು ಬರ್ತಿದ್ದಾರೆ. ಪ್ರದೀಪ್.
HS Lingraj, Ravi S. Samprati, CR Ravishankar.
ಯಾರು ಬಂದಿದ್ದಾರೆ? ರವಿಶಂಕರ್ ಅವರು ಇಲ್ಲ, ಇವರು ಇಲ್ಲ ಕೊಡೋದಕ್ಕೆ. ಏನಾದ್ರು ಕೊಟ್ಟಿವಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಪಾಟ್ಲಿ ಅಲ್ಲೋಡ್ ಆಗಿದೆ. ಶ್ರೀ ರವಿ
CR Ravishankar.
ಶ್ರೀ ರವಿಶಂಕರ್ letter standing counsel for respondent number 1 ಇದ್ರು. Respondent number 1 is requested to accept notice for respondent number 1. ಉಳಿದಿದ್ದೆಲ್ಲ ಬರ್ಕೊಂಡು his name shall be shown ಅಂತ. Admit call for TCRs. Yes. Issue notice to respondent number emergency notice. Notice ಮಾಡಬೇಕು. List on
26/11.
26.
Seal number 34, Syed Abdul Sabur.
I am for appellant in this case, my lord. It's a case of injury, my lord. The doctor assessed 52% disability, but the tribunal has granted only 17%.
How much is considered?
17%.
70%. ಯಾರು ಇನ್ಶೂರರ್ ಯಾರು? ಲಿಬರ್ಟಿ ಯಾರಿದ್ದಾರೆ?
Liberty General Insurance.
ಲಿಬರ್ಟಿಗೆ ಯಾರಿದ್ದಾರೆ? ಇದಾರ? ಇದ್ರಲ್ಲಿ ಯಾರೋ ಒಬ್ರು ಇಷ್ಟೇ ಇದ್ದಾರೆ, ಲಿಬರ್ಟಿಗೆ ಜಾಸ್ತಿ ಇಲ್ಲ. ಅಲ್ಲಿಲ್ವಾ? 1 or 2 ಅಷ್ಟೇ. ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ? ಶ್ರೀ ಬಿ ಪ್ರದೀಪ್, ಲೆರ್ನರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದೆಲ್ಲ ಬರ್ದಿದ್ದು. What about respondent number 1? Notice ಹೋಗ್ಬೇಕಾ?
Maybe dispense with because liabilities on R2, my lord.
They have not challenged it.
No.
Now counsel for the appeal seeks dispensation of notice to respondent 1. You file the memo in the registry. Is
Yes, madam.
permitted to file the memo in the registry for the same. Record show that under the impugned award liability is fastened to respondent number 2. The insurer satisfy ಮಾಡಿದಾರಾ?
It's a recent, I am not verified.
Therefore, notice to respondent number 1 is dispensed with as paid for. Admit call for TCRs. List on the 6 weeks bit of extra.
212. Cell number 35, M. Venkatesh.
My lord. Insurers appeal, my lord. Case of death, my lord. Will on liability issue, my lord. Tractor and trailer dashed against the auto rickshaw, caused the death of Ramanjanelu. Here in this case, my lord, only tractor exhibit R2 have produced or examined the officer. Tractor is only insured. Trailer is uninsured. Trailer is attached to the tractor, my lord.
You have to deposit 50%.
Please, ma'am. As per.
Admit call for TCRs. Issue notice to the respondents. Interim stay of execution of the impugned award. Till further orders, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the
Please, ma'am.
receipt of the copy of
May be
this
kept
order.
in deposit, my lord. May be kept in deposit, my lord. This is about 32 lakhs.
ಮಾಡಿ ಮೊದಲು
Martin so.
payment list on
212.
okay.
Cell number 36, Bhanuprakash HV.
Case of injury, 40% disability ಇದೆ. Tribunal has taken the 10% only.
How much doctor has spoken? Doctor ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
40 ಹೇಳಿದೆ.
40 to the whole body or to the particular limb?
Particular ಇದಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ.
Particular limb ಆದ್ರೆ ಮತ್ತೆ ಅದೇ ಬಿಡು. Division ಇದೆ ರಹೇಜಾ QB ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. ಯಾರು ಇದ್ದಂಗೆ ಕಾಣೋದಿಲ್ಲ ಇದು. ನಮ್ಮ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇದ್ದಾಗಿಲ್ಲ ಇದು.
ನೋಟಿಸ್ ಮಾಡಿ.
This is from which place?
ಇಲ್ಲೇ ಕನಿಂಗ್ಯಾಮ್ ರೋಡ್ ಅಲ್ಲಿ ಇದೆ. ಆನೆ ಪರಸ.
ಮೈಸೂರು.
ಕನಿಂಗ್ಯಾಮ್ ರೋಡ್ ಬೆಂಗಳೂರು.
Hard admit call for TCRs. Issue notice to the respondents. List on
2611. Cell number 37, B. Pradeep.
Challenging negligence and quantum. The deceased was came from the wrong side of the road, madam, and dashed against the car.
Negligence and quantum.
Yes, ma'am. There are 12 of the judgment. The spot sketch and its translated copy of at exhibit P5 and P5A reveals that state of affairs of the.
Negligence, you say he himself was negligence?
Yes, ma'am. He came from the wrong side and dashed against the car, madam, instead of car.
Deposit ಮಾಡಬೇಕಾಗುತ್ತೆ ಅದಕ್ಕೆ. How much is awarded? 78 lakhs 82,050.
1 crore awarded 1 crore 5 lakh 9,000.
On the head of ಎಷ್ಟು
75-25 ಮಾಡಿದ. 75-25 negligence ಮಾಡಿದ.
Contributory negligence, whether the tribunal has taken contributory negligence.
Yes, madam.
Where do we find that?
There are 12 of the judgment.
There are 12. You say he was totally negligent?
Yes, ma'am. He came from the wrong side. 25% against the deceased, ma'am.
It's of Rodas 22. Check ಆಗ್ತಾ ಇದೆಲ್ಲ. Judgment ಇರೋದಿಲ್ಲ. This is the car. 28. Apportionment. Discussion. Sketch ಅದೆಲ್ಲ ನೋಡಿ ಮಾಡಿದ್ರು. Negligence 25%. ಸೊ ನಿಮ್ ಲಯಬಿಲಿಟಿ ಎಷ್ಟು ಬರುತ್ತೆ ಅದರಲ್ಲಿ 75% ಅಂದ್ರೆ ಅದರದ್ದು 50% ಡೆಪಾಸಿಟ್ ಮಾಡಿ. Admit call for TCS, issue notice to the respondents, interim stay of execution of the impugned award, till further order subject to appellant depositing 50% of
78 lakh.
its liability under the impugned award within 4 weeks from the date of the reciprocal copy of this order. Okay, IA 2024 is disposed of accordingly. Earlier cases allo IA disposed ಅಂತ ಹೇಳಿಲ್ಲ, ಅದನ್ನ ಮಾಡ್ಕೊಳ್ತೀನಿ. List on
212. Cell number 38, HC Vishwendraya.
Filled by the insurance company, my lord, on the ground of liability, there is no permit, and also the quantum negligence on 3 grounds, my lord.
Which are the vehicles involved? Negligence of the
48 lakhs has been awarded, even though you are with evidence.
he was riding motorcycle.
Yes, my lord.
Insured vehicle is car. Charge sheet was filed against whom?
Charge sheet was filed against the insurance company.
We have examined
Yes, my lord.
car driver.
Even though owner has appeared before the court, he has not produced the permit.
He has not produced.
The permit.
Has not. Oh, adu ground ತಗೊಂಡಿದ್ದೀರಾ?
Yes, my lord. And also negligence. 3 vehicles are involved.
Prashant NG and Ramachandra. Who were these RW1 and RW2? Driver of the car is also examined.
Yes, my lord.
Examine ಮಾಡಿದಾರಾ?
Now examine, we are examined, my lord.
Not admit call for TCS. Issue notice to the respondents. Interim stay of execution of the impugned award. Subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of the copy of this order. IA 1 of 2024 is disposed of accordingly. List on
212.
212.
Much obliged.
Cell number 39, Nayak Krishna Venkatraman.
Claimants appeal for enhancement, case of death, my lord.
On what ground?
My lord, ground, my lord, no DL, insurance company not liable, exoneration of the insurance company, my lord. Owner is liability is owner of the vehicle, my lord.
Against respond number 1 is dismissed.
Yes, my lord.
Respond number 1 was
Respond number 1 is the insurance company, SBI. SBI insurance company, my lord. Respond number 2 is the owner of the vehicle, my lord.
delay ಇದೆಲ್ಲ.
Delay ಇಲ್ಲ.
SBI ನಮ್ಮಲ್ಲಿ ಇದೆ list.
SBI Ravi S. Samprati, B. Pradeep.
B. Pradeep.
Sharanappa Gowda, Mali Patil.
ಶರಣಪ್ಪ ಗೌಡ ಮಾಲಿಪಾಟೀಲ್ ಬರ್ತಿರ್ತಾರಲ್ಲ, ಮಾಲಿಪಾಟೀಲ್ ಬರ್ತಿರ್ತಾರೆ. ಮಾಲಿಪಾಟೀಲ್ ಬರ್ತಿರ್ತಾರಲ್ಲ. ಸರ್ದ ಕಾಪಿ ಅಂಡ್ ಮಾಲಿಪಾಟೀಲ್.
Please, madam.
ಶರಣಪ್ಪ ಗೌಡ ಅನ್ನೋರು ಬಂದಿದ್ದು ನಾನು ನೋಡಿದ್ದೇನೆ.
ಬರ್ತಾರೆ ಸ್ವಾಮಿ.
ಬರ್ತಾರ?
ಹೌದು.
ಒಂದೇ ಹೆಸರು ಶರಣಪ್ಪ ಗೌಡ.
ಶರಣಪ್ಪ ಗೌಡ ಮಾಲಿಪಾಟೀಲ್.
ಶರಣಪ್ಪ ಗೌಡ ಮಲಿ ಪಾಟೀಲ್.
ಒಬ್ಬೊಬ್ರಿಗೆ ಒಂದೊಂದು ಕೊಡೋಣ.
Please.
ಶ್ರೀ ಶರಣಪ್ಪ ಗೌಡ ಮಾಲಿಪಾಟೀಲ್. ಮಾಲಿಪಾಟೀಲ್. Nurse standing counsel for respond number 1 is requested to accept notice for respond number 1. ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ಡಿಲೇ ಇದು ಅಲ್ಲ ಇದರಲ್ಲಿ?
ಇಲ್ಲ ಡಿಲೇ ಇಲ್ಲ.
ಇದೆ.
ಅಡ್ಮಿಷನ್ ಅಲ್ಲ.
ಅಪ್ಲಿಕೇಶನ್
ಇನ್ ಟೈಮ್ ಇದೆ ಸ್ವಾಮಿ.
ಓ ಇದು ಗ್ಯಾಸ್ ಸ್ಟೇಷನ್
ಹೌದು.
ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ
ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಮೇಡಮ್.
ಒನ್ ಆಫ್
ಅಪೀಲ್ ಇಸ್ ಇನ್ ಟೈಮ್ ಮೇಡಮ್.
ಓಕೆ ಹಾಗಾದ್ರೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಿ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCS ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ಆನ್
2611. Cell number 40, Nagaraja M.
Hearing for the appellant, the claimants are the case of death, my lord. Claimants are the brothers and sister of the deceased.
36, 35. What was the age of the deceased?
My lord,
What was the age of the deceased?
40 years.
ಅವ್ರ ಹೆಂಗ್ ಡಿಪೆಂಡೆನ್ಸ್ ಆಗ್ತಾರೆ? ಏನ್ ಮಾಡಿದಾರೆ? ವಾಟ್ ಇಸ್ ದ ಫಂಡಿಂಗ್ ಆಫ್ ದ ಟ್ರಿಬ್ಯುನಲ್?
40,000 was granted
40,000.
towards
ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅದೆಲ್ಲ
ಹಾ.
ಕೊಟ್ಟಿರ್ಬೇಕು. ಕನ್ಸೋರ್ಷಿಯಂ ಇಲ್ಲ, ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಅದು ಕೊಟ್ಟಿದ್ದು ಜಾಸ್ತಿ.
Loss of estate and transportation of dead body. No other heads were granted.
ಕರೆಕ್ಟ್, ಇವರೆಲ್ಲ ದೇರ್ ಆಲ್
Brother and sisters, brothers and sister of the deceased.
he was unmarried.
He was unmarried.
ಏನ್
He
ಹಾಕಿದ್ರು?
is a physically challenged person.
ಮತ್ತೆ
And he was, not to that extent, but he was under the care and custody of the first appellant. And yeah, apart from that, he was assisting the family and earning some amount.
ಎಸ್ಟೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಅವ್ನ ಇನ್ಕಮ್ ಏನಕ್ಕೆ ಅಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ಮಲ್ ಅಷ್ಟೇ. ಯಾರು ಹೂ ಇಸ್ ದ ಇನ್ಶೂರರ್?
ಟಾಟಾ
Tata AG.
ಪ್ರದೀಪ್ ಇದ್ದಾರೆ, ಮತ್ತೆ ಯಾರು?
ರವಿ ಸಂಪ್ರತಿ, ಓ ಮಹೇಶ್, ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ, ರವಿ ಸಂಪ್ರತಿ, ಎಚ್ ಎಸ್ ನಿಂಗರಾಜು, ಜನಾರ್ದನ್ ರೆಡ್ಡಿ.
ಇದು ಯಾರು ಕಾಣ್ತಿಲ್ಲ ಇನ್ನು, ಅವ್ರು ಯಾರು? ಯಾರಿಗೆ? ರವಿ ಸಂಪ್ರತಿ ಅವ್ರಿಗೆ ಕೊಡೋಣ. ರವಿ ಸಂಪ್ರತಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ.
Please, I have sought for dispensation of notice to.
Accept notice correspondable ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ಮ್ಯಾನೇಜರ್ ಅವ್ರೇನು ಕಾಂಟೆಸ್ಟೇ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿ ಅವರು ಏನಿಲ್ಲ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರ ಅವರು? ರೆಸ್ಪಾಂಡ್ ಟು ಅಲ್ಲ, ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಡ್ಯೂ ಸರ್ವಿಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 and 2 appeared through their respective counsel, but respond number 1 filed separate written statement. Under the impugned award, the liability is fastened to respond number 2. I'm sorry, respond number 1, the insurer. Therefore, notice to respondent number 2 is dispensed with as paid for. Admit call for TCS. ರವಿ ಸಂಪ್ರತಿ ಅವ್ರು ನಿಮ್ಗೆ ಇದ್ರೊಳಗೆ ನೋಟಿಸ್ ತಗೊಳಕ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ನೋಡಿ, ಯಾವ್ದು? ಇನ್ಶೂರೆನ್ಸ್ ಟಾಟಾ ಏಜ್.
For further hearing, seal number 41, Ganesha R, C.R. Ravishankar.
ಎರಡು ಇದಾವಲ್ವಾ, ಒಂದು ಇನ್ಶೂರೆನ್ಸ್ these appeals are filed. These appeals are filed challenging the judgment and award in MEC number 6 of 2019, passed by the additional motor accidents claims tribunal and principal senior civil judge Udupi. The appellants in MFA number 6175, the appellant in MFA number 6175/2021 was the sole claimant, and response 1 and 2 in the said case were response 1 and 2 in MEC number 6 of 2019. For the purpose of convenience, the parties are referred to henceforth according to the ranks before the tribunal. On 16/7/2018, at about 1 PM, when claimant was claimant was standing on the footpath on the pavement himself. According to the claimant, on 16/7/2018 at 1 PM, when he was standing on the pavement on the pavement of NH 66 Karavali bypass road, lorry bearing number K19 AB 6086 hit him. Hit him and caused him grievous injuries. The claimant was shifted to District Hospital Udupi. And thereafter he was treated in Venlock Hospital, Mangalore. he underwent certain surgeries. And his knee, his right leg below knee was amputated. Third of right tibia. ಎರಡಾಗಿದೆ amputations. ಬದಲು ಒಂದು ಮಾಡಿರ್ತಾರೆ, ಅದು ಇನ್ಫೆಕ್ಷನ್ ಆಗಿ ಮಾಡ್ತಾರೆ. The claimants filed MVC number 6 of claimant filed MVC number 6 of 2019, claiming compensation of 36,09,000. Claimants filed ಅಂತ at the time of the accident, respond number 1 and 2 were the registered owner and insurer of lorry number K19 AB 6086. Working as a coolie and earning rupees 7,000 per day. And due to personal permanent physical disability, he has suffered loss of future earnings, amenities, and pain and suffering, pain, etc. He claimed that the respondents are jointly and severally liable to pay this said compensation. First respondent had not contested before the tribunal. Respondent number 1 did not contest. He got marked exhibit P1 to P19. Damu Narayan Nayak. Insurance company. On behalf of respondent number 2, the insurer, the driver of lorry number, the driver of lorry in question. K19 AB 6086 was examined as RW1 and the insurance policy was marked as exhibit R1. The tribunal, on hearing the parties by the impugned award, held that the accident occurred solely due to the actionable negligence on the part of the driver of the lorry. The tribunal, relying on the evidence of PW2 assessed 80% or 79% ತಗೊಂಡಿದ್ರು. The permanent physical disability of the claimant at 79%. 79 ತಗೊಂಡಿಲ್ಲ. ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರು ಕಡಿಮೆ ಮಾಡಿದ್ರ ಏನೋ 70% ಡಿಸಬಿಲಿಟಿ ಅಂತ ಅವ್ರು 70 ಅಂತ ಹೇಳ್ತಾರೆ 79 ಅಲ್ಲ ನಾವು 80 ತಗೊಂಡು ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಅಂತ. Therefore, disability is to be considered at 100%. The tribunal consider the permanent disability at 100%. 100%. The income of the claimant was notionally considered at rupees 10,000 per month. Applied 13 multiplier and awarded compensation of rupees 15,60,000 on the head of loss of future earnings. The tribunal in all awarded compensation of rupees 19,04,703 on different heads as follows. Again, page number 22 number. Questioning the adequacy of the compensation. Claimant has preferred MF number 6175 of 2021. Questioning the findings of the tribunal regarding negligence and negligence, permanent physical disability and quantum of compensation. The insurer has preferred MFA number 4856 of 2020.
6178.
ಎಷ್ಟು 100% ಅವ್ರಿಗೆ ತಗೊಂಡಿದ್ದಾರೆ. There is no issue.
ಅದಕ್ಕೆ that's why questioning the
ನಾನು consider she so and so ನಾನು consider the claimant. ಅವ್ರ ಪ್ರಕಾರ ಇದು ನೋಷನಲ್ ಇನ್ಕಮ್ ತಪ್ಪು ಅಂತನಾ 2000 ಎಷ್ಟು 2018
12,000.
This one is non concept for the claimant. Challenges the award on the ground that the notional income of the claimant considered by the tribunal is on the lower side. ಮತ್ತೆ ಯಾವ್ದಾದ್ರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ರು. ಇದರಲ್ಲಿ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. He submits that the tribunal ought to have added future prospects to the income of the claimant in assessing the loss of earning capacity and awarded compensation on the head of loss of income during the laid up period. He further submits that the compensation awarded on the other heads is also the lower side. Per contrast, Shri Ravi Shankar in our initial order for the insurer submits that the evidence of RW1 and
driver
charge sheet ಅಲ್ಲಿ ಅವ್ರ ಮೇಲೆ ಅಷ್ಟೇ ಆಗಿದೆ ಅಲ್ವಾ?
ಹೌದು.
and the other material on
pedestrian ಮೇಲೆ ಮಾಡಕ್ ಮಾಡಿಲ್ಲ.
The claimant himself was negligently crossing the road
without observing the traffic.
Abruptly crossing the road and that has led to the accident. Therefore, the finding of the tribunal regarding negligence is unsustainable. He further submits that despite the PW2 assessing the disability at 76%, 76%, the tribunal has taken the same at 100%, which is erroneous. He questions the award. He questions the compensation awarded on the other heads also. Next one. Considering the submission of both side and on examining the material on record, the questions that arise for determination of this court are: number one, whether the finding of the trial tribunal that the accident occurred due to actionable negligence of driver of lorry number KA 19 AB 6086 is sustainable. Number two, whether the compensation awarded to the claimant is just one. Next one. The insurer also does not dispute that on 16/7/2018 at 1 p.m. 1 p.m. near Karavali bypass road, by the side of Karavali bypass road, within the limits of the Java police station, exhibit P1, within the limits of Udupi traffic police station. The claimant was hit by lorry number KA 19 AB 6086. And the said lorry was insured with respondent number 2. Respondent number 2. However, the only contention is that claimant himself abruptly crossed the road without following, without exercising due diligence. Therefore, he himself was responsible for the accident. The records, evidence of PW1 and exhibit P1 to P6 shows that soon after the accident, AB Nagaraj, complainant, he himself is claimant. Statement was recorded in the hospital, no?
Yes.
And the information, the SHO of Enta police station is Sanchar, Kannadadalli barದದ್ದು. Udupi traffic police station visited district hospital ಅಲ್ಲ ಅದು?
Yes.
ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ. Visited district hospital Udupi, where the claimant was first treated, and recorded his statement as per exhibit P. As per exhibit record statement and the part of statement. Based on the said statement, he registered a FIR as per exhibit P1 against RW1, the driver of the lorry, in crime number 70 of 2018 of their police station. The aforesaid records further show that on investigation, Udupi traffic police filed charge sheet exhibit P6. Charge sheet as per exhibit P6 against RW1, alleging that when a claimant was standing on the footpath, RW1 drove the lorry in rash and negligent manner and hit the claimant, causing him grievous injuries, and laid the charge sheet for the offence punishable under section 279 and 338 IPC. Though RW1 in his chief examination contended that a bus was parked in front of his lorry, which was in motion, and claimant suddenly crossed the road, crossed the service road, which led to the accident. And ಎಲ್ಲೋ ನಂಗೆ ಬಿಡುಗಡೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇದು ಅಕ್ವಿಟಲ್ ಆಗಿದೆ ಅಂತ ಏನೋ ಹೇಳ್ದಂಗೆ ಇಲ್ಲಿದೆ ಹೇಳಿದೆ ನೋಡಿ ಇಲ್ಲ ಹೇಳಿದೆ and he was acquitted in the criminal case. In the cross examination he himself admits that the accident took place on the edge of the footpath. ಅವರೇ ಹಿಡ್ಕೊಂಡಿದ್ದಾರೆ. The response did not produce any record to show that RW1 was acquitted on trial in the criminal case. RW1 admits that no copy of such judgment is produced. He admits filing of charge sheet against him. If really RW1 was acquitted, was honorably acquitted, there was no reason for the respondents to suppress such judgment. Further, in the eyewitness exam, PW1/claimant is the injured eyewitness. His evidence stands on higher pedestal. That was further corroborated by the evidence by Exhibit P charge sheet. Exhibit P6 charge sheet. Spot sketch. Spot sketch. Exhibit P2. The spot measure, which is annexed with spot sketch, show that the accident has taken place on the border of the footpath. On the edge of the footpath. On the edge of the footpath. Okay. The driver of lorry had no reason to hit to the footpath. Such evidence falsified the contention of respondent number 2 and RW1 that the claimant abruptly crossed the road and he was responsible for the accident. The tribunal on sound appreciation of the evidence has arrived at the conclusion that the accident occurred solely due to the actionable negligence on the part of driver of lorry. Therefore, there are no grounds to interfere with the same. Next, point number 1. Point number 1 of the analysis regarding quantum. Regarding quantum. The evidence of PW1 and 2 and medical records show that at the time of the accident, claimant was aged medical 46 years ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದರಲ್ಲಿ FIR ನಲ್ಲಿ 46 ಅಂತ ಇದೆ. ಚೇಂಜ್ ಆಗುತ್ತಲ್ಲ
46 ವರ್ಷ.
46 ವರ್ಷ.
46 ಗೂ 13 ಬರೋದು.
46 ಗೂ 13. As aged 46 years. 46 years. ಇನ್ನದೇನ ಇಂಜುರೀಸ್ ಹೇಳಿದ್ವಲ್ಲ, ಕ್ರಶ್ ಇಂಜುರಿ ಆಫ್ ದ ರೈಟ್ ಫೀಟ್. ಎಕ್ಸಿಬಿಟ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2 ಅಂಡ್ ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು ಜಾಸ್ತಿ ಇದಾವೆ. ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ ಎಕ್ಸಿಬಿಟ್ P10. ಎಕ್ಸಿಬಿಟ್ P10 ಅಲ್ಲ ಎಷ್ಟು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದೆ. ಎಕ್ಸಿಬಿಟ್ P10 to P13, 10 to 13, 17. Then additional case sheet andre 17 and 19. 17 and 19. What is that, 19 additional seat ಅಂತ ಇದೆ ಅಲ್ಲ? P17 is ಕಸ್ತೂರ್ಬಾ ಅಡಿಷನಲ್ ಅಂತ ಯಾಕೆ ಹಾಕಿದ್ರು? 17 ಅಂತ. ಇನ್ನು ಹಾಕ್ತಾ ಇತ್ತು ನಾವು ಹೊಡಿಸ್ಕೊಂಡು ಸ್ಟ್ರಿಪ್ಸ್. What is that exhibit P19? Additional,
ಸೆಕೆಂಡ್ ಟೈಮ್ ಆಂಪ್ಯುಟೇಷನ್ ಕಟ್ ಮಾಡಿದಾಗ ಅಡ್ಮಿಟ್ ಆದಾಗ
ಅಲ್ಲ ಅದು ಅಡಿಷನಲ್ ಯಾಕಾಗುತ್ತೆ? ಅಡಿಷನಲ್ ಆಗೋದಿಲ್ವಲ್ಲ ಹಾಗಿದ್ರೆ?
ಹಾಸ್ಪಿಟ್ಲರ್ ಕೊಟ್ಟಿರ್ಬೇಕು.
6 ಅಲ್ಲ ಅದಕ್ಕೆ ಅದು ಸ್ವಲ್ಪ ನಾನು ಹೇಗಿದ್ರು ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದ್ದಿರ್ತಿದೆ ಅಲ್ಲ ಡಾಕ್ಟರ್. ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಬೈ PW2 ನಾ ಇದು? P19 ಆರ್ಥೋಪೊಡಿಕ್ಸ್ ಅದೇನು ಔಟ್ ಪೇಷಂಟ್ ರೆಕಾರ್ಡ್ ಅದು, ನಾಟ್ ಅಡಿಷನಲ್. ಇಲ್ಲ ಕಸ್ತೂರ್ಬಾ ಹಾಸ್ಪಿಟ್ಲೇ ಆದ್ರೆ ಔಟ್ ಪೇಷಂಟ್ ರೆಕಾರ್ಡ್ ಅಂತ ಇದೆ.
ಅದು ವಿಸಿಟಿಗೆ ಹೋದಾಗ ಕೇಸ್ ಶೀಟ್
ಅಡಿಷನಲ್ ಅಂತ ಕೇಸ್ ಶೀಟ್ ಅಂತ ಯಾಕೆ ಬರ್ಕೊಂಡು? ಫಾಲೋ ಅಪ್ ಹೋಗಿರ್ತಾರಲ್ಲ. ದಿಸ್ ವಾಸ್ ಡೇಟೆಡ್ 16/10/2019. ಆಕ್ಸಿಡೆಂಟ್ ಡೇಟ್ 16/7/2018 ಅಲ್ಲ? And 29/19, that is outpatient record of Venlock Hospital, Mangalore, discharge summary, medical certificate, P17, disability certificate, case sheet, OPD receipts, etc. show that in the accident, certificate after the accident, soon after the accident, claimant was shifted to district hospital Udupi. ಅಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಹೋಗ್ತಾರೆ?
ವೆನ್ಲಾಕ್ ಹಾಸ್ಪಿಟಲ್.
ಅಲ್ಲ ಎಷ್ಟು ದಿವಸ ಇದೆ ಅವ್ರದ್ದು ಇದು ಆಗಿದ್ದ? PW2 ಡಾಕ್ಟರ್. PW2 ಇವ್ರು ಎಲ್ಲಿ ಯಾವ ಹಾಸ್ಪಿಟಲ್ ಅವರು? ಇವರು ಅಲ್ಲ ಕಸ್ತೂರ್ಬಾ ಹಾಸ್ಪಿಟಲ್. ಅಲ್ಲ ಮೊದಲು ಇದ್ರಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ ಮಾಡ್ತಾರಲ್ವಾ?
ಫಸ್ಟ್ ವೆನ್ಲಾಕ್ ಹಾಸ್ಪಿಟಲ್ ಮಂಗಳೂರಿಗೆ ಅಡ್ಮಿಟ್ ಆಗ್ತಾರೆ, ಆಮೇಲೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್
ಉಡುಪಿ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ.
Accident, soon after the accident, he was taken to Udupi District Hospital, Udupi. Allinda he was shifted to Venlock Hospital.
Yes.
So, soon after the accident, the victim was admitted in District Hospital, Udupi. Alle 15 ದಿವಸ ಇರ್ತಾರೆ ಅವರು.
ಹೌದು.
And he was treated in the said hospital as inpatient for 15 days. Thereafter, Ali, after those, he suffered septicemia. Manipal Ali for a period of 1 month. Manipal hospital or examine ಮಾಡಿದ್ರು. ಇದೇನಾ ಕಸ್ತೂರ್ಬಾ?
PW2 ಡಾಕ್ಟರ್ ಅವರೇ ಕೊಟ್ಟಿದ್ರು.
4/8/2018 to 16/7/2018 ವರ್ಗನಾ?
Yes.
Thereafter, he was treated in Kasturba Hospital, Manipal, between 4/8/2000 as inpatient between 4/8/2018 and 16/7/2018. The above evidence further shows that initially the victim claimant had suffered. ಇವ್ರದ್ದು ಇನ್ನೊಂದು wound certificate ಎಲ್ಲಿದೆ? It was not the direct cause. Wound certificate produce ಮಾಡಿದೀರಾ?
ಇದೆ.
P3 ಕೊಟ್ಟಿದ್ದೇನೆ.
Exhibit P3.
ಇದು ಡಿಗ್ಲೋವಿಂಗ್ ಇಂಜುರಿ. ಕಸ್ತೂರ್ಬಾ ಹಾಸ್ಪಿಟಲ್ ಅದು ಇಂಜುರಿ ಇಷ್ಟೇ ಆಗಿತ್ತು, ಸೆಕೆಂಡರಿ ಇನ್ಫೆಕ್ಷನ್ ಆಯ್ತು. ಫೌಂಡ್ ಆನ್ ದ ಪರ್ಸನ್. ಇದು ಯಾವತ್ತಿಂದ ಇದು ಡೇಟು 18/9/2018. ಫಸ್ಟ್ ಟ್ರೀಟೆಡ್ ಹಾಸ್ಪಿಟಲ್ ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಉಣ್ ಸರ್ಟಿಫಿಕೇಟ್. ಮಣಿಪಾಲ್ ಉಡುಪಿ ಹಾಸ್ಪಿಟಲ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
ಅದು ಮಣಿಪಾಲ್ದು KMC ಹಾಸ್ಪಿಟಲ್.
ಇದು ಬಿಕಾಸ್ ಈ ಸಫರ್ಡ್ ಇನ್ಫೆಕ್ಷನ್, ಆಮೇಲೆ ಮತ್ತೆ ಆಂಪಿಟೇಷನ್ ಎಲ್ಲ ಮಾಡ್ಬೇಕಾಯ್ತು.
ಎಸ್.
ಇನಿಷಿಯಲ್ ಇಂಜುರೀಸ್ ಏನಿತ್ತು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಅದ್ರ ಕೊಟ್ಟಿಲ್ಲ ನೀವು. ಡಿಗ್ಲೋವಿಂಗ್ ಇಂಜುರಿ ಆಫ್ ದ ರೈಟ್ ಆಂಕಲ್ ಅಂತ ಕ್ರಶ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಕ್ರಶ್ ಇಂಜುರಿ ಅಂತ. ಇದು ಅವತ್ತು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾಗ ಇಲ್ಲ ಸರಿ ಕರೆಕ್ಟ್, ಎಲ್ಲ ಒಂದು ಇದನ್ನ ಹಾಕಿದ್ದಾರೆ ಅವರು ಅಲ್ಲಿ ನೋಡಿ. ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಇದ್ರದ್ದು ಇಲ್ಲ ಫಸ್ಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲ ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಆಮೇಲೆ ಕೊಡ್ತಾರೆ. ಫಸ್ಟ್ ಹಾಸ್ಪಿಟಲ್ ಮೆಡಿಕಲ್ ಇದ್ರದ್ದು ಡಿಸ್ಚಾರ್ಜ್ ಡಿಗ್ಲೋ ಇಂಜುರಿ ಕಸ್ತೂರ್ಬಾ ಹಾಸ್ಪಿಟಲ್ 31/8/2018. ಎಷ್ಟು ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಹಾಕಿದಿರಿ ಹೇಳಿ?
ಒಂದೇ
ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಇಲ್ಲ, ಎಕ್ಸಿಬಿಟ್ P11 ಇಸ್ ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ. P10 ಔಟ್ ಪೇಷಂಟ್ ರೆಕಾರ್ಡ್ ಆಫ್ ಎನ್ಲಾಕ್ ಹಾಸ್ಪಿಟಲ್ P10 ಅಲ್ಲಿ ಬರ್ದಿರ್ತಾರೆ ಅವ್ರಿಗೆ ಏನ್ ಇಂಜುರಿ ಅಂತ. P10 ಕ್ರಶ್ ಇಂಜುರಿ ಆಗಿದೆ ಅಂತ ಬರ್ದಿದ್ರು. ಇಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ. ಒಟ್ಟು ಒಂದು ಬಂಡಲ್ ತಂದು ಹಾಕ್ಬಿಟ್ರೆ ನೀವೇ ಹುಡುಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ಅದನ್ನೇ ಮಾಡೋದು. MSc ಕೇಸಲ್ಲಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಯಾವ್ದು ಕೊಡಬೇಕು ಅಂತ ಇಲ್ಲ, ಮೆಡಿಕಲ್ ರಿಸರ್ಚ್ ಎಷ್ಟು ರಿಸರ್ಚ್ ಎಲ್ಲ ಒಂದ್ ಕಡೆ P12 ಅದು ಇವ್ರು ಕೊಟ್ಟಿದ್ವಿ ಎನ್ಲಾಕ್ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರವ್ರು. ಇದೆಲ್ಲ ಬಿಲ್ಸ್ ಆಯ್ತು. P12 ಒಂದು ನಿಮಿಷ ಇಲ್ಲ, ಇದು ಚಾರ್ಜ್ ಶೀಟ್ P6 is ಚಾರ್ಜ್ ಶೀಟ್. P12 P17 admission record custody. Degloving injury ಎಲ್ಲಿದೆ ಇದೆಷ್ಟು ಎಕ್ಸಿಬಿಟ್ P15 ಅದು. ಇದ್ರಲ್ಲಿ ನಮಗೆ ಹುಡುಕೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. P9 P11 Kasturba Hospital. Right, it's secondary infection. It's true. Disability certificate is P13. P12 ಇದೇ ಇರ್ಬೇಕು. P12 ಇಲ್ಲಿದೆ ನೋಡಿ. ನನ್ನ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾರು ಇಶ್ಯೂ ಮಾಡಿರೋದು? ಇದು ಕಸ್ತೂರ್ಬಾ ಹಾಸ್ಪಿಟಲ್. ಸಫರಿಂಗ್ ಫ್ರಮ್ amputation. ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ he had suffered crush injury ಅಂತ. somewhere yesterday we have seen he had suffered crush injury ಅಂತ ಇದೆ. ಅದು ಎಲ್ಲಿದೆ ಅಂತ ಹುಡುಕಿ ಹೇಳ್ತೀರಾ? ಎವಿಡೆನ್ಸ್ ಗೋ ಬೈ ಎವಿಡೆನ್ಸ್ ಆಫ್ ಏನದು ಎವಿಡೆನ್ಸ್ ಆಫ್ degloving injury of right ankle and crush injury in the ankle and the crush injury ಇಲ್ಲ ಬಂದಿದೆ ಅದು. The medical evidence further show that the claimants developed some complication due to infection of the injury. And ultimately, on 7/8/2018, his right leg below knee was amputated. And on 10/8/2018, there was a revision of amputation. In all, he was treated as 54 days, huh?
54 days.
54 days as inpatient in district hospital Udupi and Kasturba hospital Manipal. ಅದು ವೆನ್ಲಾಕ್ ಹಾಸ್ಪಿಟಲ್ ಅಂದ್ರೆ ಒಂದೇ
ಕಸ್ತೂರಿಬಾ ಒಂದೇ ಇರೋದು, ಅವ್ರದ್ದು 54 ದಿವಸ ಬರಲ್ಲ ಅವಾಗ.
ವೆನ್ಲಾಕ್ ಹಾಸ್ಪಿಟಲ್ ಅಂತ.
ವೆನ್ಲಾಕ್ 54 ದಿನ ಬರಲ್ಲ ಅದು.
ಅಲ್ಲ ಕಸ್ತೂರ್ಬಾ
ಟೋಟಲ್ ಎಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ಸೇರಿ 54 ದಿನ.
ಟೋಟಲ್ ಹಾಸ್ಪಿಟಲ್
ಹೌದು.
ಟೋಟಲ್ ಪೀರಿಯಡ್. ಇಲ್ಲಿ ಫಸ್ಟ್ he was examined on 4/8/2018. ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು ಇಲ್ಲ ಅದು 16/7 ಅಲ್ಲಿ ಫಸ್ಟ್ ಮಣಿಪಾಲ್. ಅದೇ ನಾವ್ ಹೇಳಿದ್ವಲ್ಲ, ಅವ್ರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಅವರನ್ನ, ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ಗೆ ಕಾಣ್ತಾ ಇಲ್ಲ ಹಾಸ್ಪಿಟಲೈಸ್ ಅಂತ. ಬಟ್ ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ 7/8/2018 to
37.
He was in hospital from 7/8/2018 to 3/9/2018. Discharge ಮಾಡ್ತಾರೆ ಅವಾಗ. Again he was treated thereafter. 10 ಮತ್ತೊಂದ್ಸರಿ
30 days ಆಯ್ತು.
ಕಡಿಮೆ ಆಗುತ್ತೆ ಅಂತೀರಾ ಎಲ್ಲ?
54 days ಯಾಕಂದ್ರೆ there is no records.
ಆಗ್ಬೇಕಂದ್ರೆ ಎರಡು ಸರ್ಜರಿ ಅಲ್ಲಲ್ಲ. He was admitted in the hospital earlier in Udupi.
Correct.
ಅದಕ್ಕೆ ಅವ್ರು ಎವಿಡೆನ್ಸ್ ಹಾಕಿಲ್ಲ. ಹೌದು, what you are saying is correct. But can we deny that he had not?
ಅಲ್ಲ, not because ಅದು ಕಡಿಮೆ, at least it will be burden should be
ಉಡುಪಿ ಹಾಸ್ಪಿಟಲ್ 15 ದಿನ ಇದ್ದಾರೆ.
should not be go up.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹಾಸ್ಪಿಟಲ್
ರೆಕಾರ್ಡ್ಸ್ ಇದೆಲ್ಲ ಸುಮ್ಮನೆ ಹೋಗಿ 54 ದಿನ 500 ದಿನ ಹೋಗಿ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಿಸ್?
ಅದನ್ನ ಏನ್ ಹೇಳ್ತಿರೋ ಅದನ್ನ ಒಂದ್ಸಲ.
ಅಲ್ಲ, ನಾನು ನಿಮಗೆ ಅದಕ್ಕೆ ನಿಮಗೆ ಹೇಳ್ಬಿಟ್ರೆ ನಾವು ಕರೆಕ್ಟ್ ಆಗಿರುತ್ತೆ ಅಂತ ನಾನು ಹೇಳ್ಬಿಟ್ಟು.
ನಮಗೂ ಕೇಳಿಸುತ್ತೆ, ತೋರಿಸಿ. ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇದೆ ಅಲ್ಲ,
ರೆಕಾರ್ಡ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ನಾನೇನು
ಇಲ್ಲ ಹೇಳ್ತಿರ್ತಾರೆ. ಯಾವ್ದು ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ರಿ ಹೇಳೋಣ, ಎಕ್ಸಿಬಿಟ್ P11 ಅಲ್ಲಿ ಯಾವ ಪೀರಿಯಡ್ ನಿಂದ ಯಾವ ಪೀರಿಯಡ್ ವರೆಗೆ ಅಂತ ಇರುತ್ತೆ. ಇಲ್ಲಿ ಏನಾಗಿದೆ, ನಮ್ಗೆ ರೆಕಾರ್ಡ್ಸ್ ತೆಗಿಯೋದು ಡಿಫಿಕಲ್ಟ್ ಆಗ್ತದೆ. Date of discharge, date of admission. P11. There are 2 discharge summaries.
Yes.
ಸ್ವಲ್ಪ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಹೇಳ್ತೀನಿ. P11 ಇದೇನಂದ್ರೆ ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್, ಡೇಟ್ ಆಫ್ ಡಿಸ್ಚಾರ್ಜ್. ಅಡ್ಮಿಟೆಡ್ 4/8/2018, ಡಿಸ್ಚಾರ್ಜ್ 39/2018. ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಅಲ್ಲಿ? 30 ಪ್ಲಸ್ ಇಲ್ಲಿಗೆ ಆಗ್ಬಿಡ್ತಲ್ರಿ 4/8 ಅಂದ್ರೆ 30 39. ಅದೇನು ತಿದ್ದಿದ್ದಾರೆ ಇವರು ಕೈಯಿಂದ. ಆದ್ರೆ ಡಾಕ್ಟರ್ ಹೇಳೋದು ಎಷ್ಟು ಹೇಳಿದ್ರು? PW2 ಅದು ಮಾಡ್ತಿದ್ರೆ ಅದನ್ನ ನಾವು
PW2 ಅಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅವರೆಲ್ಲ ಡಾಕ್ಟರ್.
ಬಟ್ ಅವರು
ಬಟ್ ಅಲ್ಲ, because he can't speak about that document because he is not that doctor.
Hospital. He was admitted. He was received on 7/8/2000. 4/8/2000. Operation ಆಗಿ 7/8. Debridement. He was discharged on 3/9. ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು 3/9 ಎಷ್ಟಾಯ್ತು ನಿಮ್ಮಲ್ಲಿ? 4/8 to 3/9 30 days ಆಯ್ತು. ಆಮೇಲೆ ಇನ್ನೊಂದು ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ. ಇನ್ನೊಂದು ಯಾವುದು ಕರೆಕ್ಟ್ ಆಗತ್ತೆ? ಎಷ್ಟು ಇರುತ್ತೆ ಅಷ್ಟೇ ಕೊಡೋಣ. ದಟ್ ಇಸ್ ಇದಕ್ಕೆ ಬರುತ್ತಲ್ಲ, ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಅದೆಲ್ಲ ಬರೋದು ಅದರಲ್ಲಿ ಬರುತ್ತೆ. ಇನ್ನೊಂದು ಎಕ್ಸಿಬಿಟ್ P17 ಅಂತ. P17 ಸ್ವಲ್ಪ ಸ್ಲಿಪ್ ಕೊಡಿ, ಇಲ್ಲ ಮತ್ತೆ ಹಗಲೆಲ್ಲ ಹುಡುಗ. P11 ಈಗ ಹೇಳಿದ್ದು. P11 ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ. ನೀವು ನಮ್ಗೆ ಹೇಳ್ಬೇಕಲ್ರಿ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ ಅಂತ ಹೇಳಿ.
ಹದಿನೈದು ದಿನ ಚೀಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ 15 ದಿನ.
ಅವ್ರು ಹೇಳೋದಲ್ಲ ಯಾವ್ದಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳಿ. ಯು ಶುಡ್ ಹೋಲ್ಡ್ ವಿತ್ ಯು ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ವಿಚ್ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ರೆ ಎಕ್ಸಿಬಿಟ್ P17. P17 admission record ಕಸ್ತೂರ್ಬಾ ಹಾಸ್ಪಿಟಲ್ ಇದೆ ಇದು. ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್ ಇದು 48 ಸೇಮ್ ಹೆಡ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಡಿಸ್ಚಾರ್ಜ್ ಸ್ಟೇಟಸ್ ಇದು ಬಂದಿಲ್ಲ. ಇದು ಅದರದೇ ಪಾರ್ಟ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ. 31/8 ಡಿಗ್ಲೋವಿಂಗ್ ಇಂಜುರಿ ಇದೆ ಫಸ್ಟ್ ಅಡ್ಮಿಷನ್ ಇದೆ 48. ನಿಮ್ಮ ಹತ್ರ ರೆಕಾರ್ಡ್ ಇದೆ ಇವ್ರೆ ರವಿಶಂಕರ್?
ಇಲ್ಲ
ನಿಮ್ಮ ಹತ್ರ ರೆಕಾರ್ಡ್ ಇದೆ, ನೀವಿಬ್ರು ರೆಕಾರ್ಡ್ ಇಟ್ಕೊಂಡಿರೋದಿಲ್ಲ ಇಬ್ರು.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಕಳ್ಸಿಲ್ಲ ಅವ್ರಿಗೆ ಬಿಕಾಸ್ ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್
ಅಲ್ಲ ಎಷ್ಟು
ಪೊಲೀಸ್
ಇಂಪಾರ್ಟೆಂಟ್
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕಳ್ಸಿರ ಅದನ್ನ
ಇಟ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಕರೆಕ್ಟ್ ಇಲ್ಲ ಶಿಪ್ ಬಟ್ ಪೊಲೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆನ್ ದಿ ಟೆಸ್ಟ್ ಆಫ್ ದಿ ಇದ್ರ ಪ್ರಕಾರ ನಾವು ಹೋಗಿದ್ವಿ.
ಅಲ್ಲ ಅದಿಲ್ದೇನೆ ನೋಡಿ ಬೋತ್ ಸೈಡ್ IP ಅಸೆಸ್ಮೆಂಟ್ ಇಲ್ಲಿದೆ ಇನ್ ಪೇಷಂಟ್. ಇದು ಯಾವ ಹಾಸ್ಪಿಟಲ್ ಇದು? ಕಸ್ತೂರ್ಬಾ
P10 ಅಲ್ಲಿ P10
P10 ಅಲ್ಲಿ ಇಲ್ಲ ನಾವು ನೋಡಿದ್ವಿ. ಎಮರ್ಜೆನ್ಸಿ ಮೆಡಿಸಿನ್ ಇಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್ 4/8/2018 ಸೇಮ್. ನಿಮ್ಮ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದು ಒಂದು ಪೀರಿಯಡ್ ಮಾತ್ರ ಹೇಳಿದ್ದಾರೆ ಅವರು 54 ಹೇಳಿಲ್ಲ 54 days ಹೇಳಿಲ್ಲ ಅವರು. ನಿನ್ನೆ ನೀವು on what basis you said that he was hospitalized for 54 days?
on the basis of chief examination of PW1.
ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ನೋಡಿ ಹೇಳ್ಬೇಕಲ್ಲ. ಮತ್ತೆ ನೀನು ಹೆಚ್ಚಿಗೆ ಕೊಡ್ಸಕ್ ಹೊರಟಿದ್ರಲ್ಲ ನಿಮ್ಗೆ ಯು ಶುಡ್ ಪ್ರೂವ್ ಇಟ್.
ಆಂಪ್ಯುಟೇಷನ್ 2 ಸರಿ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರೆ.
ಹೌದ್ರಿ ನಿಮ್ಗೆ ರೆಕಾರ್ಡ್ ತೋರಿಸಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ. 2 ಸರಿ ಅಡ್ಮಿಟ್ ಆಗಿದ್ರು ಅಂತ. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ದ ಡಾಕ್ಟರ್ ಆಫ್ ಉಡುಪಿ ಹಾಸ್ಪಿಟಲ್. ಅವ್ರು he was discharged on 3/9/2018. He was followed on in OPD on 10/10/2018, 24/10/2018 ಹಾಗೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. ಟೋಟಲ್ ಹಾಸ್ಪಿಟಲೈಸೇಷನ್ ಅಲ್ಲಿ ಬಿಟ್ಟರೆ ಬೇರೆ ಹೇಳಿಲ್ಲ. ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಏನಾರ ಅಡ್ಮಿಷನ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದಾರೆ. ನೋ ದೆನ್ ವಿ ಹ್ಯಾವ್ ಟು 30 days ಅಷ್ಟೇ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಅದೆಲ್ಲ. ಏನ್ 54 days ಎಷ್ಟು 30 days as inpatient in Kasturba Hospital, though it was alleged that he was treated as inpatient in Venlock Hospital Udupi for as to 24 days, 15 days. No evidence was deduced regarding the same. The evidence of PW2 shows that the claimant had suffered below knee amputation at the level of upper third of right leg, right tibia, leg of right tibia. Tibiadu ಬೇರೆ ಇದ್ರದ್ದು ಬೇರೆ ಅಲ್ವಾ? ಬಟ್ ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ವೆರಿ ಬ್ಯಾಡ್ಲಿ ಕಂಡಕ್ಟೆಡ್ ಕೇಸ್. The PW2 assessed the disability at 76%. Law counsel for the insurance contends that PW2 was not the treating doctor. Therefore, his evidence regarding disability cannot be taken. However, the fact that claimant was treated in Kasturba Hospital, Manipal, and PW2 was working in the said hospital as associate professor of orthopedics. During that time, it was not disputed. His competence to assess the disability was also not disputed. Therefore, we do not find any merit in the contention that the evidence of PW2 regarding assessment of the disability cannot be accepted. The evidence on record shows that the claimant was ಕೂಲಿ ಅಂತ ಬಂದಿದೆ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ. Was a laborer which involves the physical work. However, the evidence of liability itself shows that the amputation was of below knee at the level of upper third of right tibia. Therefore, it cannot be said that there was a total functional disability. At the most, the tribunal should have assessed his permanent physical disability at 80%, not at 100%. There was no proof of actual income of the claimant. Having 12,500. Considering the prevailing wage rates and cost of living during at the time of the accident, the tribunal is to 6,500.
10,000.
Tribunal should have fairly considered his
10,000 ತಗೊಂಡಿದ್ರೆ 12,000.
monthly income at rupees 12,500. 500. Since the disability was more than 50%, future prospects has to be added to the same. Therefore, his monthly income comes to 12,500 plus 3,125. It's equal to 15,625. 12 into 13. ಅಲ್ಲ ಅದ್ರದ್ದು 80% ಅಲ್ಲೇ ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತಲ್ಲ, ಆಮೇಲೆ 80%. Okay. The applicable multiplier is 13. Therefore, his total income comes to 24 lakhs, 15,625 into 12 into 13 madi, 24 lakhs 37,500. 80% loss of future earning comes to 24 lakhs 37,500 into 80 upon 100, 19 lakhs 50,000. Next thing, 6 months ಕೊಟ್ಟಿದ್ವಿ disability. Having regard to the medical evidence, 6 months, it could be fairly held that the claimant was not able to attend to his routine works for about 6 months. The compensation ought to have been awarded for loss of earnings during the laid up period, which comes to 12,500 into 6 is equal to 75,000. Having regard to the nature of injuries and period of hospitalization, the compensation awarded on the head of pain and suffering has to be enhanced to rupees 1,25,000. Medical expenses awarded was based on the documents produced, therefore that needs to be maintained. ಇದು 54,000 ಆಗೋದಿಲ್ಲ, ಕಡಿಮೆ ಆಗುತ್ತೆ. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಬೇರೆ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು, ಬರೀ ಫುಡ್ ನರಿಶ್ಮೆಂಟ್ ಅಂಡ್ ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಅದೆಲ್ಲ. Considering the period of hospitalization, nature of the treatment underwent, and injuries, ಅವ್ರು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 30,000 ಕೊಟ್ಟಿದ್ರ? It appears that awarding compensation of rupees 30,000 on the head of food, nourishment and attendance charges and conveyance meets the ends of justice. PW2 future medical ತಗೊಳ್ಳೋಣ and amenities. Claimant had lost his leg below knee, right leg below knee, and has thereby he has suffered a loss of amenities. Therefore, reasonably, the compensation on the said head can be assessed at rupees 1 lakh. Innondu feature. PW2 deposed that the claimant needs below knee prosthesis to walk. And that may require periodic replacement due to wear and tear. Therefore, awarding compensation of 50,000 on the head of future medical expenses is just and proper. Therefore, ಇದ್ರೊಳಗೆ 30,000 ಕಳಿಬೇಕಾಗುತ್ತೆ. Therefore, the just compensation payable is as follows. Future medical expense, loss of future earnings 19,50,000, paid up, loss of income during laid up period 75,000, pain and suffering 1,25,000, medical expenses 94,703, food nourishment attendance charges and conveyance during the hospitalization 30,000. 30,000 ನಾವು 54,000 ಕೊಟ್ಟಿದ್ದೀವಿ. ಎಷ್ಟು ಕಡಿಮೆ ಆಗುತ್ತೆ ಅವಾಗ? 24,000 ಕಡಿಮೆ ಆಗುತ್ತೆ. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಆಯಿತು, ಫುಡ್ ನರಿಶ್ಮೆಂಟ್, ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ 1 lakh, ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 50,000. ಟೋಟಲ್ ಇದರೊಳಗೆ 24,48,000 ಅಲ್ಲಿ 24,000 ಕಳಿಬೇಕು. 48,000 ನಲ್ಲಿ 24,000 ಕಳಿಬೇಕು.
24,24,703.
ಎಷ್ಟಾಗುತ್ತೆ? 24,24,703. 24,703. That was there.
24,24,703.
The compensation payable is like this ಅಂತ ಆಯ್ತಲ್ಲ. Minus compensation awarded by the tribunal 19 lakhs. 19 lakh ಎಷ್ಟದು?
4,703.
ಎಷ್ಟಾಗುತ್ತೆ ಅವಾಗ?
5,20,000.
5,20,000. 5,20,000. Having regard to the aforesaid reasons, the insurer's appeal is liable to be dismissed and claimant's appeal deserves to be allowed in part. Hence the following order. Okay. MFA number 4850/2020 is hereby dismissed. MFA number 6175/2021.
80% ಆದ್ಮೇಲೆ it will be partly allowed. 100% ತಾನಿಲ್ಲ. Tribunal has taken 100%, your lordship has taken 80%.
Well, ultimately quantum is higher. Okay.
Quantum always higher because of the adoption of the prospective.
And both appeals are deserve to be allowed in part. Hence the following. Another MFA number 4850/2020 and MFA number 6175/2021. ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಡಿಲೇ ಪೀರಿಯಡ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದು ಮಾಡಕ್ಕೆ ಏನಾರ ಆಗಿತ್ತಾ?
ಇಲ್ಲ, ಆರ್ಡರ್
ಆರ್ಡರ್
ಇಲ್ಲ.
ಅವ್ರದ್ದು ಆಗಿಲ್ಲ ಏನೋ ಗೊತ್ತಿಲ್ಲ.
ಆಗಿಲ್ಲ.
ನೋಡಿ ಅದ್ರಲ್ಲಿ
116 ದಿನ ಡಿಲೇ ಇದೆ.
ಆರ್ ಪಾರ್ಟ್ಲಿ ಅಲ್ಲೋ
ಆಗಿರುತ್ತೆ.
ಹಾಗಾದ್ರೆ the claimant in MFA number MEC number 6/2019 on the file of Principal Senior Civil Judge and MACT Udupi, additional MACT Udupi is awarded enhanced compensation of rupees 5,20,000 with interest thereon at 6% per annum from the date of the petition till its realization. Respondent number to the insurer shall deposit the said amount before the tribunal. 50% deposit ಮಾಡಿದ್ರು.
50% release to the
and adjusting the amount already deposited if any. ನೀವು totally challenge ಮಾಡಿದ್ರಲ್ಲ.
And delay may be that amount has to be because it's
ಏನು
not
order
order.
ಅಂತ ನೋಡಿ.
ಆಗಿಲ್ಲ.
Order ಆಗಿಲ್ಲ.
Order sheet ಅಲ್ಲಿ ತೋರಿಸಿ ನೋಡೋಣ ಎಷ್ಟು
Only
delay.
release of the amount ಆಗಿದೆ.
216 ದಿನ ಆಗಿದೆ.
216 days. They are not entitled for interest.
ಕಂಟ್ರೋಲ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಅವಾಗ ಆರ್ಡರ್
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. ನಾವ್ ಈಗ ಹೇಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಅವಾಗ್ಲೇನೆ ಮಾಡಿಸ್ಕೋಬೇಕಾಗಿತ್ತು.
ಅದೇ ಮಾಡಿಲ್ಲ ಅಲ್ಲ.
ಅಲ್ಲಿ ಈಗ ಮಾಡ್ಲಿಕ್ಕೆ
ಅಲ್ಲ ಮಾಡಿಲ್ಲ, you should have urged that.
But only we have urged for the release of the amount.
ಅಲ್ಲಿ ನೀವೇ ಡಿಲೇ ಕನ್ಫರ್ಮೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರು ಹಾಕಿದಾಗ you could have said that.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಶಿಪ್ ಬಟ್ ಅವಾಗ ಬಂದಾಗ only release
Review our own order now.
ಅಲ್ಲ ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಅಮೌಂಟ್ ಅವ್ರು ಮುಂದೆ ಮಾಡಲಿಲ್ಲ ಬರಲಿಲ್ಲ.
ಅಲ್ಲ ಹಾಗೆ ಬೇಡ ಅವ್ರ, ಯಾಕಂದ್ರೆ ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿರೋದ್ರಿಂದ ಅಪೀಲ್ಸ್ ಪಾರ್ಟಿ ಅಲೌಡ್ ಆಯ್ತಲ್ಲ. The impugned award is modified as follows ಅಂತ ಮಾಡಿದ್ವಿ. Modified as follows. The claimant is entitled to compensation of this 24,24,703 ನದು. What of sir? ಅದು 20,000 ಕಡಿಮೆ ಮಾಡಿದ್ಮೇಲೆ 24 lakhs 24,703. Claimant is entitled to compensation of this 24,24,703 with interest thereon. ಓ ಅದು ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಆಗಿದೆ ಅಂತ ಕನ್ಸುತ್ತೆ. At 6% per annum from the date of the petition till its realization. Respond number 2, insurer shall deposit the said amount before the tribunal on adjusting the amount already deposited, if any, within 4 weeks from the date of the receipt of a copy of this order. The ಏನದು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದು
ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು ಹೈಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ.
ಆರ್ಡರ್ ಆಫ್ ದ ಟ್ರಿಬ್ಯುನಲ್ with regard to release of the amount and investment is maintained. Transmit the amount in deposit, if any, and the TC as per the tribunal forthwith.
Cell number 42, MB Raka, C. Shankar Reddy.
Now, we are not taking the courage at all to conduct the cases at the appellate stage without having these depositions and certified copies of the records. ಏನು ಹಿಡ್ಕೊಂಡು ಬರೋದಿಲ್ಲ ಇಲ್ಲಿ, ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು. ನಿಮಗೆ ಅಪ್ಲೈ ಈವನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಉಡುಪಿ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್. ಇದು ಬೇರೆ ಕೇಸ್ ಅಲ್ಲ.
Cell number 42.
This case they have not preferred any appeal, no?
No, my lord.
42.
I make one submission. Here, my lord, the deceased is having a fixed salary, my lord.
ಅದೆಲ್ಲ ನೀನೆ ಹೇಳಿದಿರಿ.
ಅಲ್ಲ ಹೇಳಿದೀವಿ. Regarding future prospects, my lord, 50% has to be added. I humble request, my lord, in this case. She is having a fixed salary, my lord.
ನೀನೇನು ತುಂಬಾ ಹೇಳಿದ್ರು ಅದ್ರಲ್ಲೆಲ್ಲ. ಅಲ್ಲೇ you don't make any efforts before the tribunal. ಇಲ್ಲಿ ಬಂದು ಹೇಳ್ತಿದ್ದ PW2 is not the employer, PW2 is eye witness ಅಂತ ಏನೋ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
And also, my lord, claimant number 2 and 3 unmarried daughters. Claimant number 4 is minor son of the deceased.
ಇದರಲ್ಲಿ finding whether the compensation award to the appellant's claimants under the impugned award is just is the question involved in this case. Appellants are, appellant number 1 is the husband and 2 to 4 are the sons, the daughters, daughters and son.
Please.
Son of deceased. What is her name? Kausar Das. Kausar Das. On 1/11/2020 at 1:30 PM. When it's 3:1. ಅವ್ರನ್ನ ಯಾಕೆ ಮಾಡೋದಿಲ್ಲ ಅಂದ್ರೆ he was the rider of the vehicle. ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಮಾಡೋದಿಲ್ಲ. Why PW1 was not, claimant number 1 was not examined? Because he was riding the vehicle.
ಗೊತ್ತಿಲ್ಲ, ಸುಮ್ಮನೆ ಮಗನ್ ಮಾಡಿಸಿದ್ದಾರೆ ಮಗಳನ್ನ.
ARSI. Resort Sub Inspector. When Kausar Das was found on motorcycle number KA01 EK1802 as pillion rider, along with claimant number 1, the rider of the motorcycle, near Shri Raja Takis, Tumkur. Tumkur adu accident ಆಗಿರೋದು. ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೀನಿ ತುಮಕೂರು. ಲಾರಿ ಬೇರಿಂಗ್ ನಂಬರ್ RJ40 GL0279. Hit the said motorcycle from the hind side and caused grievous injuries to Kausar Das. She was shifted to Aditya Hospital, Tumkur. After preliminary treated, she was shifted to Nimans Hospital, Bangalore. When she died?
On the way to hospital, my lord.
She succumbed to the injuries on the way to the hospital. At the relevant time, respond number 1 was the registered owner, and respond number 2 was the insurer of lorry number KRJ14 GL0279, Rajasthan 279. The claimants filed MEC number 1088 of 2020 before the tribunal, contending that the accident occurred solely due to the actionable negligence. Charge sheet is exhibit testimony. Driver is solely due to the actionable negligence on the part of driver of lorry number RJ14 GL0279, container lorry. Accused ಹೆಸರು ಎಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ? ಅರ್ಮಾನ್ ಖಾನ್. Deceased was earning rupees 60,000 per month, and they were all 60,000 per month working as a teacher in Delhi Public School, Bangalore.
East.
They contended that they were dependent on her income, and therefore they have, due to her death, they have suffered the damages of 60 lakhs. They claimed such damages from respond number 1 and 2. Respondent one and 2 contested the petition, denying the actionable negligence on the part of the driver of the lorry, age, occupation, and income of the deceased, and their liability to pay the compensation or ಇನ್ನೊಂದು contingent ತಗೊಂಡಿದ್ದಾರೆ. ಇವನೇ ಕುಡಿದ ಮೋಟರ್ ಸೈಕಲ್ ಡ್ರೈವ್ ಮಾಡ್ತಿದ್ದಾನೆ. Respond number 2 contended that claimant number 1 himself was riding the motorcycle under intoxication without any driving license or helmet, and accident occurred due to his negligence. To prove their case, claimants got examined claimant number 2 as PW1 and one Imran Sharif as PW2, and got marked exhibit P1 to P12. No evidence was adduced on behalf of the respondents. The tribunal, on hearing the parties relying on the evidence of PW2 and exhibit P1 to P8, the FIR complaint in spot mahazar, inquest mahazar, IM report, postmortem report, and charge sheet held that accident occurred due to the actionable negligence on the part of the driver of the lorry. The tribunal considered the income of the deceased at rupees 23,955. No? Salary slip exhibit P10. Tribunal relying on exhibit P10, the salary slip considered the income of the deceased at rupees 23,955. Deducted 1/4 from the same for her personal expenses. ಯಾವ multiplier apply ಮಾಡಿದ್ದಾರೆ?
multiply 15.
Correct ಇದೆ ಅಲ್ಲ ಅದು?
Correct it is.
One fourth millimeter. Applied ಎಷ್ಟು 15 multiplier.
15.
15 multiplier.
Please.
And awarded compensation of this 27 lakhs on the head of loss of dependency. The tribunal in all awarded compensation of this 27 lakhs 80,000 and it heads as follows. Page number 27 and page 27. Next. The respondents have not challenged the award on any ground. Claimants have challenged the award in the above appeal on the ground that the compensation awarded is not adequate one. Next one. As already stated, the finding of the tribunal that the accident occurred due to the solely due to the actionable negligence of the driver of the lorry has attained finality. Though the claimants contended that deceased, ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ತಗೋಬೇಕಾಗಿತ್ತು? You said only future prospect ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದು ಒಂದೇ ground.
Also, income malad as per exhibit malad P10. Before COVID malad she is getting 32,000 malad. Allah.
Though the claimants contended that deceased was permanently employed in Delhi public school and relied on exhibit P10.
Please.
The salary slip.
34,607.
The employer was not examined to prove that claimant was deceased was permanently employed. Further, in the absence of any evidence to show that the deceased was getting more income than the one stated in exhibit P10, the submission of counsel for the claimants that she was earning more than what is shown in exhibit P10 also cannot be countenanced. Under circumstances, the tribunal was justified in justified under circumstances, the finding of the tribunal that salary shown in exhibit P10 was her income has to be accepted because the response have not challenged the said finding. Okay. As per exhibit P10, the monthly income of the deceased was rupees 25,955. Taxable limit was exempted ಅಂತ ಹೇಳಿದ್ರಲ್ಲ 23 25,000 ತಗೊಂಡಿದ್ದೀವಲ್ಲ ನೀನು ಎಕ್ಸಿಬಿಟ್ P10 ಅವ್ರೇನೋ ಬಿಡಕ್ ಮಾತ್ರ ನಿಮಿಷ ಕೂತ್ಕೊಂಡು ಸ್ಯಾಲ್ರಿ ಸ್ಲಿಪ್ ಅಲ್ಲ ಅವ್ರು ಒಂದು ತಿಂಗಳದ್ದು ನಾವು ಲಾಸ್ಟ್ ಮಂತ್ accident was on
Accident malad 1/11/2020.
1/11/2020. ನಾವು ಅಕ್ಟೋಬರ್ ತಗೊಳ್ಳೋಣ ಅಂತ ಹೇಳಿದ್ವಿ. ಅವ್ರು ಯಾವ್ದು ತಗೊಂಡಿದ್ದಾರೆ? ಅಲ್ಲ ಅವಾಗಂದ್ರೂ ಅಷ್ಟೇ ಇದೆ ಅಲ್ಲ 23,955 ಇದೆ. ಐ ಥಿಂಕ್ ನಾವೇನೋ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡ್ವಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಅಲ್ಲ ಡಿಡಕ್ಷನ್ಸ್ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ PF ಡಿಡಕ್ಟ್ ಮಾಡಿ ಇಷ್ಟು ಬರ್ತಿರುತ್ತೆ. ಅದರಲ್ಲಿ ಡಿಡಕ್ಟ್ ಮಾಡದೆ ತಗೊಂಡಿದ್ವಿ ನಿನ್ನೆ. ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತಲ್ಲ,
ಮಾಡಕ್ಕಾಗಲ್ಲ.
ನಾವು ಇಲ್ಲಿ ತಗೊಂಡಿದ್ವಿ ನಿನ್ನೆ 25,000 ಮಾಡಿದ್ವಿ, ಅದು ತಪ್ಪಲ್ಲ? 25,955 ಅಲ್ಲಿ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಆಮೇಲೆ ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ವಾ? ಇಲ್ಲ 2,400 ಕರೆಕ್ಟ್. ಏನ್ ತಗೊಂಡು ಅಲ್ಲ ಓಕೆ monthly salary of the deceased continuously June in the astrology was rupees 25,955. Therefore, her annual income was 25,955 into 12, 3,11,460. Out of that, professional tax of this 2,400 has to be deducted. Therefore, her annual income comes to rupees 3,09,060. The deceased was aged 39 years.
Please, 39 years.
She was, since there was nothing to show that she was permanently employed, as per the judgment of the Supreme Court in Pranay Sethi's case, 40% has to be income added to the income of the deceased by way of future prospects. Therefore, which comes to rupees 1,23,624. Therefore, her annual income comes to rupees 3,09,060 plus 1,23,624. 4,32,684. Our evidence alle bandide. He was a reserve sub inspector anta heli. Claimant number 1 in the complaint has stated that he was a reserve sub inspector. He did not enter the witness box to claim that he was dependent on the deceased, income of the deceased. Therefore, claimants 2 to 4 alone have to be considered as the dependents of the deceased. In view of the judgment of the Supreme Court, 1/3 has to be deducted for the personal expense of the judgment of the Supreme Court in Sarala Verma's case. 1/3 has to be deducted from the income of the deceased for her personal expenses. Therefore, her contribution and 15 multiplier has to be applied. And deducting 1/3 for her personal expenses, her contribution to the family comes to rupees 2,88,456 per annum. Applicable multiplier is 15. Therefore, the compensation payable on the head of loss of dependency is bracket 2,88,456 into 15 is equal to bracket complete 43,26,840. In view of the judgment of the Supreme Court in Pranay Sethi's case and Magma Corporation case, claimants are entitled to compensation of this 40,000 each with escalation at 10%, which comes to 44,000 into 4, 1,76,000. Similarly, on the head of funeral expenses and loss of estate, a sum of 15,000 plus 15,000 with the escalation at 10% has to be awarded. Therefore, the just compensation payable is as follows. Loss of dependency 43,26,840. Consortium 1,76,000. Loss of estate 16,500. Funeral expenses 16,500. Total 45,35,840. ಇನ್ನೇ ಮಾಡಿದ್ದಾರೆ. ಎಷ್ಟು ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ? Minus
27,09,000.
27,80,000. 27,80,000. ಇದರಲ್ಲಿ minus awarded by the tribunal. 27,80,000.
80.
840.
17,55,840.
70?
17,55,000.
17,55,840. Enhancement. Therefore, the appeal deserves to be allowed in part, hence the following order. The appeal is partly allowed. The claimants are held entitled to enhanced compensation of this 17,55,840 with interest thereon at 6% per annum from the date of the petition till its realization. Respondent number 2, the insurer shall deposit the enhanced compensation before the tribunal within 4 weeks from the date of this order. Transmit the records. This has to the tribunal 4 weeks. Yes. Yes, yes. 48, 2018. Yes, requested by the Parents Council. List on after 1 ವಾರ.
For R1 in.
1 ವಾರ ಆದ್ಮೇಲೆ ಹಾಕೊಳ್ಳೋಣ.
411.
411. Yes.
Watch out.
Yes. Right. Rest of the matters will continue in the afternoon.
Court officer. Court officer. Court officer. Serial number 44 kept ಇದೆಯಾ?
44. ಇದೆ sir.
Okay, thank you.
List continue 230.
ಒಂದೇ ಒಂದು ಪಾಸ್ವರ್ಡ್ ಇದೆ, ಪಾಸ್ವರ್ಡ್ ಆದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಮೇಡಮ್ 48.1 ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮೇಡಮ್, ಅದು ಅರ್ಜನ್ ಆಗಿದೆ ಈಗ 4
ಯಾವ್ದು ಈಗಾಗಿದೆ?
ಅಲ್ಲ ಈಗಾಗಿದೆ, ಹೌದು.
ಹಾ ಹೇಳಿ ಮೇಡಮ್.
ಮೇಡಮ್ ನಾಳೆ ನಮ್ದ
ಲಿಸ್ಟ್ ರೆಡಿ ಇದೆ, ಬಟ್ ಆದ್ರೆ ಇದು ಸ್ವಲ್ಪ ಮಾಡಿಫೈ ಆಗುತ್ತೆ. ಇವಾಗ ಲಿಸ್ಟ್ 2 ಇದೇ ಇರುತ್ತೆ. ಲಿಸ್ಟ್ 2 ಇಂದ ಲಿಸ್ಟ್ 1 ಏನಾದ್ರು ಒಂದು ಸೆಟ್ ಮಾಡಿದ್ರೆ ಯಾವಾಗ ಅನೌನ್ಸ್ ಮಾಡ್ತೀವಿ? ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಯಾವ್ದು ನಿಮ್ಗೆ ಬಂದಿಲ್ಲ? ಇದು ಸಕ್ಸಸ್ಫುಲ್
ಇಲ್ಲ ಮೇಡಮ್, ಎಲ್ಲ ರಿಪೀಟ್ ಆಗುತ್ತಾ? ಲಿಸ್ಟ್ ರಿಪೀಟ್ ಆಗುತ್ತಾ ದಿನ ಇಲ್ಲ ಮತ್ತೆ?
ಆಗುತ್ತೆ, ಇದರಿಂದ ತೆಗೆದು ಹಾಕ್ತಾರೆ.
ನಾಳೆ ಎರಡು ಇರುತ್ತಲ್ವಾ?
ಡೇಟ್ ಇವಾಗ ಮಾತ್ರ ಇಷ್ಟ ಇದೆ, ಒಂದು 4-5 ಇದೆ. ಕೇಳ್ಬಿಟ್ಟು ನಾನು ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಕೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಒಂದು 10 ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಸ್ಬೋದು. ಆಮೇಲೆ ಲಿಸ್ಟ್ 2 ಇನ್ನೊಂದು 10 ಮ್ಯಾಟ್ರ್ ಆಡ್ ಆಗುತ್ತೆ. ಅಂದ್ರೆ 20 ಹಾಗೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಬೇರೆ ವೆಡ್ನೆಸ್ಡೇ ಥರ್ಸ್ಡೇ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ತಿರ್ಗಾ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಇದು ಲಿಸ್ಟ್ 2 ಹಾಗೆ ಇರುತ್ತೆ.
ಸೊ ಬೇರೆ ದಿನ ನಮ್ಗಿರಲ್ಲ, ಬೇರೆ ದಿನ ನಮ್ಗಿರಲ್ಲ.
Court officer serial 52. Court officer ಇದೆ. Thank you ma'am.
ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಇರಲ್ಲ.
ಬುಕ್ಸ್ ಬೇಕು ಮೇಡಮ್.
ಡೇಟ್ ಗಿವನ್
ಆಗಿದ್ದು ಫ್ರೈಡೆ ಅಂದ್ರೆ ಇವಾಗ ಏನಾದ್ರು ಪಾರ್ಟ್
ಸೈಟೇಷನ್
ಈಗ
ವೆಡ್ನೆಸ್ಡೇ ಥರ್ಸ್ಡೇ
ತೋರಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ನಿಮ್ಗೆ ಅಪ್ಡೇಟ್
ಪಾರ್ಟ್ನರ್ ಇದ್ರೆ ತಗೋತಾರೆ.
Citation.
ಈ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ ನಾವು ಫೈಲ್ ತೆಗೆಸ್ಕೊಂಡು ರೆಡಿ ಆಗಿಬಿಡ್ಬೋದು. ಅವಾಗ ಬುಧವಾರ
ಬುಕ್ಸ್ ಇಡ್ತಾರಾ?
ಮಾತ್ರ ನಾನು ಕೇಳ್ಕೊಂಡಿದ್ದೇನೆ. ಆಡ್ ಮಾಡಕ್ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ.
ಈಗ ನಾಳೆ ರೆಡಿ ಆಗ್ಬಿಡೋದ?
ಚೇಂಬರ್ ಫೈಲ್ ಇದೆ ಮೇಡಮ್.
If in case exactly 20 ನಾವು ಬರ್ತಿರ್ತೀವಿ, ಒಂದರಲ್ಲಿ ನಾವು ಅಡ್ಜಮೆಂಟ್ ಕೇಳ್ತೀವಿ, ಎರಡರಲ್ಲಿ ಕೇಳ್ತೀವಿ, ಮೂರನ್ನ ಕೇಳ್ತೀವಿ. ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅಡ್ಜಮೆಂಟ್ ಕೇಳಿ ಬರೀ 2-3 ನಾವು ರೆಡಿ ಆಗಿರುತ್ತೆ. That won't be good.
ಇದಕ್ಕೇನು ಅಡ್ಜಮೆಂಟ್ಸ್ ಕೊಡಲ್ಲ ಹೇಳಿದ್ರೆ ಇಷ್ಟಲ್ಲೇ ಇರುತ್ತೆ ಅಂತ.
ಈಗ ಇದು ತಗೊಂಡೋಗೋದ ನಾವು ಒಂದು
ಇದು 1 ನಿಮಿಷ ನಾನು ತೋರಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮಧ್ಯಾಹ್ನ ಕೊಡ್ಲಾ?
ಮಧ್ಯಾಹ್ನ ಕೊಡಿ, ಯಾಕಂದ್ರೆ ಫೈಲ್ ತೆಗೆಸ್ಕೊಂಡು
ಏನಾದ್ರು ಅಕಸ್ಮಾತ್ ಇದ್ರೊಳಗಿಂದ ತೆಗೆದು ಹಾಕಿದ್ರು ಈ 5 ಅಂತೂ ಇಷ್ಟೇ. ಇದೇನಾದ್ರು ಇವಾಗ ಆಡ್ ಮಾಡಿದ್ರೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಬೇಕಂದ್ರೆ ಹಬ್ಬ ಆದ್ಮೇಲೆ ಜಾಸ್ತಿ ಹಾಕ್ಸಿ ಮಾಡ್ತೀವಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ದೀಪಾವಳಿ ಆದ್ಮೇಲೆ ಜಾಸ್ತಿ ಹಾಕ್ಸಿ ಮಾಡ್ತೀವಿ.
ಇದು ವೆಡ್ನೆಸ್ಡೇ ಥರ್ಸ್ಡೇಗೆ ರಿಪೀಟ್ ಆಗುತ್ತಾ?
ನಾಳೆ ಕಡಿಮೆನೆ ಹಾಕ್ಸಿ ಮೇಡಮ್. ನಾಳೆನೆ
ಇಷ್ಟೇ ಇವಾಗ ಜಾಸ್ತಿ ಇದೆಯಂತೆ. ಅದು ಹಳೆ ಡೇಟ್ ಕೊಟ್ಟಿರೋದೆಲ್ಲ ಬರುತ್ತೆ ಮೇಡಮ್.
ಈ ವೀಕ್ ಅಂತೂ ನಮಗೊಂದ್ ಸ್ವಲ್ಪ ಅಕಾಮಡೇಟ್ ಮಾಡಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾವು ರೆಡಿ ಆಗ್ಬಿಡ್ತೀವಿ. ಇದನ್ನ ನೀವು ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಇಷ್ಟು ನಾವು ರೆಡಿ ಆಗ್ಬಿಡ್ತೀವಿ.
ಅಡ್ಜಮೆಂಟ್ಸ್ ಕೊಡಬಾರ್ದು ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ. ಅದೇ ಅಲ್ಲೇ
ಅಲ್ಲೇ
ಕೊಟ್ರು ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಅಷ್ಟೇ ಹಂಗೆ
ಇಲ್ಲ ಮೊದ್ಲು ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ ಮೇಡಮ್, ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ರು.
ಹಂಗೆ
ಅವ್ರು
ಕೊಟ್ರು
ಹರೀಶ್ ಕುಮಾರ್ ಸಾಹೇಬ್ರು ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ರು, ಲಿಸ್ಟ್ ಅಲ್ಲಿ ರಿಪೀಟ್ ಮಾಡಿಸ್ತಾ ಇದ್ರು, ಯಾವತ್ತೋ ಒಂದಿನ ಬರ್ತಾರೆ.
ಲಿಸ್ಟ್ ಸಿಕ್ತಾ ಆಮೇಲೆ
ಹೇಳಿ
ನಾನು ಮರ್ತು ಹಂಗೆ ಹೋದೆ.
411
ಮೇಡಮ್ 48 ಹಂಗೆ ಗೌಡಗೆ
ಈತ or 411 ಇವಾಗ ಕೇಳಿದ್ರು.
ಥ್ಯಾಂಕ್ ಯು.
ನಿಮ್ಗೆ ತಗೊಂಡು ಹೋದ್ರೆ ಅವ್ರು ಇಸ್ಕೊಂಡ್ರು.
ಇದು ನಮ್ಮ ಚೇಂಬರ್ನಾ? ಇದು ಇನ್ನೊಂದು ಬೇರೆ ಇದೆ. ಇದು ನೀವೊಂದು ಅದು ಟೈಟಲ್ ಅಲ್ಲಿ ಇಟ್ಟಿರೋದು. ಒಂದು ABK ಅದನ್ನ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಬಿಟ್ಟು ಚೇಂಬರ್ ಕೊಡ್ತೀನಿ. ಯಾವ್ದಾದ್ರು ಸೈಡಲ್ಲಿ ಇರ್ತೀನಲ್ಲ ಟೇಬಲ್ ತರ ಶೀಟ್ ತರ ಇರ್ತೀವಲ್ಲಪ್ಪ, ಇಟ್ಟಿದೆಯಲ್ಲ ಸೈಡಲ್ಲಿ, ಅದನ್ನ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ನಿಮ್ ಚೇಂಬರ್ ಕೊಡ್ತೀನಿ. ಲಂಚ್ ಅವರ್ ಆದ್ಮೇಲೆ ಇರುತ್ತೆ, ಊಟ ಮಾಡ್ಕೊಂಡು ಬಂದ್ಬಿಡಿ. ಇದೇನಾದ್ರೂ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀನಿ. ಈಗ ಅಲ್ಲೇ ತಗೊಂಡೋಗ್ಬಿಟ್ಟು ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ತಂದಿರಿ. ಅದೇ ಒಂದು 4-5 ಇರುತ್ತೆ. ಚೇಂಬರ್ ಯಾರ್ದಿದು ಚಾಕ್ಲೇಟು? ಏನ್ ಸರ್ ಬರ್ತಡೇ? ಓ ನಿಮ್ ಗೊತ್ತಾಯ್ತು. ಎಸ್
ಯಾವ ದೇಶಕ್ಕೆ ಹೋಗಿದ್ರಣ್ಣ? US ತಗೊಂಡ ಅಲ್ಲೇ ಇಟ್ಟು
ಎರಡು ವಾರ ಶೀಟ್ ಕೊಡ್ಬಿಡಿ. ಯಾಕೆ ಗೊತ್ತಾ, ಅವ್ರ ಅಕಸ್ಮಾತ್ ಬರೆದ್ರೆ ಆಮೇಲೆ ಫೋನ್ ಮಾಡ್ತಾರೆ.
ಯಾರಿಲ್ಲ ಮೇಡಮ್, ಎಲ್ಲ ಪ್ರಿಂಟ್ ಹೊಡಿತಾರೆ. ಒಂದ್ ಪೇಜ್ ಅರ್ಜೆಂಟ್ ಆಗಿದ್ದಕ್ಕೂ ಇದು ಮಾಡ್ತಾರೆ.
40?
44.
Passport matter, seal number 8. Gayatri M.
Respondent number 2.
But for respondent number 2 to 4,
ಇದೇನು ಕಂಪ್ಲೈಂಟ್ಸ್ ಏನಾಯ್ತು?
file ಮಾಡಿದೀವಿ.
ಅದಕ್ಕೆ ಇಬ್ರು.
They were served or not served?
ಸರ್ವ್ ಆಗಿದೆ ಸರ್.
ಅದೇ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಗೊತ್ತೇ ಇರ್ಲಿಲ್ಲ ಅಂತ ಬರೀತಾರೆ.
ಮಲಾಡ್ ಇದೇನಾಗಿದೆ ಅಂತಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ SC ನಂಬರ್ ಅಲ್ಲಿ ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 to 4. ಆನ್ 2924 ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್, ಬೇಲೇಬಲ್ ವಾರಂಟ್ ಆಗಿದೆ. ಅದಾದ್ಮೇಲೆ ನಾವು 1999 ಅಲ್ಲಿ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಆನ್ ಬಿಹಾಲ್ಫ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 to 4 ಮೇಲೆ. ಅದಾದ್ಮೇಲೆ 1510ಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 12. ಅವತ್ತು ತುಂಬಾ ಮಳೆ ಬರ್ತಾ ಇತ್ತು ಸರ್, ಹಂಗಾಗಿ ನಾವು ಅಪಿಯರ್ ಆಗಕ್ಕಾಗಿಲ್ಲ. ಹಂಗಾಗಿ NBW ಇಶ್ಯೂ ಆಗಿದೆ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 to 4 ಮೇಲೆ. Therefore we filed IA for warrant recall ಮೇಲೆ. Kindly recall the order ಮೇಲೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಶ್ಯೂರಿಟಿ ಕೊಡ್ಬೇಕು ಸರ್, ಅದು ಎಲ್ಲ ರೆಡಿ ಇದೆ. ವಾರಂಟ್ ರಿಕಾಲ್ ಆದ್ರೆ ನಾವು ಪನಿಷ್ ಮಾಡ್ತೀವಿ ಸರ್. ಅಂಡ್ ಆಲ್ಸೋ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 to 4 ಅಪಿಯರ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೇಲೆ.
ಕರೆಸಿ ಅವ್ರ ಹೆಸರು ರವಿ, ಮಹೇಶ್ ಅಂಡ್ ಅನಸೂಯಮ್ಮ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2, 3 and 4 ಮೇಲೆ. 2 ಬಂದು ರವಿ ಮೇಲೆ, 3 ಬಂದು ಮಹೇಶ್, 4 ಬಂದು ಅನಸೂಯಮ್ಮ ಮೇಲೆ. ದಿ ಮದರ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಮೇಲೆ. 3 ಇದೆ ಬ್ರದರ್ ಇನ್ ಲಾ ಮೇಲೆ.
P. Ravi,
ಮಹೇಶ್ ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್
ಬಂದಿಲ್ಲ ಸರ್.
ಗಾಯತ್ರಿ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸರ್ ಥ್ರೂ ವಾಟ್ಸ್ಆಪ್ ಮುಖಾಂತರ, ಅದರಲ್ಲಿ ಇದೆ ಅಕ್ನಾಲಜ್.
ಸಬ್ಜೆಕ್ಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದ ಬಾಂಡ್.
We filed a ವಕಾಲತ್.
2 to 4 ಹೇಮಂತ್ ಕುಮಾರ್ ಅಂತ ತೋರಿಸಿದಾರಲ್ಲ ಅವ್ರ
ಹೇಮಂತ್ ಕುಮಾರ್ ಮೈ ಸೀನಿಯರ್ ಮೇಲೆ.
ರೆಸ್ಪಾನ್ಸ್ 2 to 4 are present with the report. The registry has placed the application and affidavit filed by the council for response 2 to 4. Warrant is not yet executed.
No my lord. Await ಅಂತಿದ್ದೆ.
To recall the order dated 15/10/2024 issuing non-bailable warrants against response 2 to 4. Considering the reasons assigned for the non-appearance, the order dated 15/10/2024 issuing non-bailable warrant. Warrants ಹೋಗ್ಬಿಟ್ಟಿರ್ಬೇಕಲ್ಲ ಈಗ. ವಾರೆಂಟ್ಸ್ ರಿಕಾಲ್ ಮಾಡಬೇಕು. ವಾರೆಂಟ್ಸ್ ಆರ್ ಆಲ್ರೆಡಿ ಇಶ್ಯೂಡ್.
ಇಶ್ಯೂಡ್ ಆಗಿದೆ ಸಮಯ, ಅದಕ್ಕೆ ನಾವು ವಾರೆಂಟ್ ರಿಕಾಲ್ಗೆ ಹಾಕಿರೋ ಸಮಯ.
ವಾರೆಂಟ್ಸ್ ಅಂತ ಬಿಡ. ನಾನ್ ಬೈಲಬಲ್ ವಾರೆಂಟ್ಸ್ ಇಶ್ಯೂಡ್ ಅಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾನ್ಸ್ 2 to 4 as per order dated 15/10/2024 are hereby recalled. Subject to response 2 to 4 executing personal bond in a sum of rupees 50,000 and ಅಲ್ಲ ಅವೈಲೇಬಲ್ ಆಗಿತ್ತು ಅದ್ರ ಮಾಡಿ
ಅವೈಲೇಬಲ್ ಆಗಿತ್ತು ಸರ್.
ಅದು ಹೋಗುತ್ತಲ್ಲ ಇದು.
ಅದು ರೆಡಿ ಮಾಡ್ತಾ ಇದ್ವಿ ಅಷ್ಟ್ರೊಳಗಡೆ ಟಪ್ ಆಗಿಂಗ ಟ್ರಯಲ್ ಕೊಡ್ತೀನಿ ಎಲ್ಲ ರೆಡಿ ಇದೆ.
50,000 and furnishing 2 sureties on the like sum to the satisfaction of the trial court for their appearance before the court whenever required.
Yes,
The
ma'am.
bond shall be executed within 7 days
Yes, ma'am.
from the date of this order. IA number 1/2024 is disposed of accordingly. Yes.
अच्छा प्लस.
Signatures.
For final hearing, Cell number 43.
Yes.
A. Venkatesh,
Yes, madam.
Nagraj V.
Serial
We
number
are respondent, 43.
Final hearing.
230. ನೀನ್ ಇಷ್ಟೇ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಅಲ್ಲ ಹಾರ್ಡ್ ಅಂತ ಬೇಕಾದ್ರೆ ನಾವ್ ಇಷ್ಟೇ ಬರ್ಕೊಂಡಿದೀವಿ. IT records not produced, PL on salary slip, P19 bank statement. It was not heard in full. It was not heard in full.
No.
It was heard ಅಂತ ಹೇಳ್ತಾರೆ. All right. Sorry, address your arguments though.
Bank statement.
Is it both side are only on quantum or liability?
Yeah.
Both side are only on quantum? ಏನದು?
93 lakhs is the what? 50% is already withdrawn. 55 lakhs.
Yes, so date of accident was 3/10/2012 and age was 28 years. Software engineer. Software engineer. Oh. What is the income proof produced?
Income proof is not reading anything.
ಏನು ಹಾಕಿದಾರಲ್ಲ ತಡೀರಿ ನೋಡು. Election salary certificate exhibit P11. ಅವ್ರನ್ನ who is PW2?
Appointment letter.
P certificate.
To be paid annually.
Competition, account extract, P10, P11 salary certificate, P19 bank statement.
The bank statement it does not show reflect any amount received from the employer.
Authorization, settlement of benefits of late Pritish Prabhakaran, exhibit P23. Issued by the employer, P23. Who is PW2? Employer in examine madidara.
Madam,
Employer is examined.
Examined.
PW2. Practice manager so and so. Pittur district, Kerala. This victim was also working in Kerala.
Oh.
Manager pre-sales. Total gross salary of 7,27,620 per annum. Appointment letter, pay slip, certificate issued by the company for his conduct. Cross examination ಏನ್ ಕೇಳಿದಿರಿ? Office constituent of P23. Cross examination ಏನ್ ಕೇಳಿದಿರಿ ಅವರು? I am not an employee working in Bangalore. Yes.
I am not an employee working in Bangalore. I am now working as deposited in Bangalore. I do not know British and his family member. I know petitioner and his son after he joined service. My company has authorized me to give evidence, but I have not received any summons. With questions, I have written the P22, 23 only to help the petitioner. Witness request the company company is responsible to produce as per the request we produce. It is true that exhibit 24 is not original. It is false, because just to help the children, we have produced
Yes. Salary slip, exhibit test book P 21 to 24. He has produced P of 21 to 24. P19 is they know only. By transaction 18,000 every month home September. November.
24. Remuneration, para number 4. Your salary package for this position will be 6 lakh per annum.
Exhibit.
324 lakh.
Authorization. So here with the small constant to give evidence. We will not do the authorization. Distribution of documents. File number 20.
Performance alliance of the
Copies of all passports.
appointment that orders does not disturb.
Birth certificate, copies of passports, copies of surviving family members. Break of service. This is to certify there is no break in service in respect of late function. This failure is for our case. In 1/1/2011. Was working in our observation. He was there from 3/10/2012. Yes. Original for this month or deposit information. An employee ಇರ್ಲಿಲ್ಲ ಅಂತ ಏನ್ deny ಮಾಡಿಲ್ಲ. As per this document, his salary was, gross salary was 57,777. Salary convenience performance. On basic salary 20% for 2020. Deduction.
Deduction to income tax in 2012, it comes under the bracket income tax. 2012.
Income tax, professional tax ಎಲ್ಲ ಡಿಡಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ಅದ್ರಲ್ಲಿ. ಮಾಡಿದ್ದಾರೆ. ಹಾ, ಅವರು ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದಾರಲ್ಲ ಅದ್ರ ಜೊತೆಗೆ ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಸರ್ಟನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅಲ್ಲೇ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ 2094, ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ 200. PF ಅಲ್ಲ ಎಂಪ್ಲಾಯೀಸ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್. ಎಂಪ್ಲಾಯೀಸ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಬೇರೆ ಇರುತ್ತೆ. ಎಂಪ್ಲಾಯೀಸ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಅಲ್ಲ, ಎಂಪ್ಲಾಯರ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ they should not deduct. Employees contribution deduct ಆಗುತ್ತೆ. ಸ್ಟಾಫ್ ವೆಲ್ಫೇರ್ ಫಂಡ್ ಇವ್ರು ತಾವು ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ. ಸ್ಯಾಲ್ರಿ ಕಾಂಪೋನೆಂಟ್ ಬೇಸಿಕ್ ಇಲ್ಲೂ ಆಗಿದೆ ಸರ್. ಇಷ್ಟೇ ತಗೋಬೇಕಾಗುತ್ತೆ ನಮಗೆ ಕೊಟ್ಟಿರೋ ಸ್ಯಾಲ್ರಿ. How much is taken by the tribunal salary? ಕರೆಕ್ಟ್, ಅದನ್ನೇ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು. ಅವ್ರೇನ್ ಸ್ಯಾಲ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಏನಿದೆಯೋ ಅದನ್ನೇ ತಗೊಂಡಿದ್ದಾರೆ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಪ್ರಕಾರ 50 lakhs 50,000. 36 lakhs.
ಅಲ್ಲ, ಅದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆದಾಗ at the time of his death his
only 1 month.
11 month previous year 2011 ನಲ್ಲಿ joined and he died in 2012. Yes.
3 years income tax is to be produced for the, to show that is an income tax and his earning is so much.
Yes.
And the bank statement does not show any reflect, does not show any salary received from the company. This particular company in which he was supposed to work, he was RP, he says. Exhibit P, P90, the last of the can looking to exhibit P90.
ಯಾವ month ಇದ್ದಂತೆಲ್ಲ ಕಾಣಿಲ್ಲ. September to June. $57,777. Particular tag. Yes.
And IT returns are not filed. Income tax returns are not filed.
Yes. Is that so? ಅಷ್ಟೇನಾ?
And bank statement does not reflect the salary. This is your problem.
ಅದು ಹೇಳಿದ್ರಲ್ಲ.
Huh?
You already submitted that.
Yes, ma'am. Exhibit P90. And 50% is taken as future cost. And my lord, in view of the law laid down by this court bench, recent judgment, that future income does not carry interest. Future cost. I talked to Justice Srinivasan Harish Kumar and the companion. I taken the view that
ಇನ್ಕಮ್ ಕೂಡ ಫ್ಯೂಚರ್ನೇ ಅಲ್ವಾ ಅದು? ಇನ್ಕಮ್ ನಾವೇನ್ ಕೊಡ್ತೀವಲ್ಲ, ಇನ್ಕಮ್ ಅಸೆಸ್ ಮಾಡೋದು ಫ್ಯೂಚರ್ ಅದೇನು ಅಕ್ರೋ ಆಗಿರೋದಿಲ್ಲ. ಅದಕ್ಕೆ
this is not supported by judgment of Bombay High Court, Jammu and Kashmir, Goa High Court, Allahabad High Court, and our High Court.
Yes. That's all.
Division bench, ನಮ್ಮ High Court, ಎರಡು ಇದೆಯಾ? Good. ಹೌದಾಗಿ
ಕಾಪಿ ಕೊಡಿ.
That day, all the judgments are discussed.
ಏನದು?
Recently, for 2 months back.
Yes. That's all. Yes, ನಿಮ್ದೇನು?
ಮೇಡಮ್ ಇಲ್ಲಿ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಅಂದ್ರು, ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕಿಗೆ ಲೋನ್ ಮಾತ್ರ ಕ್ರೆಡಿಟ್ ಆಗ್ತಾ ಇತ್ತು. ಸೊ ಅದನ್ನ ಲೋನ್ ಅಂತ ಬಂದಿದೆ. ಇಲ್ಲಿ ಇವ್ರದ್ದು ICICI ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಅಕೌಂಟ್ ಇದೆ. ಎಕ್ಸಿಬಿಟ್ ಅಲ್ಲಿ ಅವ್ರು ಮಾಡಿಲ್ಲ, ಬಟ್ ಇವಾಗ ನಾವು ಟ್ರ್ಯಾಕ್ ಮಾಡಲ್ಲ. ಪ್ರೀವಿಯಸ್ ಡೇಟಾ ಇದನ್ನ ಅಡ್ವೈಸ್ ಮಾಡಿದ್ರಿ ಬ್ಯಾಂಕ್ ಕೊಡಿ ಅಂತ.
Produced it by way of additional evidence here. Additional evidence ಅಂತ ಹಾಕಿದೀರಾ ಅದನ್ನ?
ಅದರಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಡೇಟಾ ಅಲ್ಲಿ ಹಾಕಿರ್ಲಿಲ್ಲ. ಸೊ ಅಲ್ಲಿ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರಿ. ಸೊ ಅದನ್ನ ಪ್ರೀವಿಯಸ್ 1 week ಅಲ್ಲಿ ನಾವು ಅದನ್ನ ಕಲೆಕ್ಟ್ ಮಾಡಿದೀವಿ.
ಕರೆಕ್ಟ್. ಅದೆಲ್ಲಿ ನಿಮ್ ಕೈಯಲ್ಲಿ ಹಿಡ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಹೇಗೆ?
ಎಸ್, ನೌ ಯು ಆರ್ ಪ್ರೊವೈಡಿಂಗ್.
ಹಾಗೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ವಲ್ರಿ? ಯು ಶುಡ್ ಫೈಲ್.
ಎಸ್, ವಿ ವಿಲ್ ಫೈಲ್.
ಅದು ಈಗ ಇಟ್ಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇದು ಮಟೀರಿಯಲ್ ಮೇಲೆ. Now it is said that as per your FPW2's evidence, his salary was.
At the same time, ನಾವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದೀವಿ on the basis of.
See, he argued on 3 points. His income is not proved, IT returns are not filed, bank statement or salary income first month it is lesser than 57,777.
Salary income first as per month 60,635 plus 11,000.
Exhibit ಯಾವುದು?
Exhibit ಇವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ಬಟ್ ನಮ್ಮ ಹತ್ರ ಇದಿದೆ.
You should argue based on the records which are before the court. We are facing lot of problem in motor accident cases.
Salaries, exhibit 11. 1 minute. Sir, 11 open ಮಾಡಿ.
Exhibit P11. ಅವ್ರು ಇಟ್ಕೊಂಡಿರೋದೇ ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್. P11
P11 ಸಾಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಅವ್ರಿಗೆ
ನೀವು ಅವ್ರಿಗೆ ಓಪನ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೇಕಾ? ನೀವು ಪ್ರೂವ್ ಮಾಡೋದು.
ಇನ್ನು ಬೆಂಚ್ನವ್ರು ಹೇಳಿದ್ರೆ ನೀವು ಓಪನ್ ಮಾಡಿ ಅಂತ ಹೋಗಿಸ್. ವಾಟ್ ಇಸ್ ದಿಸ್?
Directing me to do it.
P11 ಅಲ್ಲಿ ಯಾವ್ದಿದು? Whomsoever it concerns, he was employed with so and so since February 1, 2011. He was a permanent employee, manager presets. Currently he was drawing, currently ಅಂತ ಇದೆ, first month ದಲ್ಲ ಇದು. ಕರೆಂಟ್ಲಿ ವಾಸ್ ಡ್ರಾಯಿಂಗ್. ಇದು ಹೇಗೆ ಅವರೇ ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕಿದ್ರಲ್ಲಿ 57,777. ಇಲ್ಲೂ ಗ್ರಾಸ್ ಸ್ಯಾಲರಿ ತೋರಿಸಿದ್ದಾರೆ. ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್ ಫಾರ್ 12 months. ಅಲ್ಲ, PF ಗ್ರಾಚ್ಯುಟಿ ಆಯ್ತು ಟೋಟಲ್. ಅಂದ್ರೆ ಅದು ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ ಅಂತ, ಬಟ್ ಅದನ್ನ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅವ್ರಿಗೆ. ವಾಟ್ ಎವರ್ ದೇ ಕಲೆಕ್ಟ್ ಹಿಯರ್, ಇದನ್ನು ಅವ್ರ ಇನ್ಕಮ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ವಾಟ್ ಪರ್ಪಸ್ ಇದು ಅವ್ರಿಗೆ ಅಟ್ ದ ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ರಿಟೈರ್ ಆಗುವಾಗ ಅವ್ರು ತಿರುಗಿ ಹೋಗುತ್ತಾರೆ. ಬಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ದಿಸ್ ಸೈಡ್. ಇಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ, ಇದು ತಗೋಬೇಕಿದ್ದಾರೆ. ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಹೇಳಕ್ ಇವ್ರು ಹೇಳ್ತಾರೆ ಎಲ್ಲ. ಎಸ್, ನೆಕ್ಸ್ಟ್
ಅದೊಂದು ಮೇಡಮ್, ಅಲ್ಲಿ ಆಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಒಂದಿದೆ, 6% ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ 9% ರೀಸೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ. ನಾವು ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಕೇಳ್ಕೊತೀವಿ.
Unless you produce before.
Point number 16. Point number 16.
Paragraph number 16. This total completion payable to the occurrence with foreign. Now, whether any law is laid down here, discretion stay.
What facts have been given? This law is laid down in the paper.
ಇನ್ನು ಯಾವುದೋ ರವೀಂದ್ರನ್ ಸರ್ ಅವ್ರ ಜಡ್ಮೆಂಟ್ ನಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅಲ್ಲ ಬಿಟ್ರೆ ಇದ್ರ ಮೇಲೆ ನಾವು ಮೊನ್ನೆ ಯಾವಾಗ ಚೆಕ್ ಮಾಡೋದು ನೋಡಿದ್ರಲ್ಲ, ಯಾವ್ದು ನಮಗೆ ಇಲ್ಲ. ಎಸ್, ದಟ್ಸ್ ಆಲ್. ಹಾರ್ಡ್ ರಿಸರ್ವ್. ಎಸ್, ನೋಡೋಣ. ಇದು ನೋಡೋಣ.
ಅನದರ್ ಒಂದು ಸಬ್ಮಿಷನ್ ಇದೆ ಮೇಡಮ್. ಇದು 2015 ಅಲ್ಲಿ ಸ್ಟಾಪ್ ಆಗಿದೆ ಇಂಟ್ರೆಸ್ಟ್. ಅವರು ಅಲ್ಲಿ ಏನ್ ಅವಾರ್ಡ್ ಆಯ್ತು ಅದಕ್ಕೆ 55,000 ಅಲ್ಲ ಸಾರಿ ಲ್ಯಾಕ್ಸ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು, ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ವಿ. ರಿಮೈನಿಂಗ್ ಬ್ಯಾಲೆನ್ಸಿಗೆ ಫ್ರಮ್ 2015 ಇಲ್ಲಿವರೆಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೇಳ್ಕೊತೀನಿ.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ ಅಮೌಂಟ್ ಅಂತ ಅದರಲ್ಲಿ ಎಕ್ಸಿಟ್ 323
ಅವಾಗ ನೋಡಿದ್ವಿ.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ
P20
ಸೆಟಲ್ಮೆಂಟ್ ರೇಟ್ ಕಳಿಸಿದ್ದಾರೆ.
ಒಬ್ಬರು ನೀವೇ ಇಬ್ರಲ್ಲಿ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದ್ ತರ ಹೇಳ್ತೀರಲ್ಲ.
PF ಯಾಕೆಂದ್ರೆ it is not deductible from the income.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ನಾವ್ ಯಾರನ್ನ ಹಿಯರ್ ಮಾಡ್ಬೇಕು?
ಹೇಳಿ ಬೇಡ. ಈಗ looking to the division bench.
All it, we have heard you that. Yes.
We'll have to start on into that.
Yes. We'll also see what is the other law on that point.
Number 44.
55 may be taken up next week. Some function is there.
55 ಯಾರು ಅದ್ರಲ್ಲ ಅದರ್ ಸೈಡ್?
ನಾನೇ ಅಪ್ಪ.
ಅಲ್ಲ ಅದರ್ ಸೈಡ್ ಯಾರು?
ಶಿವಕುಮಾರಪ್ಪ TC. ಶಶಿಧರ
ಡೇಟ್ ಎಷ್ಟು?
ನಿಮ್ದು ರಿಸರ್ವ್ಡ್.
ರಿಸರ್ವ್
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದಾರಲ್ಲ, ಏನ್ ಹೇಳ್ತೀರಾ?
Next week happens.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
First week of November, fourth topic.
ನೀವು ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀರಾ, ಆಮೇಲೆ ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ನಿಮ್ಮದೇ ಇಂಪೋಸ್ ಮಾಡಕ್ ಶುರು ಮಾಡ್ತೀರಾ?
ಇನ್ನೊಬ್ರು ಸೀನಿಯರ್ ಇದಾರೆ.
ಇಲ್ಲ, ಅವ್ರ ಬಂದೆ ಫಂಕ್ಷನ್ ನಾಳೆ.
ನೀವು ಅವ್ರ ಮನೆ ಫಂಕ್ಷನ್, ಅವ್ರ ಮನೆ ಫಂಕ್ಷನ್ಗೆ ಏನ್ ನೀವು ಅಟೆಂಡ್ ಮಾಡಿ ಬಂದ್ ಕೇಸ್ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಡೇಟ್ ಹೇಳಿ. ಏನ್ ಇದ್ರಲ್ಲಿ ಏನ್ ಪೇಮೆಂಟು ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ. ಟ್ರ್ಯಾಕ್ಟರ್ ಅಂಡ್ ಟ್ರೈಲರ್ ವೆಹಿಕಲ್, ಟ್ರೈಲರ್ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ ಅನ್ನೋ ಗ್ರೌಂಡ್ ಮೇಲೆ
ಕರೆಕ್ಟ್.
ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲ ಸರ್.
ಪೇಮೆಂಟ್ ರಿಲೀಸ್ ಆಗಿದೆಯಾ?
ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹ್ಯಾವ್ ಟು ಕಂಡಕ್ಟ್, ಅದರ್ವೈಸ್ 2021 ಕೇಸ್ ನಾವು as requested by appellant's counsel, list on 29, 30th, and
29.
29.
Please.
Number 44. Vamshi Krishna, Rishikesh,
Yes.
Jayalakshmama, KB, SV Hegde Mulkan,
Appear for the petitioners, my lord.
44.
Out of terms. Yes.
Lord, this is an MV matter wherein it was dismissed, my lord. Dismissed on two grounds, my lord. My lord, the first ground for dismissal that is taken up is
2014 MVC, no?
14B excellent.
Yes.
My lord, the two grounds that have been taken up herein are the first is that rash and negligent driving. And second is, my lord, may I point out the compilation which is before this honorable court of the LCR, my lord. My lord, in that I would like to point out the order copy, the judgment passed. My lord, in that, my lord, the issues framed are,
Yes.
yes. My lord, the first issue that is framed is whether the petitioners proved that on 18/6, 2014 at about 9:30 AM near Melahalli Gate, while deceased NR Ravisha was proceeding in the car so and so, he lost control due to high speed. As a result, he succumbed to death. My lord, I may point out the second issue, whether the petitioners are entitled for compensation. My lord, the basic question that was required to be framed in herein is whether the deceased has driven the car rash and negligently. My lord, if that answered, the entire petition stands either admitted or dismissed, my lord. That is not framed at all.
He himself was the driver of the car.
Yes, my lord. He himself was
Only
driving the
vehicle
car.
was involved.
Sorry, my lord.
Only one vehicle was.
Only one vehicle was involved. The interesting fact herein is, my lord.
Was proceeding in Fiat car bearing number so and so, by riding the same, his, along with his sister and her children, his father ride. And his father by riding the same. Who were driving the vehicle?
The deceased was driving the vehicle, my lord. Father was sitting beside. Sister was sitting behind along with two kids.
Sir, how they are related to him?
Yes, my lord. Father, sister and her two kids.
As if Ibru ಹೊಡಿತಿದ್ರು drive ಮಾಡಿದ್ರು.
In a place, it sounds like both were driving kind of, my lord. I understand that fact.
No, he has sought compensation for his death.
Yes, ma'am.
He himself was driving it.
He himself was driving. The fact, yes, my lord. I would substantiate that fact as to, my lord, I would stand absolved to come before this court if at all the fact remains that it was due to his negligence or his rash driving, my lord. I admit that fact. Otherwise, my claim stands as it is, my lord.
Against whom?
Yes, my lord. The insurance copy, my lord, I have filed my lord. I had filed an application. Today, the IA is also for hearing, wherein, my lord, I have filed Order 41 Rule 27 application for production of additional document, despite the same forms the compilation of the documents before the trial court, my lord. Just a second, I'll give you one.
Correct. First, you have to say how if accident occurs because of his own, when he himself was
Right,
driving
my lord.
and death takes place, how they
How even the claim is admissible, is it?
are entitled to.
I understand, madam. I understand. Lord, may I just, even before proceeding to the arguments on the main matter, may I just address the points as to why I am filing the additional documents herein along with this application, my lord?
No, you first argue on the main
Right,
matter, then
right.
consider that.
My lord, I will just describe in a nutshell the incident. He was driving on the Mailanahalli gate, and the place he reaches there, the vehicle, due to the speed and the burst of the tire, it topples. The left-hand side front wheel is what is burst due to the speed is what is said, and it topples and it falls down and he dies at that place itself. Others are injured, my lord. No other vehicle is incurred at all. My lord, the question that has to be answered in order to whether admit or decline the present thing is, my lord, whether he was driving rash and negligent or not. My lord, in doing so, the reasons why the vehicle topples has to be considered in first place. My lord, on the last date of hearing, I remember my lords had pointed out a point as to whether the vehicle toppled down and then the tire burst, or the tire burst and then the vehicle toppled down. My lord, the answer to this question is going to answer the whole thing, my lord. My lord, to answer this specific point, this is all based on physics, my lord, as to whether the speed, the velocity, and the impact of the tire, and all of those things. But interestingly, in the judgment itself, my lords, the trial court observes that IMV report is not filed, while at the same time, the same forms the compilation which is provided as a CC in their own compilation, my lord. The IMV report was very much before the court.
See,
Yes,
the tribunal has rejected the petition on the ground that if he himself was a
Yes, ma'am.
transgressor,
Yes,
for that he cannot be indemnified.
yes.
Uh,
I accept this.
Which law says at the most you should have filed it 163A, earlier 163 alva ಅದು?
163.
Hmm.
Now 166.
166 is normal.
Now 166.
ಅಲ್ಲ,
166 he has filed this claim petition. And there necessarily is to prove the negligence. PA cover in ಅಲ್ಲ ಅದ್ರೊಳಗೆ ಏನು ಇದ್ದಂಗಿಲ್ಲ. Because your lords may kindly.
Was a registered owner of the vehicle?
He not the registered owner. PA cover ಆಗ್ಬೇಕಾದ್ರೆ he must be a registered owner and the policy must be in his name and he must hold a valid driving license at the time of the accident.
Right.
These are all the three conditions. ಇದು claim petition is under section 166.
166.
ಇದರೊಳಗೆ ಶಾರ್ಟ್ ಇನ್ 2 ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳೋದಾದ್ರೆ, my lord, your lords may kindly appreciate sister, his own sister who was traveling in the said car, she gave a complaint at the earliest. She says, my brother who was driving the vehicle in high speed in a rash and negligent manner, he drove the car and accident took place. Then, my lord, the police have investigated the matter, and then police have filed the abated charge sheet against the deceased, which remained unchallenged. Then, my lord, the theory of, my lord, first time in the claim petition also they plead that, my lord, the accident took place due to his own rash and negligent driving. Then, my lord, theory of tire burst came in the first time in the in her evidence before the tribunal. Then, my lord, they made an application before the tribunal saying that to amend the claim petition, saying that because of tire burst the accident took place. And tribunal, considering all these aspects, looking into their own statement and complaint, etc., said that it will change the very nature of the claim petition. Accordingly, it cannot be maintained, and so accordingly that I was rejected. That remained unchallenged before this tribunal, and my lord, that they have not challenged that order also.
No fault liability, ಎಷ್ಟದು ಅಮೌಂಟ್ ಈಗ no fault liability?
Lord, may I make my submissions on the point which my learned friend has raised?
Because we are not getting the law here.
No, I would try and point out.
What is now?
My lord,
Then, my lord, your lords may kindly see.
163 ಇದ್ದದ್ದು ಈಗ ಯಾವುದು provision?
163, my lord,
88 Act ಅಲ್ವಾ?
Yes,
It's 88
ಅದರೊಳಗೆ
Act only.
160,
It's-
old act.
This is under old act only.
Yes. And claim petition is
63
apparently, my lord,
and-
under section 166 of the Motor Vehicles Act.
163.
163 A Supreme Court held, my lord, that he cannot claim petition against his own insurer. There, my lord, in some of these judgments, my lord, that personal accident claim he can make, but to the effect that, my lord, he should be the registered owner and policy must be in his name.
ಇದು ಹೊಸ ಆಕ್ಟ್ ಇರೋದು 88 ಆಕ್ಟ್ ಅಂತಾನೆ ಅದು ಇಲ್ಲಿ 88 ಆಕ್ಟ್ ಅಂತಾನೆ ಬರೆದಿದ್ದಾರೆ. ಇದು ಓಲ್ಡ್ ಆಕ್ಟ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ, ಅಂದ್ರೆ ಆಕ್ಟ್ ಹೆಸರು ಅದೇ, ಬಟ್ ಆಸ್ ಅಮೆಂಡೆಡ್.
ಇದು 1994 ದಲ್ಲಿ ಬಂತು ಇದು 163A that has come into force, and the accident took place in the year 2007, I think.
2014.
2014.
But the Supreme Court also held, my
ಇಲ್ಲಿ
lord.
out of use of the vehicle ಅಂತ ಇದೆ ಅದು.
Yes, my lords.
This aspect has been already interpreted by the Supreme Court long back, my lord, in Minu B. Mehta's case. And ನಮ್ಮ ಹೈಕೋರ್ಟ್ judgment before the tribunal has been ಒಂದು ಜಸ್ಟಿಸ್ N.K. Kumar ಸಾಹೇಬ್ರದ್ದು ಒಂದು, ಮತ್ತೊಂದು ರವಿ ಮಳಿಮುಟ್ ಅಂಡ್ ಆನರೇಬಲ್ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ.
ಕೊಡಿ ನೋಡೋಣ.
ಅಲ್ಲೇ ಇದೆ, ತಮ್ಮ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲೇ ಇದೆ. Relying on all this aspect, my lord.
63 was also considered.
163, my lord, the question is not raised regarding 163 at all.
ನೋಡಿಲ್ಲ, but court can mold the relief ಅಲ್ಲ.
ಅಲ್ಲ ಮೋಲ್ಡ್ದೆ ಅಂತಂದ್ರೆ my lord, here ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ the very specific case is, my lord, that he was negligent. So that question doesn't arise here at all.
Second schedule is.
My lords.
50,000 per year ಅಲ್ಲ?
Pardon, my lord.
Second schedule 50,000 per year.
Second schedule ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಅದು 40,000 per annual income ಅಂತ ಮಾಡಿದ್ದಾರೆ. But strictly, my lord, it's not applicable, my humble submission.
We'll see that, just
Yes.
out of our.
ಅಲ್ಲ ಅದಕ್ಕೂ ಮೊದಲು if he concludes his argument, I'll place before your lordship, my lord, the Honorable Supreme Court judgment
Second schedule.
in Minu B. Mehta's case.
Age of the body victim ಮೇಲೆ ಹೋಗುತ್ತೆ ನಾನು. As per the second schedule ಅಂತಾರೆ ಅದರಲ್ಲಿ. Second schedule it goes on the age. ಮ್ಯಾಕ್ಸಿಮಮ್ ಅಷ್ಟು ತಗೋಬೇಕಂತ. ಮ್ಯಾಕ್ಸಿಮಮ್ ಅದು. ಅಲ್ಲಿ ಏಜ್ ಗ್ರೂಪ್ ಮೇಲೆ ಹೋಗುತ್ತೆ.
Negligence need not be proved ಅಲ್ಲ 163.
ಅಲ್ಲ there, my lord, the provision is entirely different, my lord. There, my lord, in order to provide, my lord, the early justice, my lord, structured formula has been provided to a certain class of persons whose income they are restricting to 40,000. But here entire scenario is different.
40,000 into appropriate multiplier ಮಾಡಲೇಬೇಕಾಗತ್ತಲ್ಲ?
ಅಲ್ಲ appropriate multiplier, my lord, it's a other type of cases, my lord, where the claim petition is filed under section 163A. And Supreme Court even held, my lord, section 163A is a specific this one provision. And you cannot say, my lord, if his income exceeds 40,000 rupees per annum, then claim petition itself is not maintainable. So many judgment of our High Court.
ನೀವು ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? What was his income?
Pardon, my lord. His income they claim.
It's admittedly, my lord, even the trial court has observed annually 7 lakh it is what?
If it is 7 lakhs, then it will not apply.
ಇದು ಬರಲ್ಲ.
It is not, he is not coming within the
My
ambit
lord.
of this provision.
My lord, even
Our argument here. Yes. Just, preliminary.
Sorry, my lord, I just
Preliminary
to make
assessment.
clarify this.
Yes.
my lord, even before, my lord, we reach to whether it's admissible or not, my lord, may I just justify my argument on the point, whether there was a negligence or not, was not at all looked into as what is my contention here, my lord. My lord, in order to.
Please
Yes.
satisfy us how a claim petition life is maintainable in case of an accident on account of the negligence of the deceased himself.
Yes,
And
so,
if he himself was driving the vehicle.
my lord, in this, to answer that question, I'll have to argue on the point whether there was negligence or not. Only to that effect, I am arguing. Even if he is a driver, if at all negligence was there, then I admit the fact that he is not entitled to whatever the compensation.
What is this, your own record, exhibit P3 charge sheet, whether it was negligence or not? Exhibit P1 complaint given by whom? P1?
By
FIR.
sister, my lord,
His
sister,
sister only gives
who
the
was
complaint.
traveling in the said car only, along with the deceased. All family members, they were traveling.
My lords, on the said aspect of the sister giving the.
The dead person.
Pardon,
Repeated charge.
that's there.
My lords,
Ravish. Or ಮೇಲೆ ತರ್ಸಿದ್ರು. Now.
the deceased is
Charge
the
sheet was filed against the deceased himself.
right.
How do you say that there was no negligence on his part?
Yes, I would, if given an opportunity, I would substantiate the argument right away, my lords. My lord, the car which was driven here, there is prima facie, if negligence has to be proved, or rather prima facie negligence can be proved immediately if any other vehicle is in touch with the vehicle that happened. In cases where there is no other vehicle that is involved for the purposes to prove negligence, my lord, what they have tried to resort to herein, even in the IMV report, my lord, it's very clear in the compilation which is sent by the trial court itself, my lord. Front left side wheels disc bend and tire burst due to impact. My lord, now the terminology due to impact has to be ascertained. Even on the last occasion, this honorable court was on the same point, my lords. My lord, due to impact herein, the question that was raised by this honorable court was whether due to the toppling of the vehicle, the tire burst, or whether due to the tire burst, the vehicle toppled. My lords, in cases where the tire is burst, how can the negligence be attributed to the driver? Even per se, the driver himself is the one who is deceased and claiming. My lord, in cases of tire burst and death.
Right, your own document, it says, IMV report, I am of the opinion that cause of accident was not due to any mechanical defect of the motor vehicle.
IMV reports, my lord.
Class 9.
Clause 9, my lords.
I am of the opinion that cause of accident was not due to any mechanical defect of the motor vehicle.
Right, my lord. Right, my lord. But even before we head there, my lord, if we have to understand how the accident happened and what was the reason of death and whether negligence was involved or not, my lord, the very much we must have to harp upon the terminology which is used, tire burst due to impact, my lord. And when tire burst due to impact, I have to substantiate, my lord. The very point that has to be considered whether, as rightly was pointed out by this honorable court, that the toppling caused the tire burst or tire burst caused the toppling resulting into death, my lord. If in case in the latter part, if the tire bursts and then it topples and due to the impact. Yes, absolutely, my lord. Yes, I would like to submit a memo to that effect, my lord. There is a research paper on this specific aspect. On the point, this is, my lord, completely physics, my lord. My lord, if I have to substantiate none of this is a peculiar set of facts wherein no court would have dealt as on date, my lord. This would become rather reportable wherein, my lord, this aspect has been dealt with. My lord, this as completely depends upon the physics of a vehicle, and in cases where the vehicle is in speed and the tire bursts, and what happens thereafter is what is being dealt in very much detail by comparing the vehicles and the impact by the Qatar Physics University.
Theory is very much right, but there must be some evidence for that.
My lords, in this, my lords,
Tire burst is the reason for accident.
Right.
Something should be there.
See, there was a charge sheet. You should have let in evidence to rebut this presumption. There was some presumption. Whom did you examine? This Nagaratna alone.
Only Nagaratna, except neither the sister has been examined, my lord. Nothing has happened. The very much fate herein was
not examined.
not examined, my lord. Not examined.
Correct. She was not the inmate of the car. This
She was inmate.
PW1.
PW1 was not.
So whom did you
There's
examine?
absolutely, my lords are very much right. There's no point in cross-exam.
Taking the time of the court.
My lord, there was no point in cross-examining PW1 is what is very much rightly pointed out. Rather, it was Shobha, that is the sister or the father who was sitting in the car was.
Of the car should have been examined.
Yes, absolutely. But they were not brought in. And the fate herein is, my lord, this, the wife of the deceased, she was, she had delivered and had a 6 months baby, and she was completely unaware of the fact. My lord, if I may have to point out the reason why even the claim petition says that rash and negligent driving of the deceased, my lord, even if I have to point out why.
Just only one question.
Right, ma'am.
This was the material before the court. There was nothing to rebut this document material. Even the inmates of the car were not examined.
Not examined.
Then how the insurance company is liable to pay? Insurance company is liable to pay if the accident occurred due to use of the vehicle, if he had no role at all. Even policy, he says policy was did not cover this risk also. Policy no produce madilva.
My lord, along with my application, I produced the policy.
Finally,
Along with my application, I produced it.
Record
ಇಲ್ಲಿದೆ ಇದರಲ್ಲಿ ಯಾವ್ದಾವ್ದು ರಿಸ್ಕ್ ಕವರ್ ಆಗಿದೆ ಪಾಲಿಸಿ ಇದೆ ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಮಾರ್ಕ್ ಇಲ್ಲ ಇದು ಐಟಿ
ಇದೆ ನಮ್ಗೆ ಕಾಪಿ ಇದೆಯಾ?
Policy.
Finally, you had produced it before the trial court.
My lords, the policy, I have it along with me, along with the memo I'm submitting.
Examine ಮಾಡಿದಾರಲ್ಲ.
ಅದು ನಮ್ಮ ಇನ್ಶೂರೆನ್ಸ್ ಆಫೀಸರ್ನ ಎಕ್ಸಾಮಿನ್.
Policy mark ಆಗಿ.
Policy is not.
Policy is not marked, my lord. Policy is
But it was
before the
placed on
trial
the-
court, the matter has
it
not
was
been
placed
properly
on the
dealt
court.
with or not properly conducted, my lord.
Even if it is marked, it makes a difference.
My lord, it does make a difference because of the clause therein.
ಇದರಲ್ಲಿ ಕವರೇಜ್ ಯಾವ್ದಾವ್ದ್ರದ್ದು ರಿಸ್ಕ್ ಅಲ್ಲಲ್ಲ ಅದು ಇದು ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ ಇಲ್ಲಿ ಅವರು ಅದು ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ ಇದನ್ನ ಪ್ರೀಮಿಯಂ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ.
Limits.
My lord, I have the copy. If ready reference, I may submit.
ಅಲ್ಲ ಅಲ್ಲೇ ಇದೆ.
ಹಾ.
ಇಲ್ಲಿ ಕೊಟ್ಟರೆ ನಾನು
Fire and
ಸ್ವಲ್ಪ
body
ಇಲ್ಲ.
carriage, ಇದೆಲ್ಲ
Not
ಆಯ್ತು.
covered. ಇಲ್ಲಿದೆ ನೋಡಿ. Limits of liability. Use sections are death, bodily injury in respect of any.
One
As per the Motor Vehicle Act.
ಇದು ಅಲ್ಲ ಇದು ಲಿಮಿಟ್ ಸಾಕು. ಹೌದು ಇವ್ರದ್ದು ಕವರೇಜ್
Coverage.
ಇಲ್ಲ ಅದು ಕವರೇಜ್
It is not coverage, no? But
ಅವ್ರು ಎಷ್ಟೆಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಇನ್ನೊಂದು ಕಾಲಮ್
Policy.
ಇರುತ್ತೆ. ಯಾವ್ಯಾವ ರಿಸ್ಕ್ ಎಷ್ಟೆಷ್ಟು ಪ್ರೀಮಿಯಂ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಇಲ್ಲ ಇಲ್ಲ ಹೀಗಿರುತ್ತೆ ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್. ನಿಮ್ಮವ್ರು ಹೇಗ್ ಕಟ್ತಾರೆ ಅದು ಫೈಲ್ ಮಾಡ್ತಾರೆ ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ ಬೇಸಿಕ್ ಪ್ರೀಮಿಯಂ ಬೇಸಿಕ್ ಪಿಪಿ ಕಂಪಲ್ಸರಿ ಇಲ್ಲ ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಫಾರ್ ಓನರ್ ಡ್ರೈವರ್ LL ಟು ಪೇ ಡ್ರೈವರ್ ಇದೆಲ್ಲ ಇದು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಲ್ಲ
ಯಾವುದು?
ಅಲ್ಲ ಇಲ್ಲಿ
Any person is what they say, my lord.
accident to owner driver 100 rupees
additional
ತಗೊಂಡಿದ್ದೀರಿ
premium ತಗೊಂಡ್ರೆ.
ಅಡಿಷನಲ್
ಅಲ್ಲ ನಮ್ಮ
My lord, if may I read out.
ಒಂದು ನಿಮಿಷ ಇಲ್ಲಿ.
ಆದ್ರೆ ಪರ್ಸನಲ್ ಕಂಪಲ್ಸರಿ ಪರ್ಸನಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಫಾರ್ ಓನರ್ ಡ್ರೈವರ್ ಅಂತ ಇದೆ.
ಓನರ್ ಡ್ರೈವರ್. But it's for owner driver, my lord, not
ಕಮ್ ಡ್ರೈವರ್
owner driver, my lord, as per this on the India Motor Tariff as well as the terms and conditions policy, provided that ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ he must be the registered owner of the car or any vehicle and he must be his name is to be shown in the insurance policy. He is the insured. It means he is the insured. And he must hold a valid driving license.
you collected the premium
That is, my lord, in respect of owner. Owner of the vehicle is my lord.
ಇಲ್ಲ ಅದು ಓನರ್ ಡ್ರೈವರ್
Owner driver and as per the
ಓನರ್ ಹಿಮ್ಸೆಲ್ಫ್ ಅಂತನಾ
owner driver.
ಹಿಮ್ಸೆಲ್ಫ್ ಇಸ್ ಡ್ರೈವಿಂಗ್
If owner himself is driving.
ಅದಕ್ಕೆ ಕವರ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಕವರ್ ಆಗುತ್ತಾ
ಅಷ್ಟೇ cover
ಅದ್ರ
ಆಗುತ್ತೆ.
ಕೆಳಗಡೆ ಇನ್ನೊಂದಿದೆ LL to limited liability to paid driver ಅಂತಿದೆ. He was not even
He was not a paid driver.
50 rupees ಅದು ಇದೆ paid driver.
Only ಇದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ for the purpose of insuring the owner, this has been collected. Not for any person he can drive.
ಲಿಮಿಟ್ ಬರುತ್ತೆ paid driver ಇದ್ದಾರೆ ಅವ್ರದ್ದು ಕವರ್ ಆಗಿದೆ but he was not even a paid driver.
He was not a paid driver also.
Who was the owner of the
Owner of the vehicle is my lord.
Manjunath, my lord.
The Manjunath.
Respondent
the
number
first-
1 here.
First respondent.
The father is not the owner.
He is not the owner.
Father is not the
That was Shivaling.
G. Manjunath, my lord, the respondent.
He is
number
the
one.
brother-in-law, my lord. The one who is owner is Manjunath is the brother-in-law.
Complainant husband ಅವರು
ಯಾರು?
ಮಂಜುನಾಥ್ ಅನ್ನವರು
ಮಂಜುನಾಥ್ ಇದು
ಕೊಡು ಇದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Our husband. Our husband. My lord, but in the insurance itself, what the clause they specifically, I would like to point out is persons or classes of persons entitled. My lords, persons or classes of persons entitled. Any person including insured that a person hold an effective driving license at the time of accident and is not disqualified from holding or obtaining such a license.
Where are you reading? Where are you
The
reading?
My lord,
limitation
the
has to
insurance
use-
copy itself.
my lord, limitation has to use clause ಅಲ್ಲಿ ಇದೆ ಅವರು.
ನೀವು ಒಂದು ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡಿಸ್ಕೊಂಡಿಲ್ಲ ನಾವು ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ವಿ.
Lords, if I may
ಮೇಲ್ಗಡೆ
submit,
persons or classes of persons
if I may submit this copy along with the memo, that will be ready reference for the court.
my lord, ಅಲ್ಲೇ ಅದ್ರೊಳಗೆ ಇದೆ.
Policy in which column you read that?
ಆ ಪಾಲಿಸಿ ಒಳಗೆ ಇದೆ. ಸ್ವಾಮಿ ಇದಾದ್ಮೇಲೆ ಶೆಡ್ಯೂಲ್ ಆದ ನಂತರ ಮಧ್ಯದಲ್ಲಿ ರೀಸನ್ ಪರ್ಸನ್ಸ್ ಆರ್ ಕ್ಲಾಸಸ್ ಆಫ್ ಪರ್ಸನ್ಸ್ ಟು ಬಿ ಮಿಡ್ಲ್ದಲ್ಲಿ
Persons?
ಪರ್ಸನ್ಸ್ ಆರ್ ಕ್ಲಾಸಸ್ ಆಫ್ ಪರ್ಸನ್ ಎಂಟೈಟಲ್ ಟು ಡ್ರೈವ್ ಅದ್ರ ಓದ್ತಾ ಇದ್ದಾರೆ ಅವರು.
Sorry.
Persons are classes of persons entitled to drive. Any person including the insured, provided that person hold an effective driving license at the time of accident and is not disqualified from holding or obtaining such license, provided also that person holding an effective learner's license may also drive the. Yes.
And my lord, even the limitations as to use is also what is immediately below that. In this specific case, even the deceased doesn't lie in any of those A to F clauses.
Yes.
So my lord, the whole thing that lies around is, my lord, whether the negligence was actually there or not is the question. My lord, if at all the series is taken into consideration, the FIR, my lord, the charge sheet, all the statements that have been taken by the people around, that is farmers or the Shobha Rani, that is the sister who was inmate of the car, my lord, everything is a copy paste is what I may substantiate, my lord, if those documents I may point out. My lord, even the first paragraph of the claim petition is a copy paste from the same FIR, which contains, my lord, this is incongruable, wherein the claimant himself or the legal representatives of the claimant themselves come and say that the deceased was driving rash and negligently, my lord. My lord, this can only lead to a case wherein it is only a copy paste of what has been stated in the FIR, my lord. My lord, the compilation is before this honorable court. If I may point out from the FIR, my lord. My lord, point number 10 of the FIR at page number 28 of the documents from the trial court, my lord.
Yes.
My lord, the para number 10. ಈ ಕೇಸಿನ ಸಾರಾಂಶವೇನೆಂದರೆ, my lord, I am a bit weak at reading Kannada, my lord. If read in this in entirety, my lord, what is coming out is ಅತಿ ವೇಗವಾಗಿ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಿಂದ ನಡೆಸಿದ್ದಾರೆ. This is one thing. My lord, the charge sheet, if seen, the charge sheet which is marked as Exhibit P3 before the trial court, my lords. There, point number 17, my lords, on page number 2 of that charge sheet. It's also the same extract of that FIR, again, which points out to the fact that it's a copy paste, which says that ಅಜಾಗರೂಕತೆಯಿಂದ ನಡೆಸಿದ್ದಾರೆ rash and negligently, my lords. Lord, now if I may point out the claim petition first para itself, my lord.
Yes.
My lord, at the relevant time, the said Mr. Ravisha drove the same with high speed in a rash and negligent manner without following the traffic rules in endangerous manner to public and property, and lost his control over the same. As such, the said car toppled on the road and caused the accident. My lord, which claimants would say in their own claim petition that it is, I am the tortfeasor, my lord? Lord, here one fact which is missing is, my lord, the wife.
When you were pleading itself was that you were driving in a rash and negligent manner.
My lord, the plea before the trial court, it has not been at all conducted properly, my lord, is what I have to admit, my lord.
How can you say now that the accident occurred because of tire burst and not because of negligence? You are pleading. Pleadings are the admissions. They carry more value.
I understand, my lord. But if such is the case, my lord, the statement of the wife has to be taken into consideration in pari with the claim petition, my lord. If she has to sign the claim petition, and that has to be considered.
The claim petition.
Sorry, my lord.
She is the signatory to the claim petition.
She is signatory to the claim petition. Nagaratna ji. My lord, if this and her statement in a deposition has to vary, then something is missing is what has to be taken into consideration.
This is very childish. It's not before the, it is not an.
Can you say something which is not there in the pleading in the evidence?
My lord, in the evidence, she has stated it very clearly that it is due to tire burst.
Even before the Tahsildar, these kinds of arguments and these kinds of pleadings are not permitted.
My lord, even in the IMV report also, if considered, my lord, IMV report itself admits the fact that it is due to tire burst, my lord. Maybe it was not bought due to the advocates.
Case conduct ಮಾಡ್ತಾ ಇದ್ದೀರಿ? Since how many years you are practicing?
My lord, I'm practicing since 3 years.
3
years.
3 years.
Yes.
How many motor accident cases you have conducted?
Lord, I've conducted like 4 to 5 cases at least.
4 to 5 cases. What is the basic jurisprudence regarding admissions And
I understand where my lord is pointing out directly where the claim petition itself admits.
ಅದನ್ನ ನೇರವಾಗಿ ಹೇಳ್ಬೇಕು ಈ ತರ ಅಲ್ಲ ಅಲ್ಲ. Yes,
Well, my lord, if that is the case, I may request to defer this. My senior, Mr. Bamshi Krishna, will come and address to that effect, my lord. My humble request, my lord, the lady, the wife of the deceased.
he has all sympathies, but we must be able to get her something in the law. That's why we asked whether once 163 he comes, whether he gets covered under section 163. Huh?
My lord, when one fact has to be considered.
Says that there is.
My lord, why do I point out that there is something missing is, my lords, why do I point out there is something missing is the judgment itself says that there's no IMV report. My lord, while the copy of the court is given and there is an IMV report.
That is taken, IMV report itself says that it was not due to mechanical defect.
My lord, the statement of the person, if they, my lord, but the statement of the examiner has to be taken.
Where judgment says that there is no IMV.
Yes, my lord, I will point out. My lords, para number 10, page number 6 of the judgment.
Yes.
My lord, I would like to read last 6 lines, my lord. There is no pleading in the petition.
10, no?
Para 10, my lord, page number 6. It starts from 5. There is no pleading in the petition that due to tire burst, the accident occurred. Moreover, the petitioners have not produced any IMV report to evidence their contention. My lord, the compilation given by the trial court itself has IMV report, my lord. This is where I point out something is missing, my lords.
Yeah, even if that IMV report is taken into consideration.
Yes, my lords.
You didn't get that marked IMV report, then the trial court was justified. That IMV report was not marked.
IMV report was, my lords, IMV report was, but despite it was right in front of the trial court.
Unless you get a document admitted in evidence, how the courts can look into that?
I completely agree to
Then why are you saying that the trial court was in error in saying that IMV report is not placed before that?
I can see, I understand the point.
Yes.
My lords, the trial that has been conducted somewhere requires a retrial wherein, my lord, at least a retrial wherein, my lord, the Shobha Rani and the inmate, the father.
Don't argue further, because if you, why these kinds of submissions are being made before us?
My lords, there is some scope wherein we could see through or between the lines is what is my submission, my lord.
Basic principles. If your senior has to come, he has to come. Otherwise, yes, it's very funny. Our pleading our accident, our
even evidence illa, pleadings illa.
Our pleading our
My lord, law is, my lord, the evidence is also clear and law is also very clear.
conduct
matter.
Unfortunately, official courts and motor accident cases. At least 163 ಕೆಳಗಾದ್ರೆ ತಗೊಂಡು ಬಂದು ಮಾಡೋದಿದ್ರೆ ಮಾಡಬಹುದಿತ್ತು, ಅದನ್ನು ಮಾಡಿಲ್ಲ. ಈಗ how can they
ಇವಾಗ my lord, your lordship may kindly appreciate the accident is of 2014. 10 ವರ್ಷ ಆಗ್ಬಿಟ್ಟಿದೆ. ಇವಾಗ they are not in a position to even repair also. Pleadings ಇದನ್ನ ಏನು ಚೇಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. And even my lord, your lordship may kindly appreciate IA file ಮಾಡಿದ್ದಾರೆ to amend the claim petition, saying that tire burst anta, but that was also rejected.
IA was rejected.
ಅದರ ಬಗ್ಗೆನೂ
ಹೇಳಿದ್ದು ಆ ಪ್ಲೀಡಿಂಗ್ ಇತ್ತು ಆದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, ಅದು ಇಲ್ಲ, ಎಲ್ಲೂ ಇಲ್ಲ.
2000
even my lord, as your lord,
CCR ತೆಗೆಸ್ಕೊಂಡ್ರು.
your lordship also seen my lord
parties name ಇಲ್ಲ, KCCR ನಮ್ಮಲ್ಲಿ ಇರೋದಿಲ್ಲ.
software
ಇಲ್ಲ, KCCR ಅಲ್ಲಿ KLC ಇದೆ. ಪಾರ್ಟೀಸ್ ನೇಮ್ ಹಾಕಿದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಸಿಗುತ್ತೆ ಅದು.
ಇವಾಗ ಮಿನು ಬಿ ಮೆಹ್ತಾ ಕೇಸ್ ನೋಡಿದ್ರೆ my lord, ಮಿನು ಬಿ ಮೆಹ್ತಾಸ್ ಕೇಸ್
ಯಾವುದು ಸೈಟೇಷನ್?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ my lord. I will please my lord, your lordship may kindly excuse me my lord, I just mark that particular paragraph by me. Sorry my lord for that.
ಸೈಟೇಷನ್ ನಾವು ನಿಮ್ ಸೈಟೇಷನ್ ಯಾವ್ದನ್ನ ಕೊಟ್ರೆ ಇಲ್ಲಿ ತೆಗಿತಾರೆ, ಅನ್ಲೆಸ್ ಇಟ್
ಅಲ್ಲ ಅದು ನಾವು ಮೊದಲು ಇನ್ನೊಂದ್ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತು, ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ, ಈಗ ಅದರದೇ ಕಾಪಿ ತಗೊಂಡ್ವಿ.
ಇದು 2 ಸರಿ 3 ಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋ ಕೇಸ ಇದ್ರ ಜೊತೆಗೆ. We have all sympathies for the
ಪ್ಯಾರಾಗ್ರಾಫ್ 20
members of the bereaved family.
ಪ್ಯಾರಾಗ್ರಾಫ್ 20 my lord, I just time mark.
Then ಹೋಯ್ತಲ್ಲ.
Paragraph 20.
20. This should normally conclude the judgment, but we feel it desirable that we must deal with the question
May I
of
read,
law
my lord?
that has been dealt with at a considerable length by High Court as to whether it is incumbent on the claimant to prove negligence before who would become entitled to compensation. High Court of the
ಇಲ್ಲಿ ಲಾಸ್ಟ್ my lord, you lost me after. Last my lord, then my lord, after discussing all this, paragraph 27 your lords may kindly. Paragraph 27, page 453.
Yes.
May I read my lord?
Right.
The plea ignores the basic requirements of owner's liability and the claimant's right to receive compensation. The owner's liability arises out of his failure to discharge a duty passed on him by law. The right to receive compensation can only be against a person who is bound to compensate due to the failure to perform a legal obligation. If a person is not liable legally, he is under no duty to compensate anyone else. The claims tribunal is a tribunal constituted by the state government for expeditious disposal of the motor claims. The general law applicable is only common law and the law of torts. If under the law a person becomes legally liable, then the person suffering the injuries is entitled to be compensated and the tribunal is authorized to determine the amount of compensation which appears to be just. The plea that the claims tribunal is entitled to award compensation which appears to be just when it is satisfied on proof of injury to a third party arising out of the use of the vehicle on a public place without proof of negligence if accepted would lead to a strange results. Then my lord, further my lord, then my lord, section 110 of the act empowers state government to constitute one or more claims tribunal, accidents claim tribunal for such area as may be specified in for the purpose of adjudicating upon the claims for compensation in respect of the accident involving death and injury to person. The power is optional and state government, then I will skip that my lord. When a claim includes a claim for compensation, the claimant has an option to make his claim before the civil court. Regarding the claims for compensation, therefore, in certain cases, the civil courts also have a jurisdiction. If the contention put forward is accepted, so far as civil court is concerned, it would have to determine the liability of the owner on the basis of common law or torts, while the claims tribunal can award compensation without reference to common law or torts and without coming to the conclusion that the owner is liable. The concept of owner's liability without any negligence is opposed to the concept of owner's liability without any negligence is opposed to the basic principles of law. The mere fact that a third party received an injury arising out of the use of a vehicle in a public place cannot justify passing liability on the owner. It may be that a person bent upon committing a suicide may jump before a car in motion, and thus he gets himself killed. We cannot perceive by what reasoning the owner of the car could be made liable. The proof of negligence remains the linchpin to recover compensation. The various enactments have attempted to mitigate the possible. My lord, this is my lord, the proof of negligence is the linchpin. My lord, Supreme Court as long back as my lord 77 itself, my lord stated. My lord, paragraph further, my lord, paragraph 30 also, my lord, laces provides.
Mandatory.
Pardon, my lord. Negligence is a mandate.
Concept of owner's liability without any negligence is opposed to basic principles
Yes,
of
ma'am.
law ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದೇ ಹೇಳಿದ್ರೆ ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ ಪ್ಯಾರಾಗ್ರಾಫ್ 13 ನೋಡಿ.
Then no fault liability 163A ಒಂದೇ.
ಅಲ್ಲ 163 my lord, that is a special enactment.
Under the act that was
ತಾವು ಹೇಳ್ತಾ ಇರೋದು my lord, I think your lordship is in mind that section 140 of the Motor Vehicles Act, my lord, earlier act that is providing for 25,000 as on that date. I think it is in your lordship's mind, my lord. Not section 1.
liability ಅಂತ ಇತ್ತು.
ಅದೇ no fault liability ಅದೇ.
ಅಲ್ಲಿ
Section 140 your lords may kindly
not have proved negligence,
But still,
use of motor vehicle was sufficient.
he is entitled for no fault liability under section 140, my lord. I think your lordship.
Earlier 140.
Earlier 140.
ಈಗಿಂದು
ಈಗ ಬೇರೆ ಚೇಂಜ್ ಆಗಿದೆ. ಈಗ 140 ಸೆಕ್ಷನ್ ಇಲ್ಲ. ಈ 163 ಏನೂ ಇಲ್ಲ.
163A. ಇಲ್ಲ ಅದು ಇಲ್ಲ.
ಅದು ಇಲ್ಲ 163 ಏನೂ ಇಲ್ಲ.
ಅಲ್ಲ, but when this accident took place,
140 was there. 140 was there.
140 was there.
140 was there.
Earlier 140, that was.
That as on that date, my lord, what is is only to the extent it may be section 140 of the earlier act. Madam, matondu book idea.
140
Matan book
liability to
idea.
pay compensation in certain cases on the principle of no fault. Resulted from an accident arising out of use of motor vehicle or motor vehicles, the owner of the vehicle shall, or as the case may be, the owner of the vehicle shall jointly and severally liable to pay compensation in respect of such death or disablement in accordance with the provisions of this section. Ali 50,000.
Date ಅಲ್ಲಿ my lord 2014 ಅಲ್ಲಿ, if I am right, my lord, 25,000 was there. Just I will.
Alla, this
1994
ಇದು 94, ಇದು 2004 ದಲ್ಲಿ ಆಗಿದೆ
in
ಆಕ್ಸಿಡೆಂಟ್.
case of death,
ಅದು time and again it was amended.
50,000 ಇರ್ತದ. ಇದು 94 ನಲ್ಲಿ ರೆಡ್ಯೂಸ್ ಮಾಡಿದ್ರ ಅದನ್ನ.
94 ದಲ್ಲಿ ಹೆಚ್ಚಾಗಿದೆ. ಮೊದಲು 25,000 ಇತ್ತು, ಆಮೇಲೆ 50,000.
ಇದು 2000 chapter section.
If I am right, my lord, it was the 25,000, if I am right, subject to
Chapter
correct.
10 was omitted in 2019.
Yes. ಈ ಹೊಸ ಆಕ್ಟ್ ಅಲ್ಲಿ ಅದೇ ಅಮೌಂಟ್
1994 ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು?
94, ಇದು 2014 ಆಕ್ಸಿಡೆಂಟ್. If I am subject to correction, my lord, 25,000 was the under section 140. ಆಮೇಲೆ 94 ದಲ್ಲಿ ಅದು ಎನ್ಹಾನ್ಸ್ ಮಾಡಿದ್ರಿ.
The amount of compensation, ಇದು ನೀವು ಯಾವ ಆಕ್ಟ್ ಓದ್ತಾ ಇದ್ರಿ? 88. Amendment.
25,000 substituted with effect from
94 ದಲ್ಲಿ
50,000 ಅಲ್ಲಿವರೆಗೆ 25,000.
2019 ನಲ್ಲಿ ಬಂತಲ್ವಾ ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್?
ಇದು ಹೊಸದೇ 2019 ನಲ್ಲಿ ಬಂತು.
2019.
But it is effective.
So when the accident took place, 50,000 was the
50,000, 2000, my lord, it was 2014. Sorry, correct.
2014.
Correct.
50,000 was the no fault
Yes, ma'am,
liability
correct.
limit.
Correct. ಅಷ್ಟೇ ಬಿಟ್ಟು I think, my lord,
If you want to, yes. What
My lord, it's only to that effect, my lord. If given an opportunity, my lord, my senior would address on the points which I may have lagged somewhere.
interest pass also.
My lord, as far as the points are concerned, I tried to urge them, but then if, my lord, if I may be missing out somewhere, my lord, if passed over also, if we see through, if not to waste the time. Pass.
ಆಯ್ತು ಹೇಳಿ.
Yes, madam.
For 415, you should tell everything. Mr. Council, if your senior comes or not, 415, if you want to make.
We will.
Yes, my lord. So I before that only I'll make some.
We appreciate, we encourage the juniors also, but our time is also valuable. It is at the cost of other litigants you are doing it.
Number 45, Prakash Vaivy.
For appellant.
ಇದು ಅದ್ರಲ್ಲಿ ಹಾಕಿಟ್ಟಿರ್ತೀರಾ ಅವ್ರ್ದು?
Yes, sir, appellant.
Unless we have a Sharma tag, we will not be able to identify your name.
Sorry.
Yes. ಬೆಳಿಗ್ಗೆ ಪ್ರಕಾಶ್ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾರ್ ಪ್ರಕಾಶ್ ಅಂತ? Yes. Right, that's what he doesn't see. That he has changed his initial. Yes, ನಿಮ್ದೇನು? Claimants appeal.
Death case, my lord.
Is it on quantum or?
Quantum, my lord.
No, my lord, they are on quantum. Insurance have filed
Insurance have filed
challenging liability. Oh, Mahesh, my lord. Oh, Mahesh.
2 appeals.
2 appeals, 3 appeals.
ನೀವ್ಯಾರನ್ನ represent ಮಾಡೋದು?
I am representing the R1 and R2, driver and owner.
Driver and owner? ಎಲ್ಲೇ ಇದಾರ ಅವರು?
ಇದ್ದಾರೆ, ಓ ಮಹೇಶ್ ಇದ್ದಾರೆ.
ಆಯ್ತು ಹೇಳಿ. ನೆಕ್ಸ್ಟ್ ಇರೋದಿಲ್ಲ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್. wait ಮಾಡಿದ್ರೆ Yes. You are going to conduct this matter, no?
Please,
So we'll ask others to, others need not wait because if we take up these matters, 3:42. Just how much time you may need?
15 minutes.
5015?
1515.
15.
No, mine only for quantum, my lord.
Mahesh,
They have to say that.
Lord, my appeal, my lord, is on the question of
how much time you may require?
Lord, it will take another half an hour or 45 minutes because I have to take your lordship through the my lord.
You have to be to the point, not 45 minutes. Okay. Then we may not be able to take up other matters.
Without interruption, Your Lordship, may I submit? I am appearing online for item number 56. If the other matters are not taken up, a date may be given for item number 56, Your Lordship.
ಎಲ್ಲಾನು ಕರೆಸ್ಬಿಡಿ ಒಂದ್ಸರಿ. All right, we'll grant.
Cell number 46.
Next week ಅಂತ ಹೇಳೋದು.
30th ಅಂತ ಹಾಕ್ತೀವಿ.
30th
3010 ಅದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್.
ಇದೆ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್, ಅದಕ್ಕೇನು ಅಸೈನ್ ಡೇಸ್ ಇದಾವಲ್ಲ, ಡೇಟ್ ಕೊಡಕ್ ಬೇಡ. ಅವಾಗ ಅವರು ಯಾವ್ದು ಲಿಸ್ಟ್ ಇದೆ ನೋಡ್ಕೊಂಡು ಹಾಕೊಳ್ಳಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಲಿಸ್ಟ್ ಇಂದ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Cell number 47. O Mahesh.
47, my lord, I appear for the
ಟುಮಾರೋ ನಮ್ಗೆ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ತಗೋಬೇಕಾಯ್ತು. ಪಾಪ ಅವರು ಒಂದ್ ಕೇಸು ತಗೊಂಡಿಲ್ಲ ರೋಸ್ಟರ್ ಶುರು ಆದ್ಮೇಲೆ.
28.
As requested, list on 28:10. 28.
Cell number 49. SPP. Next week.
ಇದೇನು ಸರ್ಡ್ 100%. ಲೋಕೇಶ್ ಯಾರೋ ಇದ್ದಾರೆ SPP. ಬಟ್ urgent for due to paucity of time. Urgent due to paucity of time. ನಾವೀಗ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡುವಾಗ ಓಲ್ಡೆಸ್ಟ್ ಕೇಸ್ ಇಂದ ಲಿಸ್ಟ್ ಮಾಡಲಿ. ಡೇಟ್ ಕೊಟ್ರೆ ಆ ಆರ್ಡರ್ ತಪ್ಪುತ್ತೆ.
Cell number 50. ಹಳ್ಳಿ ಶಾಂತಪ್ಪ ಬಸಪ್ಪ.
I appear for the appellant in the connected.
ವೇಟ್ ಮಾಡ್ತಿದ್ರೆ ಮಾಡಿ ಅಷ್ಟೇ. ಅವ್ರದ್ದು ಮುಗಿದ ಮೇಲೆ ಸಿಗೋ ಹಾಗಿದ್ರೆ if you want to take a chance.
May I make one submission, madam? In this matter, the counsel on record is out of station. She will returning on 26th, my lord.
Who is counsel on record? Connected
Connected appeal.
But 50.1 ಅಲ್ಲಿ as requested by appellant's counsel, list on
2910.
ಇದು claimant's appeal ಏನಾ?
ಹೌದು, ಅದು dismiss ಆಗಿದೆ claim petition.
Date
2910.
29.
Cell number 51. ಪ್ರಕಾಶ ಹೆಚ್ಚಿ.
ಇದ್ರಲ್ಲಿ ಈ ಪ್ರಕಾಶ್ ಬೇರೆನಾ, ಆ ಪ್ರಕಾಶ್ ಬೇರೆ? ಯಾರು ಅದರ್ ಸೈಡ್? ಪ್ರದೀಪ್.
B Pradeep.
No representation for the appellant, urgent.
52. B Pradeep. ಸುರೇಶ್ ಯಮ್ಲಾತೂರ್.
ಅವರೇ ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್. ಸ್ಕೋಟಲ್ ಮೂಡ್ ಅಂತ ಇದೆ, ಅವರೇ ಮೂವ್ ಮಾಡಿರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ. ಡೇಟ್ ಹೇಳಿದ್ರಲ್ಲೊಂದು ಲಿಸ್ಟ್ ಆನ್
411.
411.
53. KT ಗುರುದೇವ್ ಪ್ರಸಾದ್. T Vijay Kumar.
53. ಲಿಸ್ಟ್ ಆನ್ ಇದರಲ್ಲೂ ಪೋರ್ಟಲ್ ಮೂಡ್ ಅಂತಿದೆ, ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಹಾಕಿ.
511.
511.
Cell number 54. Mohan KN. FS Sabali.
List on non-filing of translated copies of documents. Let
511.
511. ಅದ್ಯಾರೋ repress 56 ಅವ್ರು ಹೇಳಿದ್ದು.
56. B Pradeep.
You have muted your mic. You have muted your system. She is talking. ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
Your Lordship, I think there's some confusion. I'm appearing
56.
for
You are appearing in 56, no? Serial number 56.
serial number 56, writ petition 24378 of 2023. Your
Not
Lordship.
writ petition. This is MFA. You are appearing in some other court, it seems. Not this court.
I apologize.
Serial number 56 before us is MFA 417 of 2023.
Madam, that too you have to wear the gown and appear. It is a court hall only. You are appearing in the VC does not mean that you
You are from which
wear in the
state?
jacket.
Your Lordship, here we don't, I'm from Kerala. I'm
Okay.
enrolled in Kerala. We don't wear gown when we are appearing
It is
online.
mandatory.
Apologize.
It is
Apologize.
not,
I do.
it's not our court matter. 56 probably I have mistaken.
Maybe. Yes, Your Lordship. I'm sorry, sir.
56 ಪ್ರದೀಪ್ ರಿಲೀಸ್ ಆಫ್ ಅಮೌಂಟ್ ಅಂತ ಇದೆ, ಸ್ವಲ್ಪ ಡೇಟ್ ಕೊಡಿ ಯಾಕಂದ್ರೆ ಅವರು ಮತ್ತೆ ಮೂವ್ ಮಾಡ್ತಾರೆ.
1111.
ಲಿಸ್ಟ್ ಆನ್ 11.
Cell number 57, Puttaswamy C.
ಇದರಲ್ಲಿ ಡೇಟ್ ಕೇಳಿ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಯಾರೋ ಥರ್ಡ್ ಅನ್ರಿಪ್ರೆಸೆಂಟೆಡ್ ಇದೆ ಇಲ್ಲ 57 KSRTC ಅವರು ಯಾರು ಇರ್ಬೇಕು ನೋಡಿ ಅವರು ಇಲ್ಲಾಂದ್ರೆ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಮಾಡಿ ಅವ್ರು ಬಂದಾಗ ನೋಡೋಣ PCRs ಆರ್ ಆಲ್ಸೋ ರಿಸೀವ್ಡ್ ಯಾರಿಗಾರ ನೋಟಿಸ್ ತಗೊಳಕ್ ಹೇಳ್ಬೋದು ಒಂದ್ ವೇಳೆ ಅದಿದ್ರೆ ಪುಟ್ಟಸ್ವಾಮಿ ಅಂದ್ರೆ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಿರ್ತಾರ ಕ್ಲೇಮೆಂಟ್ಸ್ಗೆ ಕ್ಲೇಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಪುಟ್ಟಸ್ವಾಮಿ ಸಿ ಅಂತ ಇಲ್ವಾ ಅವರು ಮತ್ತೆ ಅವ್ರ ಹೆಸರೇ ತೋರಿಸ್ತಾ ಇದಾರೆ ಅವ್ರು KT ಮಧು ಅಂತ ಹೌದು ಒಬ್ಬರ ಹೆಸರಿದೆ ಅದ್ರಲ್ಲಿ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ KSRTC it is submitted that Shri Puttaswamy C advocate for the appellant unfortunately passed away. The records show that one KT Madhu was also appearing along with Puttaswamy. Therefore, registry shall show his name in the cause list henceforth for the appellant. Managing Director KSRTC are Dabali or
Dabali.
ಇನ್ನೊಬ್ರು ರವೀಶ್ ಇನ್ನೊಬ್ರು ರವೀಶ್ ಬನ್ನಿ ಇದಕ್ಕಲ್ಲ
SRTC.
ನಾಗರಾಜ್ ರೆಡ್ಡಿ
K. Nagaraj, B. Palakshaya, Shweta Anand.
K. Nagaraj Mayor Standing Counsel for Respondent is requested to accept notice for respondent. His name shall be shown in the cause list accordingly. He shall file the wakalat in the registry within 2 weeks. List after 2 weeks.
Cell number 58, Nagaraj Reddy.
Liberty ನೀವೇನಾ ಬರ್ಕೊಳ್ಳಿ ಶ್ರೀ ಬಿ ಪ್ರದೀಪ್ ಲರ್ನರ್ಸ್ 58 ಶ್ರೀ ಬಿ ಪ್ರದೀಪ್ ಲರ್ನರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 undertakes to appear for respond number 2. He shall file the wakalat in the registry within 2 weeks. His name shall be shown in the cause list accordingly. List after 2 weeks. Date ಬೇಕಾ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ 2 weeks
1911. Cell number 59, D. Vijay Kumar.
ಇದರಲ್ಲಿ ಯಾರು ಮೈನರ್ ಇರೋದ್ರಿಂದ ಯಾರು ಬಂದಿಲ್ಲ ಸೊ ದೇ ಹ್ಯಾವ್ ಟು ಸೀಕ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಗಾರ್ಡಿಯನ್ ಫಾರ್ ಮೈನರ್ R2 and 3 ಆರ್ ಮೈನರ್ ಅಂತ ಇದೆ 59 ಅಂತ ಬರ್ಕೊಳ್ಳಿ ರೆಕಾರ್ಡ್ ಶೋ ದಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 and 3 ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡಿಸಿ 2 and 3 are minors and their guardian respond number 1 has not turned up to protect their interest. 15 years 13 years mother is Obama anta
Obama 34.
Therefore appellant's counsel shall take steps for appointment of the court guardian to response 2 and 3 list after 2 weeks.
Cell number 45.
ಮತ್ತೆ ಎಷ್ಟೆಷ್ಟಿದೆ ಅದರಲ್ಲಿ 45 ನಲ್ಲಿ
There are 4 appeals, Lord. 2 by the insurance company.
4 ಒಂದು ನಿಮ್ದು ಅವ್ರದ್ದು 2 ಅವ್ರದ್ದು
ಎಲ್ಲಾನು ಕೊಡಿ ಒಂದ್ಸರಿ ನೋಡೋಣ ಯಾವ್ಯಾವ ವಕೀಲ್ ಯಾವ ಏನು there were 2 claim petitions.
Yes, below.
ಈಗ MEC 78 of 2013 ಮೇಲಿರೋ ಅಪೀಲ್ ಯಾವುದು
Lord, may I mention, my lord, in
MSc 78
FA,
ನೀವು
78 of 2013
I is the claimant in that.
I am the claimant.
ಅಲ್ಲ MFA ಎಷ್ಟದು ನಿಮ್ದು
833 of 18, my lords.
Lord, I make submission in my appeal that
833 of
Yeah.
2018.
833
regarding the facts also.
833 of 2018, my lords. Yes, ma'am.
2008
Claimants.
ಮತ್ತೆ ಅವ್ರದ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಯಾವ್ದು ಇದ್ರ ಮೇಲೇನೆ 78 ಮೇಲಿಂದು
2186.
2186 of 2017.
2186 of 2017 okay MEC number 27 of 2016 ಮೇಲೆ
8480/2017, that is claimant's appeal. 8480.
That is MEC 27 of 2000.
84 of
8480/17.
8480
8480.
ನಾವ್ ಹಿಡ್ಕೊಂಡಿರೋದು 8480
8480 ಅಲ್ಲ?
ಹೌದು, 8480.
2017
70.
ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಕ್ಲೈಮೆಂಟ್
claimants appeal.
ಕ್ಲೈಮೆಂಟ್ ಇನ್ನೊಂದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿದು
2185/17,
MFIT
2185.
5 of 2017
17.
Insurance company. Yes. So ಅಲ್ಲ ಒಟ್ಟೊಟ್ಟಿಗೆ ಇಡಬೇಕು 27 ಅಲ್ಲ MFA 8480 2185 they are one batch.
2186 of 2007.
All right, now you are going in your matters.
Please.
27.
Yes.
First argument.
MSc 27. Finding on negligence in all the cases will be same, no?
Same.
And may I suggest
The only dispute they are raising mainly. Driver was substituted, that is what they are claiming.
Right. Andre accident and other things are admitted. Involvement of the vehicle is also admitted. Only substitution of planting of a licensed driver.
Not only that, they are saying that
Correct?
negligence and my lord the
ಅವರೆಲ್ಲ ಬಂದ್ರೆ ಅಷ್ಟು ಸರಳವಾಗಿ ಎಲ್ಲಾನು ಒಪ್ಕೊಳ್ಳೋದಿಲ್ಲ. ಈಗ ಹೇಳಿ.
ಹೌದೌದು.
ಹೇಳಿ. ನೆಗ್ಲಿಜೆನ್ಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು? ಯಾವ್ದು 56? ಯಾರು ಆ ಲೇಡಿ ಒಬ್ರು ಯಾರೋ
ಕೇರಳದವ್ರು ಅಪಿಯರ್ ಆದ್ರಲ್ಲ ಅದು
11 ಅಂತ ಹಾಕಿದೀವಂತಲ್ಲ. ನೀವು ಕ್ಲೇಮೆಂಟ್ ಆಯ್ದ್ರಲ್ಲಿ ಕ್ಲೇಮೆಂಟ್ ಆಗ್ಬೋದ 2023 ಅಲ್ರಿ? ಇಲ್ಲ ನಾವು ರಿಲೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಯಾವ್ದು 11 ಹೇಳಿದೀವಲ್ಲ. ಈಗ ಎಷ್ಟೊಂದು ಹಾಲಿಡೇಸ್ ಬರ್ತಾ ಇದೆ, ಆಗೋದಿಲ್ಲ. ಮದುವೆ ಓಹೋ ಯಾವಾಗ ಬೇಕು ನಿಮ್ಗೆ? 14 ಅಲ್ಲವನ್ನ 14 is working day. ಅದಾದ್ಮೇಲಂತೆ 19 ನಾನು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಕೇಳ್ತಾ ಇದ್ದೀರ ನೋಡ್ಕೊಂಡು.
ಅಲ್ಲ ಯಾವ ಡೇಟ್ ಬೇಡ ಅನ್ನೋದೊಂದು
19th ಅಂತ ಹೇಳ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. 19th ನೀವೆಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ನಿಮ್ಮ ಮ್ಯಾರೇಜ್. ಹಾಕೊಳ್ಳಿ ಬೇಕಾದ್ರೆ ಯಾರು ಅವ್ರಿದ್ರ ಅದರ್ ಸೈಡ್ ಅವಾಗ
29.
ನಿಮ್ಮದು ರೀಚ್ ಆಗೋದು ಡೌಟ್ 2023 ಮ್ಯಾಟರ್. ಅದಕ್ಕೆ 19th ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ನೀವು. ಸರಿ ಆಯ್ತು, ಮುಗಿದು ಹೋಗಿದೆ ಈಗ. ನಮ್ ಲೆಟ್ ಅಸ್ ಡೂ ಅವರ್ ಜಾಬ್. ಎಸ್ ಇದರಲ್ಲಿ ವಾಟ್ ವರ್ ದ ವೆಹಿಕಲ್ಸ್ ಇನ್ವಾಲ್ವ್?
It's a jeep
involved,
jeep and one motorcycle.
one motorcycle and a scooty.
3 vehicles.
3 vehicles. New motorcycle.
The deceased was sitting on the scooty and was speaking in mobile phone. That is what my claim, Lord. And the jeep has drawn negligently and he hit the motorcycle and then hit the scooty which was parked on the left side of the road. And in the accident, she suffered injury to head and leg and back, and she was hospitalized for 12 days. And on 4/1/2013, she succumbed due to the injuries, my lord.
So charge sheet was filed against whom?
Against first respondent, my lord, driver of the jeep, driver of the jeep.
The driver of the jeep is examined by the respondents.
Yes, my lord. They have examined. He is
Examined.
appearing for them. They have examined.
Sure.
He has been examined as
Common
RW2, my lord.
RW2.
ಇದು ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಕನ್ಸಾಲಿಡೇಟ್ ಆಗಿದಾವ ಎರಡು ಕೇಸು? ಬಿಕಾಸ್
ಹೌದು. Petition ಹಾಕಿ
Consolidate ಯಾವಾಗ ಆಯ್ತು ನಾನು ಹೇಳ್ತೀನಿ.
ವಿಟ್ನೆಸ್
Milord, it was liability was fixed on the owner. We've come in an appeal and the insurance have also come in an appeal. The matter was remanded and directed to be clubbed and tried together in Virajpet. Earlier it was filed in Mysore.
ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಸಪರೇಟ್ ಸೆಟ್ ಇದೆ ಎರಡರಲ್ಲೂ.
ಇಲ್ಲ, ಆಮೇಲಿಂದ ಕಾಮನ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದಾರೆ.
No common.
ಇಲ್ಲ ಸಪರೇಟ್ ಎವಿಡೆನ್ಸ್.
ಸಪರೇಟ್ ಎವಿಡೆನ್ಸ್.
ಅಲ್ಲ, PW1 in both the cases.
ಹೌದೌದು, ಬೇರೆ ಇದ್ದಾರೆ. ಸಪರೇಟ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
Even exhibits are different.
ಹೌದು.
ಎರಡರಲ್ಲೂ. So charge sheet is exhibit.
ಇಲ್ಲದ್ರೆ ಏನಾಗಿ ಮೊದಲೊಮ್ಮೆ ಅವಾರ್ಡ್ ಆಗಿತ್ತು, again they came.
ನಿಮ್ದು 27 ಅಲ್ವಾ?
ಹೌದೌದು.
27 ಅಲ್ಲಿ charge sheet is marked at exhibit P9. ರೆಕಾರ್ಡ್ಸ್ ಇದ್ರ ಕೊಡಿ.
ಎರಡಕ್ಕೂ ಒಂದೇ ರೆಕಾರ್ಡ್.
ಅಲ್ಲ, ಆಮೇಲೆ ಒಂದ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹೌದು, ಅರ್ಲಿಯರ್ ನಂಬರ್ ವಾಸ್ MEC 203/13 ಮಿಲಾಡ್.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅಂತ ಅಲ್ಲಿದೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ದಟ್ ಇನ್ MFA 4313/2015 there was an order and remanded the earlier award has been passed, that was set aside and matter was remanded.
Now we have to decide afresh.
Please Milord, please.
What was complaint to charge sheet ಎಲ್ಲ it was against. ನಮಗೊಂದು ಪ್ರಾಬ್ಲಮ್ ಇರುತ್ತೆ ಇಲ್ಲಿ, ತುಂಬಾ ಬಲ್ಕಿ ರೆಕಾರ್ಡ್ಸ್ ಇರುತ್ತೆ ಹ್ಯಾಂಡಲ್ ಮಾಡೋದಕ್ಕೂ.
Complaint is P2 Milord.
78 MEC 27.
27 ಅಲ್ಲಿ.
ಅಲ್ಲ, ಇವ್ರದಿರೋದು MEC 78 ಅಲ್ಲ.
27
ಕೇಸ್.
27 Milord.
MEC 27 ರಿಕಾರ್ಡ್. ಬಹುಶಃ ಅವ್ರು ಏನ್ ಮಾಡಿರ್ತಾರೆ, ಎರಡದ್ರದ್ದು ಎಕ್ಸಿಬಿಟ್ P ಸೀರೀಸ್ ಒಂದ್ ಕಡೆ ಹೊಂದಿರ್ತಾರೆ, ಹಾಗೆ ಮಾಡಿರ್ತಾರೆ ಅನ್ಸುತ್ತೆ.
ಎರಡರಲ್ಲೂ ಕಂಪ್ಲೇಂಟ್ P2A.
ಇದರಲ್ಲಿ
P2 ಎರಡು P2.
78 ಅಲ್ಲಿ ಇಟ್ ಇಸ್ ಮಾರ್ಕ್ಡ್ ಅಟ್ ಎಕ್ಸಿಬಿಟ್
P2 ಕಂಪ್ಲೇಂಟ್.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಚಾರ್ಜ್ ಶೀಟ್
ಮಾರ್ಕ್ ಮಾಡೋದು
P8.
ನೋಡಿ.
In that, in my case, it was P9 Milord.
P8. In your case it is P8.
P9. In my case P9. In their case P8.
ಯಾವ್ದು ಮೊದಲು ಕೈಗೆ ಸಿಕ್ತಾವ್ರಿ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ P8 ಸೇಮ್ ಅದು, ಎರಡಕ್ಕೂ ಸೇಮ್ ಇದೆ.
ಎರಡು ಸೇಮ್.
ಸೇಮ್.
ಈಗ 12/2012 5:30 ಗಂಟೆಗೆ ಮಡಿಕೇರಿ ರಸ್ತೆ ಸಿದ್ದಿಕ್ ವರ್ಕ್ಶಾಪ್ನ ಮುಂದಿನ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯಲ್ಲಿ ಕಲಂ ನಂಬರ್ 1 ಸಾಕ್ಷಿ ಮುಂದೆ ಕೂರಿಸಿಕೊಂಡು ಮೋಟಾರ್ ಸೈಕಲ್ ನಂಬರ್ 7 ಹೋಗುತ್ತಿರುವಾಗ ಎದುರು ಮುಂದೆ ಆರೋಪಿ 5ನೇ ಸಾಕ್ಷಿಯನ್ನು ಜೀಪ್ ನಂಬರ್ 7 ಕೂರಿಸಿಕೊಂಡು ಅತಿ ವೇಗ ಹಾಗೂ ಅಜಾಗರೂಕತೆ ಓಡಿಸಿಕೊಂಡು ಬಂದು 1ನೇ ಸಾಕ್ಷಿ ಓಡಿಸಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಪಡಿಸಿ 1ನೇ ಸಾಕ್ಷಿದಾರ
ಅಪರಾಧಿ ಸಂಖ್ಯೆ 1 ಛೇದಂಡ ಗಗನ್ ಮಚ್ಚ
ಸಾಮಾನ್ಯ ಹಾಗೂ ತೀವ್ರ ಜೀಪ್ ಮುಂದೆ ಚಲಿಸಿ ರಸ್ತೆ ಬದಿಯಲ್ಲಿ ಸ್ಕೂಟಿ ನಂಬರ್ 7 ನಿಲ್ಲಿಸಿಕೊಂಡಿದ್ದ ಆಶಾರವರಿಗೆ ಡಿಕ್ಕಿ ಪಡಿಸಿ ತೀವ್ರ ಸ್ವರೂಪ ಗಾಯಪಡಿಸಿ ಮುಂದೆ ಚಲಿಸಿ ಮುಗಿಸಿಕೊಂಡ ಪರಿಣಾಮ CW 45 ಸಾಕ್ಷಿದಾರರಿಗೆ ಸಾಮಾನ್ಯ ಸ್ವರೂಪ ಗಾಯಗಳಾಗಿರುವುದರಿಂದ ಶ್ರೀಮತಿ ಆಶಾ ಚಿಕಿತ್ಸೆಗೆ ದಾಖಲಾಗಿ ಫಲಕಾರಿಯಾಗದೆ 4/1/2000 ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. So accident was on 22/12 and she died on 4/1/2013.
4/1/2013.
Petition is by her LRC. So charge sheet was against him, saying that he dashed against 2 vehicles.
Yes, Milord. First hit the motorcycle, then scooty which was parked on the left side of the road.
Was their defense?
Their defense was she was driving on the scooty while talking on the phone.
On the phone.
Yes, that is their contention.
How another vehicle was hit?
Standing on the roadside and talking to mobile.
Asha was riding while speaking on the phone, but it has hit another vehicle also.
What they claim?
Because
Their claim is that motorcycle has hit the jeep and then to the two-wheeler. That is their claim.
Yes. Yes.
Yes, ma'am. The charge sheet and evidence on record clearly establishes that even evidence on record in this case also clearly shows that there is a negligence on the part of the driver of the jeep.
All right, then quantum. Now you have no issue on quantum, but they may counter it.
No. Yeah, yes, my lord. I filed an appeal only for quantum only.
MEC number 27, no?
27.
7.
That was discussed in page number.
Page number, judgment page number.
that page number. Ink page 40 onwards, my lord.
Page
40, in my appeal, ink page 40 onwards.
2185
That-
8480 alva?
42 ನಲ್ಲಿ ಟೇಬಲ್ ಇದೆ.
Please, my lord,
Ink page number 40.
40. Other page 36.
External page ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕಾಗುತ್ತೆ.
ಇಲ್ಲ 36 ಅದು ಪೇಜ್ ನಂಬರ್ 36 ಅಂತ ಇದೆ ಅಲ್ಲಿ ಅವಾರ್ಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ. That para 42 onwards. Para number 42 onwards.
Yes.
May I read, my lord?
ಇಂಕ್ಲೂಡ್ ಬೇರೆ ಮಾಡ್ಬೇಕು, ಇದು ಬೇರೆ ಮಾಡ್ಬೇಕು. ಅವರೇ ಒಂದು ಬೇರೆ ಬೇರೆ ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಕೊಟ್ರೆ ಒಳ್ಳೇದಿರುತ್ತೆ.
44 ಅಲ್ಲಿ.
ನೀವು ಇಂಜುರಿ ಕೇಸ್ ನಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿರೋದು?
ಹೌದು.
ನೀವು ಒಂದು ಸಪರೇಟ್ ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಕೊಟ್ರೆ ಒಳ್ಳೇದು ನಮ್ಗೆ. ಒಂದು ಕಾಮನ್ ರಿಗಾರ್ಡಿಂಗ್ ದಿಸ್ ರ್ಯಾಶ್ನೆಸ್ ಅಂಡ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಒಂದಾದ್ರೆ ಸಾಕಾಗುತ್ತೆ. ಬಟ್ ಬಿಕಾಸ್ ಹಿಸ್ ಕೇಸ್ ಇಸ್ ಇಂಜುರಿ ಕೇಸ್, ಅದ್ರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನೇನಿದೆ ಅದೆಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳೋದು ನೋಡಿ ಎಷ್ಟು ಕಷ್ಟ ಇದೆ ಅಂತ. What were the documents produced to prove the disability? You are on the point of disability.
Disability is 30%, my lords.
That is taken as spoken by doctor.
Yes, ma'am.
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಇಶ್ಯೂ ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು 30%.
Doctor has spoken 30%.
Yes, my lords.
And that much
PW2 has been spoken.
exhibit ಎಷ್ಟದು?
This P11, my lords.
P11.
ಹೌದು ಸ್ವಾಮಿ. 78 of 30.
Copy of disability certificate.
Yes, ma'am.
Salary certificate, discharge bill. Discharge bill. Discharge summary is exhibit P21.
Yes.
At least ಇಂಥದ್ದರ ನೀವು ಒಂದು ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಕೊಟ್ರೆ ನಮ್ಗೆ ಅನುಕೂಲ ಆಗುತ್ತೆ.
Please, my lords.
ಎಷ್ಟು ಕಷ್ಟ ಇದೆ ನೋಡಿ.
At least separate ಒಂದು flag right ಕೊಟ್ರೆ ಇದೆ.
ಫ್ಲಾಗ್ ಹಾಕೋದು ಬೇಡ, ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಕಷ್ಟ ಇದೆ. ಯು ಮೇಕ್ ಎ ಕಂಪೈಲೇಷನ್ ಆಫ್ ಯುವರ್ ಎಕ್ಸಿಬಿಟ್ಸ್. ಬೇಕಂದ್ರೆ ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ ಬಿಟ್ಬಿಡಿ, ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ ಒಬ್ಬರೇ ಕೊಡಿ ಯಾವ್ದಾದ್ರು ಒಂದು. ಮಿಸ್ಟರ್ ಶರ್ಮಾ, ನೀವು ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅದ್ರದ್ದೆಲ್ಲ ಸ್ಪಾಟ್ ಸ್ಕೆಚ್ ಅದರದೆಲ್ಲ ಒಂದು ಕಂಪೈಲೇಷನ್ ನೀವು ಕೊಡಿ. ಡ್ರೈವರ್ ಎವಿಡೆನ್ಸ್ ಅಂಡ್ ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ, ನೀವೇನು ಪ್ರೂಫ್ ಆಫ್ ಇನ್ಕಮ್ ಡಿಸಬಿಲಿಟಿ ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ಇದಾವೆ, ಆಮೇಲೆ ಡಾಕ್ಟರ್ಸ್ ಎವಿಡೆನ್ಸ್ ಅದನ್ನ ಒಂದು ಕಂಪೈಲೇಷನ್ ಮಾಡಿ ನೀವು ಕೊಡಿ. ಅಂದ್ರೆ ನಮ್ಗೆ ಈಸಿ ಆಗುತ್ತೆ. ಇಲ್ಲ ನೋಡಿ ಎರಡೂ ಕೂಡ ಸ್ಟಿಚ್ ಮಾಡಿದ್ದಾರೆ. How will look into those documents?
Please, my lords.
May I just pass on, my lord, for ready reference.
You have it?
Exhibit P11, disability certificate, what this pertains to him.
ಅದು ಒಂದೇ ಅಲ್ಲ ರೀ,
ಎಲ್ಲ ಗೊತ್ತಾಯ್ತು.
ಬೇಕಲ್ಲ.
ಇದು ಒಂದಿದೆ, ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೇಳಿದ್ರೆ ಅದಕ್ಕೋಸ್ಕರ.
ನೀವು ಒಂದು ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಕೊಟ್ಟಾಗ ನಮ್ಗೆ ರೆಫರೆನ್ಸ್ ಈಸಿ ಆಗುತ್ತೆ.
Please, my lord.
ಇಲ್ಲ ಅಂದ್ರೆ it becomes
ಮಾಡಿಕೊಡ್ತೀನಿ.
job for us.
I'll make a copy and I'll give it.
At least records ಅಲ್ಲಿ ಒಂದು flag ಕೊಟ್ರೆ ಆಯ್ತು.
ಅಲ್ಲ ಮಾಡಿಕೊಡ್ತೀನಿ ನಮ್ಮ.
ಟ್ಯಾಗ್ ಹಾಕಿದ್ರೂ ಕಷ್ಟ ಇದೆ ಅದು ತಿರುಗಿಸೋದೇ.
ಹೌದೌದಲ್ಲ ಅದು ಕಷ್ಟ. ಹೌದೌದು, ಅದು ತೂತು ಮಾಡಿ ಮತ್ತೆ ಸ್ಟಿಚ್ ಮಾಡಿರ್ತಾರೆ, ಅದು ಫುಲ್ ಓಪನ್ ಆಗಲ್ಲ.
ಕ್ಲೇಮೆಂಟ್ಸ್ ನೀವೇ ಮಾಡ್ಕೊಟ್ಬಿಡಿ, ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್ ಇರುತ್ತೆ.
ಹೌದು, ಎಲ್ಲ ಮಾಡಿಕೊಡ್ತೀನಿ.
The claimants in both these cases shall submit the copies of ಅಷ್ಟೇ. ನಾವು ಎಕ್ಸಿಬಿಟ್ಸ್ ಅಂದ್ರೂ ನೀವು ಒಂದು ಅದೆಲ್ಲ ನೆಗ್ಲಿಜೆನ್ಸ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಬರೋವಂಥದ್ದು ಒಂದು, ಯಾಕಂದ್ರೆ ಅದು ಒಂದ್ ಸೆಟ್ ಇಬ್ಬರಲ್ಲಿ ಒಬ್ರು ಕೊಟ್ಟರು ಸಾಕಾಗುತ್ತೆ. ಯು ಡೂ ದಟ್ ಅಂಡ್ ಇನ್ ಯುವರ್ ಮ್ಯಾಟರ್ ಪ್ರಾಬಬ್ಲಿ ನೋಷನಲ್ ಇನ್ಕಮ್. ನೋಷನಲ್ ಇನ್ಕಮ್ ಇರೋದ್ರಿಂದ ನೀವು ಕ್ವಾಂಟಮ್ ಮೇಲೆ ಏನು ಕೊಡೋದು ಬೇಕಾಗೋದಿಲ್ಲ.
ಅಲ್ಲಿ ಏನಾದ್ರೆ she was working and I produced exhibit P21 to 25.
ಏನದು?
She was working as estate agent and also pygmy collector.
ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಿರಿ ಅದಕ್ಕೆ?
ಅಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, ಬಟ್ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೆ ನೋಷನಲ್ ತಗೋಬೇಕಾಗುತ್ತೆ. ಅದಕ್ಕೆ ನಿಮ್ಮದ್ರಲ್ಲಿ ಕ್ವಾಂಟಮ್ ಮೇಲೆ ಬೇಡ.
9,000 ತಗೊಂಡಿದ್ದಾರೆ ಈಗ.
ಈಗ ಅದು ಯಾವ ಇಯರ್ ಅಲ್ಲಿ ಆಗಿರೋದು ಆಕ್ಸಿಡೆಂಟ್?
2013 ಸಾರಿ 12 ಡಿಸೆಂಬರ್
2012 ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು ಇದು ನಮ್ದು ಇದು ಚಾರ್ಟ್ ಪ್ರಕಾರ? 2012 7,000 8,000 2012 7,000 ಇದೆ. ಟ್ರಿಬ್ಯುನಲ್ has taken
9,000.
ನೋಡೋಣ ಸರಿ. Seek time to produce The compilation containing the copies of the exhibits and depositions. List on.
Monday.
ಆಯ್ತು ಕೊಡ್ತೀವಿ ಅಷ್ಟು. Next Monday ಅಲ್ಲ? ಆಯ್ತು Monday.
28/10.
29/18. Tuesday. Well, it's next Tuesday.
Tuesday. ಅವ್ರು ಯಾರೋ ಕರ್ಕೊಂಡ್ ಬರಕ್ ನಂಬರ್ ನೋಡೋದಿದೆಯಲ್ಲ ನಾವು ಅದಕ್ಕೆ.
Tuesday, 14% final disclosure ಅಲ್ಲ.
ಟ್ಯೂಸ್ಡೇ ಯಾವ್ದೋ 2013 ಏನೋ ಹಳೇದಿದೆ ಅಲ್ಲ, ಅದು 2006 ಮ್ಯಾಟ್ರಸ್ ಅವು. ಮಂಡೇ ಬಿಟ್ರೆ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಮತ್ತೊಂದ್ ದಿವಸ ಯಾವಾಗ? ಟ್ಯೂಸ್ಡೇ ಆಗಲ್ಲ.
Monday.
ಅದ್ರ ಮುಂದಿನ ವಾರ.
Senior ಇರಲ್ಲ ಅಂತ.
Huh?
Senior will not be there ಅಂತ.
Who is your senior?
Harish Ganapati.
Huh?
Harish Ganapati.
ಹರೀಶ್. ಮುಂದಿನ ಅದಕ್ಕಿಂತ ಮುಂದೆ ಹಾಕ್ರಿ ಎಷ್ಟಿದೆ?
4/11.
4/11. ನಾವು ಬರೆಯೋದಂತೂ ಸ್ವಲ್ಪ ಬರ್ದಿವಿ ನಾವು ಅದ್ರಲ್ಲಿ.
Past story.
ಲಾಸ್ಟ್ ಅವರ್ ಅದನ್ನ ತಗೊಳ್ಳಿ, ಅದೊಂದು ಇನ್ನು ಉಳಿದಿದ್ದು ಅದೊಂದು ಅಲ್ಲ.
First of all. Still number 44.
Department of Parliament.
Lords, I tried to reach out.
Please, my lord.
Yeah, my lord. Vamshi Krishna. My lord, he is held up in Devanhalli court and due to the rains is unable, not in a position even through join through VCSM. Lords. My lord, may I pray? Genuine request, my lord, my attempt to address the matter shouldn't be a cause to penalize me. My lord, my humble request.
Heard the appearance. Further arguments is 6 time. List tomorrow.
Lords, may I pray Monday, my lord?
You have
Obliged,
sufficiently
obliged, my
times.
obliged.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೊಂದು ಜಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ, ಅವ್ರು ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಕೊಟ್ಟಿದ್ರ.
Finally, I have what?
ಆಯ್ತು.
ತಗೊಳಪ್ಪ, ಇದು 84.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 59 ಏನಾಯ್ತು?
59 ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 53.
511.
511 ಒಂದು ನಿಮಿಷ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಸೀರಿಯಲ್ ನಂಬರು 16. ಸೀರಿಯಲ್ ನಂಬರ್ 16.
16 2 weeks for steps for R4. Failing which appeal against R4 stand dismissed. ಇದು non filing of acknowledgement not complied. Respondents are at liberty to